scholarship, clarity of reasoning, and deep constitutional commitment represent the finest traditions of judicial leadership. Many of us had the privilege of hearing her just last month when she spoke at the ICA conference in the prelude to International Women's Day on the topic, "Where Women Lead, Justice Follows." Her thoughts gave a much-needed encouragement to the idea of better women representation, not only in the legal area, but all walks of life. Before we invite Justice Nagaratna to deliver a keynote address, may I request Mr. N.G. Khitan, President of ICA and Senior Partner Khitan & Company, to felicitate Justice Nagaratna with a green certificate, a pledge by the ICA to plant a thicket of 8 trees at the facility in Ayodhya, Uttar Pradesh, with this gesture symbolizing growth and subsidiarity. May I now warmly request Ms. Justice Mivi Nagaratna to deliver a keynote address.
Namaskar and a very good morning to each one of you. Esteemed panelists on the dais, Sri Arun Chawla, Director General, Indian Council of Arbitration, learned arbitrators and mediators who are present here, learned senior advocates and advocates, distinguished invitees, ladies and gentlemen. Once again, I have accepted Mr. Chawla's invitation, as last month I was there at the Federation House, and I'm happy to participate in this important and relevant session of the conference. I must commend the Indian Council of Arbitration for bringing together leading jurists, policymakers, and industry experts to explore the evolving landscape of mediation and arbitration. In the increasingly sophisticated and globalized economy of today, there has been a discernible shift away from the traditional mode of dispute resolution towards what we call ADR, or alternative disputes resolution mechanisms. ADR mechanisms such as mediation and arbitration offer flexibility, efficiency, confidentiality, and party-centric solutions. This shift also reflects a deeper churn within legal thinking about the nature of conflict resolution, the manner and the method. It recognizes that disputes are not only legal questions, but also social, commercial, and relational questions that may require more voluntary solutions than a court adjudication. Arbitration and mediation, therefore, are not merely alternatives to litigation, but integral components of a modern and responsive justice system. As we all know, arbitration has become a most preferred method of resolving cross-border commercial disputes. Its advantages, namely neutral forums, procedural flexibility, confidentiality, party autonomy, and the enforceability of awards under international conventions, have made it indispensable in global commerce. For practitioners, arbitration demands not only legal expertise, but also an understanding of international business practices and economics. Arbitration today operates in a very sophisticated institutional ecosystem. And international commercial arbitration has assumed particular significance in this interconnected global economy. The effectiveness of international arbitration is strengthened by the New York Convention, which enables arbitral awards to be recognized and enforced across over 170 jurisdictions. Another important dimension on the topic is international arbitration is closely connected in the field of investment arbitration under bilateral investment treaties or BITs. These treaties provide foreign investors with protection such as fair and equitable treatment, protection against unlawful expropriation, and access to neutral dispute resolution mechanisms against host states. Investment arbitration has therefore become an important feature of the global economic order. An added layer of complexity arises when one looks at how disputes arise across different sectors of the economy. In infrastructure and construction projects, where disputes over delays and cost escalations are common, arbitration tends to be the preferred mechanism. In sectors such as technology, telecommunications, and cross-border commerce, international arbitration provides neutrality and enforceability across jurisdictions. Many of these diverse sectors also rely on arbitrators with specialized industry expertise and not just legal expertise. For instance, in construction, energy, maritime, and technology disputes, where an understanding of technical and commercial practices can be as important as legal analysis. Developing greater sector-specific arbitration expertise in India will therefore be a sine qua non if we wish to strengthen India's position as a credible arbitration jurisdiction. I have highlighted a few aspects of the arbitral ecosystem. Moving on, I go to mediation, which is, on the other hand, a different philosophy of dispute resolution altogether. Rather than imposing a binding decision, mediation facilitates dialogue between parties, enabling them to arrive at mutually acceptable outcomes. In many disputes, particularly those involving long-term commercial relationships, family matters, or community conflicts, mediation preserves relationships and promotes durable settlements. The strength of mediation lies in its ability to focus on interests rather than positions. The increasing institutionalization of mediation in legal systems across the world reflects a recognition that consensus-based solutions often provide deeper and more sustainable justice than adversarial outcomes. At the same time, mediation is increasingly proving effective in sectors where commercial relationships are ongoing, for instance, in joint ventures, shareholder disputes, supply chain relationships, and commercial partnerships. In such contexts, a negotiated or mediated settlement often preserves business relationship in ways that adversarial proceedings and even arbitration may not. Similarly, mediation holds considerable promise in intellectual property disputes. Parties can explore creative business-oriented solutions such as licensing arrangements, coexisting arrangements, or phased rebranding strategies that preserve the commercial value. In India, the enactment of the Mediation Act 2023 represents an important legislative step in that direction, seeking to institutionalize mediation and strengthen its role in commercial dispute resolution. But I must confess that it really needs to take off as such. While we have the structure in the form of a legislation, there is no real active, implementation of the said act, as many provisions are not yet notified. The Mediation Council of India is not yet constituted, and therefore we have to rely upon diversified centers of mediation in the various states and union territories. With regard to the various forms of alternative disputes resolution, I may briefly touch upon MEDLIT, where we have the Section 12 capital A of the Commercial Courts Act being inserted, where mediation is a mandatory requirement even before the commencement of a commercial suit or a proceeding. It is a time-bound process. It has to be done unless there is an immediate interim order which has been sought. Now, coming to interim orders, we know as lawyers and legal practitioners how interim orders are prayed for, and in order to see that the mediation process as a first step is overcome, the manner in which the interim orders are sought. But now they say that even if the mediation process has been bypassed, the court can refer the matter back to a mediator so that Section 12A is complied with. In this regard, what it states is in India that the state legal services authorities are responsible for the mediation or pre-litigation mediation under Section 12A. Critically speaking, how far the state and the district legal services authorities have shaped up in this regard is a question to be asked by all of us. And what are the steps which are required to be taken? My only submission to this House is that in the initial stage there has to be a synergy between the mediation centers where they are there in the various state headquarters and the legal services authorities which are there, and also between what we have the MCPC in the Supreme Court and the NALSA as such, so that there is a good coordination for the training of mediators in commercial matters, so that Section 12A is given its due importance and is implemented in letter and spirit, and not just as a formality. Just when the plaint is also ready to be filed, you go in for a Section 12A as a formality, and the very next hour after the mediation fails, you are waiting to go and file the plaint. That should not at all be the attitude of even the legal practitioners. In fact, there has to be sufficient importance given for pre-litigation mediation. Now, coming to mediation, arbitration, or MED-ARB as it is called, you know that it is a hybrid dispute resolution mechanism that sequentially combines the consensual process of mediation with the binding nature of arbitration. Typically, parties first attempt to resolve their dispute through mediation. If such efforts are successful, then it is only a drawing up of the settlement terms, and if necessary, the matter goes to an arbitrator who is already appointed, possibly, to draw up the settlement in the form of an award. The MED-ARB model is particularly valued in commercial contexts for its ability to balance flexibility with certainty, enabling parties to explore amicable settlement without forging the assurance of adjudication, without foregoing the assurance of adjudication. The effectiveness of MED-ARB depends on careful institutional design and procedural safeguards. They may include explicit and informed consent of the parties, an option to appoint a different person as a mediator, and if the mediation fails, the arbitrator can commence and conclude the arbitration. We have another model called the ARB-MED-ARB model, which represents an even more institutionally refined hybrid mechanism. Under this approach, the parties may first initiate arbitration, thereby securing jurisdiction and procedural certainty, after which the proceedings may be paused to allow for mediation. If the parties successfully reach a settlement, it may be recorded as an arbitral award under the Act. If mediation fails, arbitration resumes and culminates in a binding decision. This model effectively balances the advantages of consensual dispute resolution with the finality of adjudication. Notably, jurisdictions such as Singapore have institutionalized this process through protocols at the Singapore International Arbitration Center and Singapore International Mediation Center, where ARB-MED-ARB framework are applied, demonstrating its practical viability. Insofar as India is concerned, wherever we have arbitration institutions, that is institutional arbitration, whether which are attached to the high courts or the sui juris one like the ICA, it is necessary that they have trained mediators side by side, so that in an arbitration which has been commenced, even possibly after the issues are crystallized, at that stage the matter may be referred compulsorily to mediation. And if there is a settlement on certain issues, there could be a settlement agreement drawn on that process. And if there is no settlement on certain issues, only on that aspect the arbitration may continue, so that ultimately an award is passed. So this is in order to control and curtail the arbitration proceeding itself, which you know very well in reality sometimes are long drawn out, despite the timeline that has been given in the Act itself and the amendment made and the inevitable expansion of the timeline by the courts thereafter. In sum, while mediation, arbitration, and hybrid models such as MEDARB and ARB-MEDARB each offer distinct advantages, their effectiveness ultimately depends on how and at what point in the life of a dispute they are employed. Equally important is negotiation, the most fundamental and often the most underappreciated form of dispute resolution. Effective negotiation requires legal knowledge, strategic thinking, and an appreciation of the interests and motivations of the parties involved. In a sense, negotiation represents the first and most natural stage of dispute resolution, and its success often determines whether more formal processes such as arbitration or litigation become necessary. In fact, very often skilled negotiation resolves disputes long before they escalate into formal proceedings. Advocates who represent the two sides can themselves be negotiators in the presence of their parties, so that the matter does not go into arbitration at all or in the form of a suit or to any other proceeding. All of this is to say that no single dispute resolution mechanism can address every kind of conflict. A mature legal system must therefore support a diverse and complementary ADR mechanism and framework where arbitration, mediation, negotiation, and other mechanisms operate together to deliver efficient and context-sensitive solutions. But even as ADR has transformed the landscape of dispute resolution, the practical challenges are also worth acknowledging. Questions of enforceability of awards, delays, and rising costs in arbitration, the need for well-trained arbitrators, mistrust in the arbitrators and mediators, and continuing adversarial mindset of parties and sometimes their counsel all remind us that ADR must constantly evolve to remain effective and credible. Experience has shown that arbitration in practice sometimes becomes prolonged, particularly when the awards are challenged and a dispute returns to court system. This reality has led to an increasing emphasis on mediation and other consensual mechanisms which can complement arbitration by offering quicker collaborative solutions, especially in disputes where commercial relationships need to be preserved. What emerges is that not a single ideal method but a spectrum of approaches could be applied to a case, each suited to different contexts and stages of dispute resolution. The challenge lies in ensuring that these mechanisms are not reduced to mere formalities, but are structured and implemented in a manner that preserves their core objectives of efficiency, fairness, and finality. While in contracts and agreements, an arbitration clause is a must, I must say that the absence of a mediation clause in the contracts would not deter the parties from going in for mediation. After all, it is by consent, an alternative dispute resolution. Therefore, it need not be insisted that mediation must be written in the terms of the contract. Even when the arbitration is commenced at any stage, the parties could be sent for mediation. As India continues to refine its ADR framework, a nuanced and context-sensitive approach will be essential in realizing the full potential of these mechanisms and in fostering a more responsive and effective system of justice. I am confident that the deliberations and discussions of this conference will provide valuable insights and solutions, and a continued evolution of dispute resolution practices in India and abroad will emerge. I hope that the exchanges at this conference will generate ideas, collaborations, and practical solutions that will enrich the ADR ecosystem in India and beyond. I hope this conference will give us practical ideas. I thank the organizers of this conference for this kind invitation, and I extend my best wishes for the success of the Alternative Dispute Resolution Conference. I thank each one of you for your patient hearing, for I may have taken a few moments longer. Thank you and namaskar.
Ratna, for these absolutely immense contribution to the field of alternative dispute resolution. I actually will adopt the words of the Honorable Chief Justice of India yesterday to say the preferred mode of resolution. And of course, the most exciting part, I think, in today's session is the fact that we are seeking a collaborative effort. The ICA has been moving this forward. And before we go further on this aspect, I must point out to you, ladies and gentlemen, that Justice Nagaratna on the last occasion, which Mr. Chawla pointed out, on the issues of gender justice in the context of arbitration and mediation, she made a couple of suggestions, and I can't forget them. So one of the suggestions was that we should have, where there's a tribunal of 3 arbitrators, there should be 1 woman arbitration mandatorily. Of course, how much that goes forward is for Mr. Chawla, Mr. Khaitan, and some of us to go into. But indeed, delightful positions, because definitely there is a big encouragement in this field. Also to mention on a gender statement, Justice Nagaratna, you actually have mediation. Very many people think, and sometimes we should actually take advantage of this, that women are better mediators than possibly men. The only difficulty is commercial mediation. The only situation is, unfortunately, commercial mediation, where it is believed possibly that women are not as good. And I was at a session with the NCW the other day, and we were talking about women not being as good at finance, accounting, maths. Well, I am sorry, I kind of disagree with that principle, and it's high time that we got over that. But having said that, this is not only a statement on this. This is really speaking on the issues of mediation and arbitration, and the preferred mode and what we have come up with. I must say we have come a long way. This entire search for this process of dispute resolution, I mean, I know we are all lawyers, and I am going to again bring in Justice Nagaratna's comments here shortly. But we are lawyers, but we do need to understand that ultimately disputes need to be resolved at the earliest. We are in a world which is moving fast. We may have the Middle East at war as we speak, but at the same time, these wars will keep coming and going. We do need to get on where we can get possibly gas at good prices. We can ensure that trade goes on smoothly, and we will find a lot of issues which come up even with the current dispute in hand. So how to synergize this process? I again enjoyed the word that Justice Nagaratna used for spectrum of change, and that is, I think, the era in which we are kind of going forward. So having said this, Justice Nagaratna a week ago raised deep concerns with the Indian governments being the nation's biggest litigant. Over the last decade, the Indian government spent INR 400 crores contesting court litigations. In financial year 2025, private companies spent INR 62,000 crores on legal fees. Trilegal, and I'm sorry, I shouldn't be naming this, especially a firm, but a very well-known firm, between 2020 and 2025 has quadrupled its earnings. In 2024, the firm earned 1,000 crores. As a lawyer, I have no difficulty with these earnings. I quite support it. But as a patriot, I find this unacceptable. This is not only a question of money spent on lawyers. This is also a question of opportunity loss. And to compute such an opportunity loss is not possible. It is my belief that by marrying arbitration and mediation, we can create a legal regime that doesn't drain money, but assists businesses in flourishing in a rule-based regime. I understand that there are various models of dispute resolutions. Justice Nagaratna has been kind enough to put down all of the various possibilities, and actually there's no end to these possibilities. You have med-arb, you have arb-med again, in whichever fashion, and it's an open field. In fact, just recently I was doing an arbitration, and in that arbitration, while we were, the counsels were addressing, we asked them to consider settling, and they were coming in full scale for a fight, and these were 2 major motor companies, and ultimately they said, well, can we go ahead with the settlement talks? You proposed it on the last occasion, so we are going in for it. So this is the kind of situation that we do believe. There can't be a hard and fast rule, but there are a couple of issues that concern you. Should it be compulsory mediation in the first instance? I know there are some advocates for, and there are some advocates against. So it really depends. But to my mind, the Greek and the Italian model of opt-in and opt out possibly is good. Compulsory mediation, as Justice Nagaratna mentioned, 12A of the Commercial Courts Act, is something which is desirable. You actually at least push in parties for the first leg. If it doesn't work out, very well into litigation, very well into arbitration, very well back again into mediation. So that is the foray that we are today heading into. Whether there should be also the second question that I think is of some significance is a double hat situation. Should a mediator be an arbitrator, or should a mediator not be an arbitrator? Now there are advantages, but having said that, there can be two phases. You can actually have mediation and start the process of arbitration at that time itself. And that helps you because you can then not raise questions on the mediation and the arbitrator being somebody of credibility, and you would not oppose that later. You could consider having the arbitrator at a later phase after the mediation is over. Then again, the second phase of mediation. But then that should be a different phase. So you have two phases where you can actually bring in to expedite the process. And as I mentioned, during the processes, you have various possibilities. So for example, you have an arbitration. It is reserved for orders. At that stage also, prior to the award being pronounced, you can actually have a process of yet another last attempt at mediation when parties know what is the cross surface. So anyway, ladies and gentlemen, as I said, there are various solutions. We all know the distinct advantages. We are all experienced litigators. We are all experienced arbitrators. We are all experienced mediators. I do believe India needs to kind of kickstart the Mediation Act a little more, as mentioned just now by Justice Nagaratna again. But at the same time, we do have ad hoc mediation going very successfully as we speak. So it's just a matter of putting the processes into place for this to be effective. We are in this field, in the global field, pronouncing ourselves very pronouncedly in the field of alternative dispute resolution. This synergy, this spectrum, is something that we are looking forward to, and we have, ladies and gentlemen, today the most top people, I might say, people I'm very fond of, aside from being the fact that they're the most efficient arbitrators, mediators across the country and across the globe. So with this, I would like to call upon Sapna Jangiani, who, as I said, is a very popular person with the world and with me. And I think it starts with His Excellency, Justice Sapna Jangiani, a judge in the Court of Appeal of the DIFC courts, alongside her independent practice. And that's an interesting feature today. You can have international judgeship along with practice, which I think is something that I went in for also. She's a member of Blackstone Chambers, based in Singapore, previously practiced in London, New York, and Dubai. 25 years experience, even though she doesn't look it, as counsel, arbitrator, and judge in complex commercial disputes seated all over the world. She's a KC. We were just discussing KC and QC across the chamber. So with this, I think there's so much more, Sapna, but may I ask you to give your opening comments, and then we'll take it up from there.
Thank you very much indeed, Pinky. Can everybody hear me? Mike? It's such a privilege to be here. May I please start by disabusing anyone in this room of the notion that women don't make as good commercial mediators as men. I think the reality is the top commercial mediators, those who are most sought after, are senior practitioners, and we have less senior practitioners or women, as women. But of course, that paradigm is changing. But I think women are just as able as men to mediate complex commercial disputes. So I'd like to start off by looking at some data. Now, a couple of years ago, I had the pleasure of being involved in a task force of the ICC Commission, and its focus was arbitration and ADR and how they intersect, with a particular focus on mediation. And they collected both qualitative feedback and quantitative feedback from users, specifically in-house counsel. And they found that what business users really want from dispute resolution are three main things. Firstly, more dispute prevention tools. Secondly, more dexterity across dispute resolution options. I know Justice Nagaratna has spoken about this. And finally, arbitrators who can encourage or facilitate settlement. And I think traditionally we've not had arbitrators who are doing that. I think there's been a lot of impetus in courts to support mediation because they think it's in the interest of justice, but it also helps court backlogs. Courts have wider powers, wider duties than arbitrators. Arbitrators traditionally have been just focused on the specific dispute before them. But I do think that's changing. We've talked about the different ARB, MED-ARB protocols that we have available. In one of the surveys of the task force that I was involved in, 70% of users were of the view that arbitrators should inform parties about ADR options during the first case management conference. Now, 20 years ago, that would have been unheard of. But because users have been telling the dispute resolution world that this is what they want, we're starting to see that in different institutional rules. The ICC arbitration rules in 2021 have included a provision that arbitrators should encourage settlement facilitation, including by mentioning ADR options or proposing to the parties they may wish to consider, say, a mediation window. In 2025, the most recent edition of the SEAC rules has provided that the tribunal may consult with the parties at the first case management conference about ADR options and the potential for settlement of the dispute. And in the latest Whiten Case Queen Mary University survey, there was a significantly higher percentage of respondents who favoured a combination of arbitration and ADR rather than just arbitration. So I'm going to end with another survey that was mentioned in this task force report. It was a survey conducted by the International Mediation Institute. Now, in the survey, practitioners all around the world were asked to respond on what they thought the role of arbitrators should be in settlement facilitation. And the staggering statistic from that survey is that when asked, do you think an arbitrator has a role in fostering settlement, over 78% of participants said yes. So nearly 80% of practitioners think that arbitrators have a role, and it could be something as benign as asking the parties at the case management conference, as I've suggested, have you thought about ADR? Do you want a mediation window? On the other end of the spectrum, it could be the arbitrator actually trying to facilitate settlement between the parties, which is regularly carried out in certain civil law jurisdictions such as Germany and Switzerland. So we'll talk about all of this later, time permitting. I think one option we need to think about is the possibility that if an arbitrator facilitates settlement, it's without confidential caucuses, so it's not going to be mediation per se. It's usually both parties present, and it's more a sharing of preliminary views to help focus the parties' minds on where a settlement may be possible. Now, it's something that's a complete anathema, I think, to many of us trained in the common law tradition. But if we think about what users are telling us that they want and this dexterity between dispute resolution options, I think it's something that we need to explore, we need to discuss. If you speak to our German law qualified and Swiss law qualified colleagues, what they will say is, who is better to facilitate settlement than the arbitrator or the judge? Who knows the case better than them? Why should you go to a third party? And I recognize that's not something that we're very familiar with in the common law tradition, but it's certainly worth exploring and learning more about. Thanks.
Sapna has really brought up interesting questions, and we'll come back a little more. May I turn over to you, Yilong? You're the co-head of Allen and Gledhill LLP's international arbitration practice, and the head of the firm's restructuring and insolvency practice. He is diverse expertise in all subjects of construction, energy, oil. He's an arbitrator in almost every possible organization that I know. Sorry, I was looking that side. So having said that, I think the introduction could go on, but you definitely have an expertise of almost 36 odd years And we would love to hear from you.
Thank you very much. Good morning, everyone. It's a real honor to be here this morning to talk about our favorite topic, ADR. And actually, it is actually, I think, an opportune time actually to start talking about ADR in the form of the relationship between arbitration and mediation. Now, as we all know, both this form of ADR has developed separately. And it's not always obvious that they should have a relationship with each other. But from my own practice, actually, and a lot of my own practice is in infrastructure development, construction, building, and it was in the 90s that I started noticing that in the arbitration world, we start getting into mediation or getting informed of mediation. Why is that? Because a lot of infrastructure contract and construction contract actually provides for mediation as a form of pre-arbitral multi-tier contracts. In fact, the FIDIC contract introduced in the 1999 suites actually mandate for settlement discussion to be held before one can start an arbitration. So that's where we start getting in touch with mediation and starting to have to deal with the issue of mediation, because there's a lot of issue that parties have said, oh, you have not complied with the multi-tier requirement and you have not gone for mediation, therefore you cannot start an arbitration. That's where the arbitration practitioners start getting, in terms of their relationship with mediation, that's where it all starts. Now, mediation, I think, as we all know, has all its benefits about party maintaining their relationship, and it has got a lot of benefits. But the one problem that mediation has is that if you actually successfully mediate the matter and enter into a settlement agreement, and the settlement, one party does not carry out the settlement agreement, then the settlement agreement is but another contract for you to enforce. You cannot immediately enforce the settlement agreement. I think that's when SIAC started with the ARP-MED-UP protocol. And it was in 2014 that the Singapore International Mediation Center was established, and the protocol was introduced really to address this particular issue of mediation that results in a settlement, but need to be sued upon again. So to obviate that, there's the idea of you start an arbitration, then you go into mediation. And once you successfully enter into a settlement agreement, you can go back to the arbitrator and get the arbitrator to record the settlement as an award. And once the award has been recorded, it is enforceable in all the New York Convention countries. And that's the whole idea of the ARP-MED-UP concept to address that particular deficiency that mediation has. But we have come a long way since then. Since then, I think arbitration institute has recognized mediation as a very valid want of the user. I think Sabna have told us about all the surveys that have been conducted, and users really want to explore mediation as a possible way to resolve their dispute, even though they may have started arbitration. And arbitral institutes have responded to that. You have ICC, LCIA Hong Kong, who start looking at mediation as a possible outcome for their users as well. And that's why you see in their rules, they start mandating tribunal to tell the arbitral parties that there is a possibility to mediate. If you want to mediate, we can facilitate it. We can suspend the proceedings, and we can also, if you successfully mediate, record it as a consent or what, so that it can be enforced straight away. All these have developed, and I think Sabna had also mentioned about the 2025 rules as SIC has introduced last year, and that's have taken the ARP-MED-UP protocol to a further step, in the sense that there are four areas that the SIAC 2025 rules have introduced. First is that when a notice of arbitration is filed, there is an option for parties to indicate whether they are amenable to mediation or any other form of negotiations or up protocol. And then in the response, the respondent also have the option to indicate whether they are amenable to such thing. And the tribunal can do two things. Tribunal can, first thing they need to do, and is mandated in the 2025 rules, is that in the first preliminary meeting, they have to inform the parties that there is the option of going for mediation, and if they so intend, that arbitration can be suspended and they can go for either up or any other form of mediation that they want. And the other one is that if any time that the parties want to mediate, the tribunal has the power to suspend the proceedings and allow party to mediate. So it goes to show that really, in terms of the ADR world, the relationship between arbitration and mediation has really come a long way. I think, as Sapna said, I think 20, 30 years ago, no arbitrators would, in their wildest dream, dare to suggest mediation to the party. I think they spawn out a few fears. One is that they do not want to appear to be biased, or to have said something which has led them to being accused of bias. But nowadays, I think it becomes mandatory and is supported by the arbitral rules. And so I can only see the relationship between the two ADR, form of ADR, arbitration and mediation, becoming closer and closer. And I'm sure if time permitted, we will have some very fruitful discussion about that. Thank you.
Thank you so much, Shi. I think you've narrowed it well between your statement and our earlier statements. The world has changed. Now we're looking at all sorts of different possibilities of solutions. With this, for the time being, let me go to Sahil. Sahil, of course, has an extremely diverse practice in dispute resolution, which is, I think, the new word in town. He works with and is running Khaitan and Company. We also have Mr. Khaitan here as the president of our ICA. So Sahil, may I ask you to give your opening statements?
Sure. Yes, ma'am. Thank you so much. So firstly, thank you so much, Justice Nagaratna, for setting the right tone to this, panel. Very rightly, you've put in, the background of mediation, litigation, mediation, arbitration, and arbitration, mediation, arbitration. And of course, to Sapna, who brought the international perspective by bringing in the data. So I would like to start by bringing in some domestic perspective, right? And I would like to start by a number for everyone. And that number is 40%, right? That is the current satisfaction rate with domestic arbitration among Indian businesses. And it is down by about 14%, which was 54% a decade ago. And this is a survey which Khaitan and Company did in 2024. And I'm sure not much has changed in the last 1 year. And this number, of course, is raising alarms for us as practitioners, that whether we are, using arbitration rightly, or we are underutilizing the other modes, such as negotiation, mediation, and ARB, or MEDARB. So it's not only us as practitioners who are faced with this question, it is also the government. Unfortunately, the government very recently, in 2026 and also in 2024, has decided to remove arbitration clauses from its contracts. And unfortunately, we have a lot of arbitrations against government. And whenever we are talking to, people who are representing the government, they say that in all fresh agreements, they've decided not to go ahead with arbitration clauses. In some cases, the arbitration clauses are limited to disputes which are below 10 crores. And, that makes me think, where is arbitration heading? So, and what is the right fix for it, right? And, looking at this, I feel that we really need to advise our clients wisely by telling them what is the right forum for you to mediate, to litigate, or to negotiate. And we as practitioners should not be afraid to advise our clients properly. And of course, Justice Nagaratna has very nicely put the various features of the Mediation Act. So I also wanted to touch upon that, since I'm also an enthusiast of mediation, and that to commercial mediation, which we haven't been able to take as far. And I'm sure there are some lacunas, or we are not yet at the same level as SIMC or SIAC, where the protocols are so good that people are also preferring mediation. So yes, Mediation Act is a welcome move, but at the very same time, the enforcement is delayed. We really want that enforcement should happen as soon as possible. India should also ratify the convention, the Singapore Convention on Mediation. If that happens, of course, the mediated settlement agreements will have proper enforcement, in various countries who are parties to the convention. So that will certainly bring some sort of certainty to the enforcement mechanism. And of course, there is also a proposal, bill of 2024 to amend the Arbitration Act to amend Section 30 of the Arbitration Act, wherein, of course, nowadays what we do is that if parties, they try to settle a matter while they're in the arbitration, we tell them that you draw the consent terms and you go for an award, a consent award from the tribunal, and therefore you'll be able to get the benefit of New York Convention, and you'll be able to enforce it in multiple countries. But now, of course, they are trying to change it, and they're trying to change it by saying that it'll be a mediated settlement agreement rather than an award. So of course, that'll also be a welcome change. It is putting a lot of confidence into mediation. And with that, of course, we'll delve more into the questions in the session, which Pinky ma'am is going to ask us. So thank you so much, everyone. Thank you for the opportunity.
Thank you, Sahil. I think he talked about the arbitration amendments, which was posed as a real question. Right now, our country is looking at various amendments to try to fast forward the entire process. We'll talk more about it at some other time, but it's indeed a welcome development. And I must say that India has been very forthcoming in the various forms of amendments to the arbitration and mediation platforms, I think, which shows a progressive nature towards resolving disputes in this fashion. May I now call upon Divyam to give his opening statement. Divyam Agarwal is an Indian lawyer and an English solicitor as well, a partner with JSA, a preeminent firm, of course, handling international arbitration, commercial litigation, and of course, mediation. So, Divyam, over to you.
Thank you. So, good morning, everyone. Good morning, Justice Nagaratna, Dr. Anand, Ms. Jhangiani, Elong, Sahil. And thank you, ICA, for having me. The difficulty of going last is that you end up having very less points left to really present. I'll start with what Joseph Brinham had stated, that an ounce of mediation is worth pound of arbitration and a ton of litigation. So that goes on to show the importance of mediation, but I'll also show that this is the mindset we all have, that we always referred it as an ADR, alternate dispute mechanism. The philosophy, the mindset which needs to change is that how do we harmonize mediation and arbitration, mediation and litigation, and possibly all three in a given scenario. The difficulty, I would say, when we talk about harmonizing mediation, arbitration, litigation, is there are some ground realities. I was going through some statistics. Justice Nagaratna pointed about the pre-mediation litigation. The statistics are that there is only 2% settlement that has been arrived at last year by using this mechanism. Out of 870, out of 59,568 cases, 877 were settled. But that does, while that underscores the fact that the system is not being effectively utilized, it does not underscore the importance and effectiveness of the mechanism. The difficulty is that there are roadblocks which are created virtually by lawyers, by the clients, which is not allowing the system to evolve. And I'll give you certain examples, which is where we all as lawyers, as a community, we need to come together and sort of educate the clients. I'll cite an example. I was doing an arbitration and all pleadings were complete, contentious dispute. I told the client that, listen, why don't you take a shot at mediation? The client's reaction was, it's a promoter, his reaction was that, why you don't believe in my case? You don't think I'm going to win? So why are you asking me to settle? So the reaction I had was that it's not that I don't believe in your case. I'm confident about the case, but I'm also confident enough that when you go on the table, you're able to settle it out. You're not going to prolong it for many years. It's not just going to end here. You have arbitration, you have 34, you have 37, you have going up till the Honorable Supreme Court. So why not end it now? Why not cut short this delay and see if you're able to resolve it? Another issue that happens is the tokenism that is involved in this process. Sometimes it's just a checkbox. I have seen a lot of clients going for this pre-mediation litigation or for that med-up, stating that let us go through this procedure, let's just finish it off, let's go through the drill, let's not focus it. But I have seen those cases as well where highly contentious disputes, two commercially savvy parties decided to really follow the procedure to the T, and they are able to resolve the disputes in an amicable fashion. It also helps in, and which is very important, that their relationship continued. What happens when you go for a protracted arbitration or litigation, your relations are to the extent that you don't even see eye to eye. I have, in fact, seen, and it's a sort of a surprising aspect that I've seen government also resolving disputes now, where the government is even willing to pay. I have done an arbitration where we were against a PSU, a Maharatna, and they decided to enter into a mediation during the pendency of arbitration. We were able to successfully bring it while going through the pleadings, taking them through the expert reports. We were able to impress upon them that this is a matter which does not require protracted dispute. We can resolve it, and where the PSU agreed to pay some portion of the claim to the client and settle it out. However, the difficulty is, and that's, I would say, is an exceptional circumstance. The difficulty is in government dispute, no law officer, no government officer is willing to take it on his or her head, that let us resolve a dispute where we end up paying. They have the fear of vigilance, they have the fear of inquiry. No one is, so what we really need to do is we need to empower the officers, we need to empower the people who are dealing. We should have trust in them. We should allow them to appreciate the nuances of the case, and which is where what Long pointed about, that arbitration, ARB is a better format. One more reason why it's a better format as per me is that when you do first start with arbitration, you flesh out the entire case, you put together all the pleadings, all the expert reports, everything goes in. Then the case is spelled out in a more elaborate fashion. Both parties have this realistic feel of the case. They realize where they're heading, whether they would like to accept it on the face of it or not, but they know that this case, what are their strengths and what are their weaknesses. So yes, you would want to have that kind of a platform laid out before you decide to go for your mediation. Another aspect I would also like to point out is the lack of confidence. Sometimes the impression is that if you're going for mediation, the case is not really worth the time and effort. which needs to be taken off, what really needs to be focus is, and I mean, I'll not blame all the clients, all the cases, because sometimes there is an adrenal rush syndrome also. People go for a dispute, they say, no, let's go all out, let's fight it out. We have been wrong, there is a breach of contract, let's fight it out till the end. Which is where a skilled arbitrator, skilled mediator comes into play. They have to bring it to them that we need to sit down on the table, really look into the fact, while of course you are agitated right now, while there is a hostility on both sides, but the timing of it also needs to be calibrated properly. You need to see really at what time. It should not be a situation where you already have a sunken cost gone into the dispute and you realize at no point now going for mediation, I need to recover everything out. Also, there should not be a situation that it should be a very hostile situation. Parties are really not amenable to any form of dispute. So again, as I said, timing is relevant. It's important to see at what time we really need to come forward. And just one last point, and then I'll hand it over, that we should avoid this siloed approach, that when we are talking about mediation, we only talk about mediation, because as Sahil pointed out, government came up with a circular stating that we'll go for only mediation for a dispute over an X amount of money. That kind of approach also needs to be dispelled with. They have to be harmonized, they have to go hand in hand. It cannot be a situation where one particular resolution mechanism is sufficient in itself. We all have seen every resolution mechanism fail in some form or some manner in some or the other assignment. So it has to be harmonized, it has to be seen and calibrated for each and every case, and which is where the arbitrators, the mediators, the counsels, the judges, all will have an important role to play.
Thank you, Divyam. Ladies and gentlemen, 2 quick questions and we'll go into wrap up. So, Justice Nagaratna, what should we do in this country to improve the lot and the standing and the credibility of arbitrators and mediators?
Thank you. See, we all know that Section 89 was initially there in the Code of Civil Procedure. It was deleted and then again added. What does this imply? It means that ADR became an alternative to a court system of adjudication. So, alternative does not mean a lack of standards. We have a rigid and disciplined system of court adjudication. We trust the courts. But why don't we trust the arbitrators or mediators? The question is, what is the standard we are having in arbitration and mediation as an alternative to court adjudication? We have many advantages of it, but one of the disadvantages is this conduct of the arbitrators or mediators, and sometimes to the extent of saying that there is a lack of trust, a bias, or a misconduct. And it's very difficult to change the arbitrator on that score. Therefore, my submission is that the arbitrators and mediators must first of all have within them the sensitization that they are an alternative to the court system. That means they are as equal to adjudication, but it is not an adjudication, it is an ADR mechanism. The standards of the arbitrators and mediators must be very high standard, and they have to maintain that throughout the proceeding, and there can never be any reflection of a bias or anything. That is the first thing I would say. And the second aspect is with regard to the, can I just say another word? With regard to the composite systems of ADR that have to be worked when a dispute arises. At the very initial stages, every party, every legal practitioner knows what are the strengths and weaknesses of a case. Now, as it was said that if the legal practitioner or advocate tries to explain to the party that this is your weakness in the case, this is the strength in the case, probably as far as the weaknesses are concerned, the party will think that is the strength of the case. But it is actually a weakness, then the party thinks that I have to change my advocate. Therefore, there has to be an education with regard to the dispute as such with the party from the legal practitioner to explain where they stand, both sides. A strength of one party is the weakness of the other party and vice versa. So if they go in for a pre-arbitration negotiation, or I would say a pre-arbitration mediation with this kind of an education, then the things would be easy to settle. That is one thing which is necessary. The skill of the legal practitioner to convince a party the strength and weaknesses of his or her case is important. And maybe the advocates have to be trained in that regard in the first instance as to how they would grasp at the litigation in the very initial stages itself, and not as the case proceeds either before the court or before the arbitrator as such. Even with regard to the arbitrators, reference to a mediation at the crucial stage of arbitration should not be viewed as a kind of a misconduct or their refusal to pass an award. I must say that in favor of the arbitrators, it is an attempt to settle the matter, especially in commercial cases where the relationships have to be continued. Reference could be even after a mediation has failed. In a pre-arbitration mediation or negotiation, if it has failed, arbitration has commenced. At a particular stage, the matter could be referred to mediators, but not the same arbitrators to be turned into mediators. They should be separate. And if it can be settled at that stage also, for the matter would result in ultimately a settlement award, and there's no further recording of evidence, etc., etc. So this is another aspect. Even after an award is made, matter goes under section 34 for challenging an award. There could be a mediation at that stage because there's already a crystallization of the dispute further in the form of an award. So at that stage itself, section 34, where the challenge is made to the award, there could be a mediation or a negotiation or a compromise, whatever you may call, Order 23, Rule 3, and settle the dispute. These are the 2 points I wanted to highlight insofar as the legal practitioners and arbitrators are concerned. Of course, there is no forum as such where a misconduct of an arbitrator is complained against except before a court, and the courts are very wary of changing an arbitrator as such, because many of the arbitrators, you know, are former judges, chief justices, and with the higher positions that they have already held. Very rarely it happens, but the thing is, it all depends on the standard the arbitrators and mediators would have to meet as compared to the court adjudication, and not forget that ADR does not mean a slackening of standards or rigor or discipline. Thank you.
One approach that we've started to adopt in Singapore is that we have shifted our language to shift our mindset. Instead of talking about alternative dispute resolution, we have started terming it appropriate dispute resolution. And I think that to get this mindset that we need dexterity between options, it's not a zero-sum game, it's trying to bring in mediation at the right time. And I agree with everything that Divyam said about this. Over to you, Yilong.
Yeah, I think it's actually very topical now to talk about qualification and ethical standards, which is very important of arbitrators. I think there's a lot of debate and discussion now going on in Singapore as to what is the relevant ethical standards of arbitrators and counsel. Because sometimes, you know, as arbitrators, when we go into arbitration, we do encounter some very naughty behavior from counsel. Particularly, I think they take liberty in arbitration because very few arbitrators will want to report a misconduct by the counsel. to the relevant bar association. And sometimes, because counsel comes from very many different jurisdictions, it's also very difficult for the arbitrators to make such complaint. But it is has become a problem enough for serious debate to be had in Singapore as to how we can manage such issue. And I think in SIAC itself, we are also looking at possibilities of establishing ethical standards. First of all, very importantly for the arbitrators, and secondly, for counsels who appear before the arbitration. I think the whole topic can actually be made another subject matter for a whole seminar that we can conduct. But those are the areas that we are looking at the moment.
See, I must in a lighter vein say, if you have a code of conduct for arbitrators and a code of conduct for legal practitioners who appear before, and there is a dispute arises between the codes of conduct, then you forget the parties. So that should not happen. You see, therefore, great responsibility is there when you're not going through the adjudication system and that rigor, and you want party autonomy and arbitrators to be, appointed as per your choice, etc. There's an inherent, discipline which is required on the part of the advocates, the parties, as well as the arbitrators. The parties also should not think that I'm making the payments, so therefore I expect the advocates and the arbitrators to listen to me. That cannot be their mindset too, because that is sometimes their mindset and they command. That is not correct also. Similarly, a restraint is required as we have in a court adjudication on all sides. And therefore, it will not be really good to have a code of conduct as such for arbitrators and then a violation and then change the arbitrator. That is not going to help the arbitration ecosystem at all. Thank you.
Just a final couple of points about promotion of mediation that I've seen from Singapore. The first is to look at incentives. I mean, I said that one of the drivers for courts is to reduce the number of cases on their docket. Arbitrators never want to reduce the number of cases on their docket. But I think that if we have this mind shift change, and I think we've had a lot of capacity building on this in Singapore, that users want better settlement options, and arbitrators and counsel who start proposing and talking through the options as to what might be appropriate, they're actually going to expand their practices rather than reduce them. And the second point is just, I think that a key driver for the promotion of mediation in Singapore is the ratification of the Singapore Convention on Mediation, just to pick up on what Sahil said. And the Domestic Mediation Act really is exactly the same structure for domestic mediation, so I hope that it's possible that we might see that step forward taken in India in the future.
Thank you very much, ladies and gentlemen. This has been a very interesting debate on synergies of all systems across the world. So with this, we hand over the mic back to Akshita to take over.
Thank you, ma'am. That was indeed a thought-provoking, enriching discussion. On behalf of all of us, I extend our gratitude to the chair for the session, Honorable Ms. Justice Nagaratna, and to each of our distinguished panelists for sharing their valuable expertise and perspective. I would now call upon stage Dr. Khaitan and Mr. Chawla for the ceremonial picture of the session. As we conclude the session, I would request the dignitaries for the technical session 1 to kindly take their seats in the audience. Meanwhile, I request attendees to kindly remain seated. We prepare for the next technical session. Welcome back, ladies and gentlemen. It's a pleasure to once again welcome our distinguished guests and valued participants joining us from India and overseas. May I request our honored dignitaries to kindly take their seats on the dais? पीछे से जाओ Without much ado, it's my privilege to welcome you all to the technical session 2 titled ADR Mechanisms, a Catalyst for Global Economic Growth and Investor Confidence. This session seeks to maneuver the imbroglio of an increasingly volatile global order and to examine how ADR mechanisms, particularly arbitration and mediation, foster investor confidence by ensuring neutrality, predictability, and efficient dispute resolution across jurisdictions. Building on the momentum of the previous session, we look forward to a focused, engaging, and insightful discussion that will illuminate key challenges, emerging trends, and best practices in the ADR ecosystem. Without much delay, it gives me great pleasure to invite Mr. Arun Chawla, Director General for ICA and former Director General for Key, to kindly welcome the chair on behalf of ICA.
Ladies and gentlemen, we will now have another scintillating session focusing on ADR mechanisms, a catalyst for economic growth and investor confidence. It's my distinct honor to have Honorable Mr. Justice Ehsanuddin Amanullah, Judge, Supreme Court of India, chairing this session. Ladies and gentlemen, many of us have had the privilege of hearing you at a prior ICA organized event under the umbrella of Delhi Arbitration Week, wherein the insights of arbitration and dispute resolution resonated deeply across participants. Justice Amanullah has been a leading figure in the legal arena since 1991. He has served with distinction at the Patna High Court and the Andhra Pradesh High Court before being elevated to the Supreme Court. While at the Patna High Court, he was instrumental in drafting and vetting subordinate and delegated legislation for various acts passed by the Bihar legislature. Furthermore, Justice Amanullah pioneered innovation as the first judge to conduct a paperless e-court at the Patna High Court. Before we invite Justice Amanullah to deliver his keynote, may I request Dr. N.G. Khetan, President of ICA and Senior Partner Khetan & Company, to felicitate Justice Amanullah with a green certificate, a pledge by ICA to plant a thicket of 8 trees at a facility in Ayodhya, Uttar Pradesh. May I now request Justice Amanullah to deliver his keynote address.
Good morning, everybody. Namaskar. Sat Sri Akal and Assalamu Alaikum. Sorry for the delay, but I think the previous session was quite interesting. I wasn't aware, otherwise I would also have come and sat at the audience. I thought it would end soon. But I think we will not rush through, because this topic, I think, will also interest you, because this is a more practical and relevant topic in the sessions. Mr. Chawla, who has been very kind enough to invite me, has always been in touch, a very learned person, I would say, in the sense that he has a deep insight about the dynamics of the system and how it works. And then now in this role, I think he's a very key position in which he is really discharging his duty toward that position of now the globalization of everything. Mr. Ratan Kumar Singh, Mr. Jimmy Yim, SC Senior Partner Dewey Napier, Mr. J.P. Duffy, Partner Bracewell, Madam Shweta Bharti, Partner Hammurabi and Solomon, Ms. Ela Kapoor, Partner Shaldur Amarchand Mangaldas, distinguished guests in the audience, ladies and gentlemen, and members of the press. Today, I don't have to remind you, because you must have seen in the brochure, but still, this session is dedicated specifically toward ADR mechanisms, a catalyst for global economic growth and investor confidence. Like you, I am also waiting to hear the panelists, but just to give you a few of my thoughts on this, perfunctory, just touching on the topic. In a timeline defined by rapid globalization, cross-border investment, and unprecedented economic interdependence, the stability of commercial relationships, especially given the geopolitics of today, disputes and dispute resolution mechanisms are in the spotlight. Today's era essentially conveys that disputes need not necessarily always be or become roadblocks. As long as legal systems guarantee, or at least attempt to guarantee, that disputes will be resolved efficiently, fairly, predictably, without derailing commercial momentum, whether through arbitration, mediation, conciliation, or a mixture of these, or via a hybrid process, ADR can emerge as a catalyst for economic growth and a guarantor of investor confidence. Economic growth thrives on certainty. Investors deploy capital when they trust that their rights will be protected, their contracts enforced, their disputes resolved impartially, and enforcement of decrees or awards. ADR mechanisms or systems, in my view, should aim to provide assurances such as speed and efficiency to reduce the cost of doing business, neutrality and party autonomy to empower investors across jurisdictions, enforceability of arbitral awards to give businesses confidence that outcomes will be respected, and most importantly, confidentiality to protect sensitive commercial information and preserve business relationships to the extent possible. These, if translated on the ground, would do more than resolve disputes. They would enable investment, encourage innovation, and strengthen global supply chains. More often than not, foreign investors face unfamiliar legal systems, regulatory uncertainties, and geopolitical risks. ADR mechanisms thus have a potential to act as a stabilizing force, offering a neutral forum insulated from local biases, predictable procedures, preferably aligned with international best practices, specialized adjudicator with commercial expertise, adequate secretarial assistance, and reduced litigation risk, as disputes ought to get settled amicably, and if not so, within the ADR sphere, either by mediation or arbitration or any other mode. Notably, when investors know that disputes will be handled professionally and efficiently, they would be, statistically speaking, more willing to commit capital, enter into and expand long-term partnerships, and expand operations across borders. The original value of ADR lay in its ability to provide a cost-effective alternative to traditional litigation. By reducing the financial burden of prolonged legal battles, it was hoped that justice would be accessible not just to multinational corporations, but also to small and medium enterprises. Incidentally, despite humongous conglomerates straddling the world, these small and medium enterprises remain the backbone of global supply chains. Countries that embrace robust ADR frameworks send a clear message to the world that we are open for business. In the same vein, modern arbitration laws coupled with strong institutional and judicial support frameworks for ADR signal a mature, investor-friendly environment. While judicial intervention cannot be totally ousted, resulting in a hands-off approach, it can be recalibrated to an interference only when really needed model. I do not for a minute say that India should blindly ape what others are doing, but surely leading economies of the world and best practices from other jurisdictions should be examined and emulated with some tweaking for regional variations. The alignment of our domestic laws with internationally accepted norms is a continuous and evolving process. This consistency ensures that the rule of law is not merely a local concept, but a global guarantee, providing a level playing field for all market participants. As we look ahead over the horizon, ADR itself is evolving. Online dispute resolution, artificial intelligence, assisted case management, virtual hearings, etc. are innovations that will make dispute resolution even more accessible, cost-effective, and globally harmonized. Yet, technology should serve to enhance the transparency and speed up the process, not replace the nuances best left to humans. In this case, the arbitrator, or as the case may be, the arbitral tribunal. That said, the future of ADR rests on trust. Trust in institutions, in arbitrators, in procedural fairness, and in the rule of law. The success of these mechanisms in equally, if not larger part, leans also on the robustness of arbitral institutions. The development of arbitral institutions will bring about an added element of certainty inasmuch as sophisticated procedural rules will be simplified and known in advance. In complex sectors such as energy and construction, the parties should have the ability to select arbitrators with specific technical expertise. This would ensure that decisions are also commercially sensible and viable, further reinforcing certainty that investors so deeply value and desire. The legislature must stay alive to the concerns of the major stakeholders of the arbitral process. In my view, more than the judiciary, it is for the legislature as also the executive to take steps to be alive to the views, whether positive or negative, and take appropriate steps. The judiciary, I may state, steps in only when it is forced to, especially qua gaps in the statute or deficiencies in connected subordinate legislation. Last but not the least, a change in mindset is required to bring about confidence and faith in the integrity of the ADR sphere. In this aspect, it goes without saying that no big-ticket changes can bring about this, but incremental and targeted steps towards fostering such culture can surely prove useful. Legitimacy will follow when integrity and confidence meet. In sum, ADR hence is not merely a legal tool. An economic instrument, it can transform into a diplomatic bridge, reducing friction, enhancing predictability, and fostering confidence. ADR mechanisms help nations grow, businesses thrive, and investors believe in the promise of tomorrow. ADR thus would be not just an alternative, but an essential pillar of sustainable global development. The choices made today can shape the confidence with which the world invests tomorrow. Before summing up, I'd just like to throw two ideas to the audience. Slightly it may sound incongruous and not in line with the mainstream. I've just flag marked two biggest challenges. One is the time frame. How do you fix a time frame in an arbitration? Laws, statutes cannot ensure that. For that, practicality demands that the arbitrator or the arbitral tribunal itself imposes certain restrictions upon itself with regard to the number of such disputes it would handle at a particular point of time. That has to come from within. It cannot be enforced because no matter what you write in the statute, the practical experience all over the world has been that very rarely it is really adhered to. That is the biggest, one of the biggest, and most importantly, the implementation. For this, it has been my consistent view for the last 2-3 years, and at 4-5 such conferences, even abroad, I flagged that site of arbitration is very important. Now, in the world of globalization, there has to be respect among nations of each other's competence, jurisdiction, and the confidence that the matter would be equally heard in the same way as it is heard in their own country. This is important because when implementation comes, it becomes a problem. If the award is of another country, what happens? To what extent? Then the courts come. A lot of issues come, local issues come, which probably may not have been really gone into while coming at a result in these matters. According to me, when businesses really want to play safe, they should always choose the place of arbitration to be the country where actually the scene is happening or the event happens. I think that would be the best option for any future complication if really the parties want that the award should also be implemented effectively and quickly. There is no otherwise there will be disputes. The local judiciary is supposed to be insulated from all these legislations. Whatever good one side would think, it has to be independently to be judged on many various parameters, which according to the other side may not be reasonable. It's an open debate, it will never end. But if really it has to have an effect, and yes, conciliation, I think nothing better can be there, and India has started the process of enacting an act in 2023, the Mediation Act. I think the encouragement to do that, the desire will also have to be inculcated by the so-called experts in the field, in the sense who are the advocates, who are the counsel for the clients. Sometimes we think in our own way, and that element, you cannot detach yourself from the brief you are holding, in the sense that you also have a commitment that briefs should keep coming to you. You also have a responsibility towards yourself and to your fraternity. I'm not saying that unethical practices are being introduced. Not for a moment I should be misunderstood for that. But then you have to take a practical. And I don't know whether one other thing which I've always flagged is that how effective all these mechanisms would be without the participation of the real person who is affected. There should be wide participation of the stakeholder who actually is the beneficiary of the award or who comes with the dispute. Has his or her view been taken? That is most important. What do they look to a system? What would they want? Without taking names, I'll just give you an analogy. You know, he's still there, there's a chief minister in the country. There may be many with these things. He was credited with getting a lot of investments, and effectively businesses, houses rushed to that state to set up industries. And it was a success. You know, I asked him, he said only two things. He said, whenever I used to call a meet of all the stakeholders, the big businesses for investment, my secretary used to go and meet the boss at least a week in advance. His one query was, the chief minister has asked, what according to you is the minimum you would want on day one? He would not ask, he would not go into the dynamics, whether it is reasonable, no discussion. You give me just 2-3 things which you think this should be the beginning point. He would note down, he would come, it would be deliberated upon, and before the conference began, the first thing the CM would say, this is the basic I announce from this platform. It would be more than what they'd asked for. So nobody could say no, and it clicked, and he made sure that it was a single window system. That is the commitment. That is the commitment, direct contact from what the person for whom it is meant wants from the system. We are trying to form a system, trying to think on behalf of the, it is for the person to come. That person, is he really, really involved in these activities? Is he really a stakeholder when it comes to recognizing him as a stakeholder? I think we are too much lacking on that front. That is my personal and firm view. They are not taking into, their view is not taken into account as it should be. They are the major stakeholder players. They have to be counted before anything really is achieved on the ground. I am sanguine that the discussions ahead will leave us with greater food for thought, with the insights to be offered by the esteemed panelists. I am also confident that the deliberations of all the sessions will provide some answers and to the questions that confront arbitrators, lawyers, and parties alike. Thank you. Jai Hind.
Thank you, sir, for your profound and insightful address. Your remarks have laid a thoughtful and intellectually robust foundation for the discussion ahead. At this point, I would request the chair for the session, Honorable Justice Amanullah, the panelists Dr. Khaitan and Mr. Chawla, to kindly join us on the stage for a ceremonial picture of the session before we start the panel discussion. As we now move towards the panel discussion, it is my privilege to introduce the moderator for the session, Mr. Ratan K. Singh, Senior Advocate, Supreme Court of India, and international member of Keating Chambers, London. We have had him time and again at the ICA conferences, lending his perspectives and expertise, and we are delighted to have him here today. He brings not only deep domestic expertise, but also a nuanced understanding of international arbitration practice and investor confidence mechanisms. Joining this distinguished panel of speakers are experts with rich global perspectives. Mr. Jimmy Yim is a senior counsel and chairman at Drew & Napier, Singapore. Ms. Shweta Bharti is managing partner at Hammurabi and Solomon Partners. Mr. James P. Duffy is a partner with the International Arbitration Group at Bracewell LLP, USA. Unfortunately, his visa got delayed. He's compelled to join us online today. Ms. Ila Kapoor is partner in the dispute resolution practice at Shardul Amarchand Mangaldas, India. Without much ado, I now request Ratan sir to kindly take over the panel discussion.
Good morning, my Lord Justice Amanullah, friend Jimmy, Shweta, Ila, ladies and gentlemen in audience. The topic, the ADR mechanisms, a catalyst for global economic growth and investors' confidence, is little enigmatic, but at the same time very timely. Day before yesterday, I was in Vietnam and in Ho Chi Minh City, and I was asked to speak on opportunities which ADR brings for construction industry. So the topics which we are having today is almost on the same lines. Question for us is whether ADR mechanisms if you have a robust ADR mechanism in your jurisdiction, does it really bring economic growth? Do we have empirical data on that? Yes, international arbitration and arbitration as an industry brings a lot of money to the particular jurisdiction. UK regularly does this data, collect this data and tell you how much money international arbitration per se brings to that country, that UK. We need to do this. But one thing is for sure, that every investor, domestic or international foreign investor, wants a robust dispute resolution ecosystem in a country where they want to invest. And the traditional court system has its limitations, we all know, whether it is delayed disposal through court system, or the issue of confidentiality, or the issue of flexibility. And something which personally to me is the most important aspect, that is expertise of the decision maker. Mellow Justice Amanullah just said, how to adhere to timeline in arbitration is a big question which we must pose to ourselves. If you would have appeared before Mellow Justice Amanullah in Supreme Court, or any other colleagues of Mellow Justice Amanullah in Supreme Court, you would get to see that within seconds, not beyond minutes, cases are taken up, argued, understood, and decided. It is all because of the expertise our judges have in the subjects they are deciding their disputes which are coming before them. Expertise is one thing which brought arbitration to a level where we are today, apart from other the positives we have. Now, whether a particular location or a place or a jurisdiction should be a place where one would like to go to do arbitration was an issue where there were a lot of deliberations. And I remember, since I am also director of Chartered Institute of Arbitrators India branch for 13, 14 years, now Chandru has joined me recently, Ganesh Chandru. So, in the centenary year of CIR, Chartered Institute of Arbitrators, CIR came out with 10 principles, which people call as 10 commandments, which tells us which are those places and what a particular place should aspire to have in order to become a preferred seat of arbitration. It says law of the country that should be clear, effective, modern international arbitration law which recognize and respect of the party choice of arbitration as the method for settlement. Second is judiciary, an independent judiciary, competent, efficient, with expertise in international commercial arbitration and respectful of the party choice of arbitration as their method for settlement of their disputes. Third is legal expertise, an independent, competent legal profession with expertise in international arbitration and international dispute resolution, providing significant choice for parties who seek representation in the courts of the seat or in the international arbitration proceedings conducted at the seat. Education, and which is very important, which important for us as well, and I know Sweta is also have something to say on this when her turn comes. On this principle 4, it says an implemented commitment to the education of counsel, arbitrators, the judiciary, experts, users, and students of the correct character and autonomy of international arbitration, and to the further development of learning in the field of arbitration. 5, right of representation. 6, accessibility and safety. 7, facilities, functional facilities for the provision of services to international arbitration proceeding, including transcription services, hearing rooms, document handling and management services, and translation services. In fact, my friend James has not been able to join us. 2014, I had gone to speak in Harvard Law School, and while coming back, I had meeting with James in New York, and James told us, why don't you visit NIAC, New York International Arbitration Center? I said, what is NIAC? Does it administer arbitration? He said, no. NIAC is an arbitration hearing facility which was promoted by 10 top law firms of New York. Now that facility is one of the most sought after facility in New York. So hearing facilities are again something which is very, very important. Ethics, enforceability, and immunity. These are the 10 principles which makes, according to this 10 commandments, 10 principles of CIF centenary thing. And the people who were really authors of these 10 principles were Lord Goldsmith, Doug Jones, Judith Gill, Julian Liu, Carol Narron, Toby Londo, Honorable Vivian Ramsey, Peter Rees, so all very celebrated international arbitration personalities. Ladies and gentlemen, we have got today amongst us very eminent panelists. So now we will first start with Jimmy. Jimmy brings in lots of experience and expertise to the table. And now we will start with Jimmy. Jimmy is going to talk about, and I suppose so, the nexus between good ADR mechanism and the growth, right to choose the mechanism, right mechanism of ADR, Singapore experiences, which we all look at, despite the geographical differences in terms of the size. But we always look at Singapore. In fact, recently, I was in Singapore, and there one thing which I liked about was that the Singapore Supreme Court had invited us for a particular talk on, talk was to be given to accredited construction lawyers. So Singapore has something called a provision for giving accreditation to expert construction lawyers, IP lawyers, or a couple of others. Fantastic model to adopt, because arbitration, as I said, is primarily about expertise. And if you recognize the expertise amongst pool of the professionals, you give them accreditation, it is easier for the parties to approach them. It takes lesser time in court because the advocates understand what they are up to, and if you have got especially judges. In fact, it really helps. In fact, few years back, Jimmy, I was in Singapore and for SCL International Conference, and I was asked 3 questions. Do you have construction legislations in India? Do you have specialized construction courts in India? And do you teach construction law in India? An answer to all the 3, ladies and gentlemen, then was in negative. But yes, after I came back, I worked hard being the founder and chairman of Society of Construction Law India branch. We got started construction law courses, certificate courses, LLM courses, PG diploma courses, and PhD now in 3 universities to start with. I'm honorary professor with 3. We are doing it. Mehak is sitting here. She is teaching in some of the courses. So it is going in right direction, but for other 2, whether we have got construction courts, specialized construction courts, we will have to look at to Milord Justice Amanullah, and whether we have got construction legislation which takes care of the, because why I'm talking about construction, because almost 60 to 70% arbitrations in India are construction arbitrations. If you look at the statistics of ICC Paris, around 40% of their disputes are construction and energy. So this is one area, Millets, we really need to give some focus on so that we can really take forward this whole journey of arbitration in right direction. With this now, I'll ask Jimmy to tell us his experiences about what he has seen all happening in Singapore. Jamie, over to you.
Yes. The Honorable Justice Aman Manula, Mr. Ratan Singh, clearly a senior advocate, the way he argues his points was so impressive. Good morning, everybody. It's a real pleasure to be here. It's an honor. Thank you very much, Mr. Chandler. Well, to start with, Singapore, we follow the 10 Commandments. That should be able to answer why we have such an effective system. Everything that has been distilled in that is true. You need all of them to make sure that you have the right environment for arbitration to follow. But the topic today is effective ADR as a catalyst to economic growth and investor confidence. I wouldn't agree it is a catalyst. I say it's more than a catalyst. A catalyst is something that is necessary to stimulate and cause a change. But it is not a catalyst. It is a precondition. It is a necessary ingredient. You cannot imagine today in any modern country where an investor putting in millions into a project cannot choose the law that governs the contract he enters into or choose the method by which he decides how disputes are to be resolved. And if you just cast your mind back 50 years, 100 years, no longer than that, any investor coming into a country will have to abide by local laws and local courts, and there were no options. So we have taken a sea change in the way international trade and international economic activity has been, if you look at it. And earlier you heard the session where they talked about how much change has taken place and so quickly. I remember a time not too long ago, just about 1 decade, here in India, judges had a certain disinclination to international arbitration or arbitration. They felt arbitrators were usurping the role of judges. But today, all the judges, particularly the Supreme Court, understand and support the autonomy of parties in choosing arbitration. So change has been rapid. Change is there, and I must say, my learned friends here in India and my international friends, we've all practiced law for a while now, and we can see how rapid changes are. So on the first point, it is not a catalyst. The right to choose an effective form of dispute resolution is a necessary condition to promoting trade, to promoting investor confidence, and even locally. And if you think about it, over dinner last night, one of my Indian lawyer friends showed me a study that said that if you did not file an extra case here in India, you would need about 200 to 300 years to resolve the backlog. Now, this is not a criticism of the Indian judiciary or its judges who work very, very hard. It is this study that came out that many Indian lawyers are aware of. I don't know the parameters of their study. I don't know the metrics. I don't think that's correct. It might be an over-exaggeration. But the truth is, I know my Indian lawyer friends here are hugely busy doing domestic arbitration because that's a faster route for even local businesses to get their disputes resolved. So it's a clear condition that you have to have a form of dispute resolution that you can choose if you're going to have faith in getting disputes resolved. It's not that we choose to fight. It's just sometimes, as you know, in parties, in contracts, disputes do take place. And of course, the first thing that happens is parties will try and negotiate it. But when they can't negotiate it out, it ends up with us lawyers trying to resolve it for them. The second point I make is this: what are the necessary ingredients of an effective dispute resolution format or mechanism? You've heard all the speakers speak. The judges have given their views eloquently and eruditely. They are quite simple. You need the system that you choose to be transparent, fair, and neutral. That's so important. Now, it may not sound to be so simple, because there are issues in which we take that certain, perhaps, arbitrators haven't declared their interest fully. And we suspect that maybe they're not so neutral. So when those things happen, you get challenges in the court over the awards. But it is crucial, right? You can't imagine if a judge might have had the scales of justice tipped because he's been approached. You know what I'm referring to. You wouldn't have that. The second aspect is, whatever effective form it is, it has to be robust. By robust, it means that it has to be effective. It has to be binding on the parties. It must stick, in other words, whatever the decision. And the third, it must be enforceable. And again, although these fundamentals are agreed by all of us, but our daily and our work experience tells us that sometimes it is not so simple. There are challenges, there are tactics, strategies employed to slow down things. There are issues of challenges that are unfair, unreal. Awards take a long time to be enforced. And there are international awards being, I'm taking a case here in Singapore that has taken 10 years from the time it was first decided, given in England, and 10 years, and it's been sought to be enforced, and it's still being fought out. These are real issues. The third aspect, of course, in order for it to be effective, is that it must be relatively fast. Again, it's easier said than done, but I'm sure many of you have had experiences where some of your arbitrations have taken 5 to 10 years to finally be resolved. And that's where mediation comes in, because a mediated agreement is ultimately an agreement in which both sides have found a common area, and the chances of them being enforced and carried out is much higher. And so that comes to the third point. Apart from arbitration, we have all heard about mediation, and in a while I will also mention the International Commercial Courts, which is a new creature that's come out in the 21st century, although England has it already in the 19th century. But coming back to mediation, there are a number of things that all of us from our experience know that we need to say. For one, we know that what would be a 3-week arbitration could be resolved if the parties are willing in 1 to 2 days of mediation. A great saving of costs, a saving of stress for the parties, but a drop in the income for counsel. And that may sound scurrilous, but I have to tell you, about 10 years ago or 15 years ago, when in Singapore, a judge who has been commissioned to start the mediation system gathered some top lawyers in Singapore to talk about mediation behind closed doors. One of the Singapore senior lawyers said, but mediation would mean we'll lose our income. Oh, that's a wrong approach to take. That's an ethically wrong and improper thing to do, where counsel puts his own interests ahead of the client's interests. Because we belong to an honorable profession. Our client's interest is paramount. Apart from having to be forthright with the court, our client's interest overrides our personal interests. So earlier in one of those speakers, you heard them say that there has got to be a change of thinking. And one of them is this: counsel must be prepared to tell the client the benefits of having something mediated out. But then on the other aspect, there's a level of education that needs to be given to the public, to the clients, that submitting and considering mediation is not that because we don't believe in the case, the strength of the case. It's not because we think that we're not going to be able to win the case. It's because it is the client's best interest to consider a form of dispute resolution that is faster, cheaper, and more likely to be enforced. So in that sense, mediation has now taken on a level of importance that Singapore sponsored a convention that was first opened to signature only 6 years ago. In August 2019, the Singapore Convention on Mediation was established. Today, there are 22 nations that are signatories to it. Now, if you take your mind back to the New York Convention, that was in 1958, over 170 nations. But they didn't all sign it immediately. They took time. So mediation is going to take its traction amongst the nations of the world, and soon you will have 170 nations signing on to the mediation agreement. And why do they need to sign it? It's because it will enable internationally negotiated settlements through mediation to be enforced in the same way you enforce international arbitration awards or international judgments of the international courts. And that will come. But is with mediation an issue? In a sense, it is entirely up to the parties to be able to reach a point where they are in agreement. It also means giving up certain aspects. Now here, I have to tell you that there is also a matter of difference in culture. When I first went to practice law and we went to Japan, I realized that in Japan in the 80s, the Japanese don't go to courts because it was their culture to always talk things through. Courts and litigation in Japan only caught on in the 20th century, 21st century. But earlier on, Japanese people settled all the disputes. And litigation lawyers were not common. I'm sure Sweta remember that too. But equally, there are certain sort of culture in different places where people are more litigious. It's not proper to name people by race or by nationality, but I think if you go through your own experience, you will know certain areas of the world is given to a little bit more of a, I need my day in court. I need to fight this out. I can't have them trample over me, right? And sometimes it's a question of their ego. Sometimes it's a question of their stubbornness. But it is the duty of counsel to run through for them the rationality of being able to have a quicker, faster, cheaper, and forcible award through mediation. So all the talk about the protocols of MET, ARP, MET, or ARP, MET, or MET, ARP, they are all being worked out, and they're all sensible options. But it is up to us as counsel to educate our clients that that is a good way forward. But some things are not given to mediation always. Some things that in the nature of the fight has to be fought out. And that we as counsel know. It depends on the facts of those cases and the personalities of the clients that are involved. I now want to have a quick word about the international commercial courts, which is, as I say, a new phenomenon, not because that it has never existed. As I said, England had their first commercial court in the 19th century. But in the 21st century, and I'll reel this off to you, the Dubai International Financial, excuse me, the Dubai International Financial Center was established in 2006. The Qatar International Court and Dispute Resolution in 2010. Singapore established ours in 2015, and we have Justice Sikri sitting on it. The Astana, Kazakhstan was established in 2018. The Netherlands Commercial Court 2019. Belgium, Brussels International Business Court 2020. Bahrain, and as you know, your Justice Kaur was invited as one of these panelists, and so is Dr. Pinky Anand. I hope she's here. And she's a panel member on that Bahrain International Commercial Court. And Switzerland is considering having one enacted in 2027 next year. It's a new phenomenon in a sense, as you can see all the countries rushing to it. It has certain attributes different from international arbitration. You don't choose your arbitrators because you don't choose your judges. That, in a way, has its attraction in some sense, but for those in the arbitration world, they say that detract from parties' autonomy. This is not the session to quarrel over who is right. There is also, in a sense, a greater firmness in which directions and orders are given when it is the court. I think you will see that in arbitration, arbitrators tend to be more consensual, more respectful, because the parties pay them to be there. In an international court, you don't really pay the judges to be there. The system pays the judges to be there. You may pay some court hearing fees. So the judges don't feel so beholden to the parties and do come down harder on the parties. So that's a new phenomenon. And through the Hague Convention on the choice of court agreements, as well as bilateral agreements being established, international court awards are being enforced almost in the same way as international arbitration. For Singapore's International Commercial Court, we now have a panel of 26 international judges, and through the Hague Convention, through the bilateral treaties, through the various agreements reached, I think the awards of the Singapore International Commercial Court is enforceable just about in every civilized nation. And that's another form. But I come back to what Sepna said earlier, which I found very attractive. She said the catchword in Singapore now is not to call it alternative dispute resolution to the local courts, but to call it the appropriate dispute resolution. And I think that's right. It is up to us as lawyers to advise our clients. It may not be us dispute lawyers. It is the transactional lawyers that need to know all of this to be able to recommend what goes into the contract. And they are no longer midnight clauses. These dispute resolution clauses are important clauses. Thank you very much.
Thank you, Jimmy. Hearing Singapore experience prompts me to say something since Melody Justice Amanullah is sitting here. A couple of years back, I was chairing one session where Michael Huang was one of the panelists. There, Michael said that in Singapore, if you appear before a court and say that kindly accommodate us for a particular day or a particular week because I have arbitration hearings, courts willingly tell their lawyers, don't worry, we'll have it after those dates. But when it comes to India, when we appear before courts and we say that kindly accommodate, don't have date on that particular day because I have arbitration or that week, generally courts are reluctant and sometimes they get upset, they do not take it in good taste. They say if you want to do arbitration, do it arbitration only, don't come to the court. In UK also, arbitration bar did not become arbitration bar in one day. And even today, a lot of arbitration lawyers are appearing in courts because sometimes if they have done the arbitration, they are requested by the parties to appear before the court as well. So this is one thing we will urge on behalf of arbitration practitioners to Melody Justice Amanullah to send word across the in judiciary that if arbitration lawyers are requesting for accommodation on dates, it will be really great achievement of this ICA conference that this will really help a lot of arbitration lawyers sitting here. So that was one thing I thought I must say.
Hello.
I think I'll respond to that immediately because maybe I'll forget. No, your point is taken. I'll tell you the mindset of a judge. You have to understand what before the judge is the proposition. You ask for time in a case. The ground is arbitration. But normally now in the Supreme Court, before me, more than 3 years on the bench by now, not even one lawyer has made this because I know for sure whoever is the arbitrator, maybe an ex-former judge or whoever, they fix their cases so that it is convenient for the lawyers not to miss their actual litigation time, either it's in the evening or on court holidays. Very rarely they have to accommodate because that request has not come. But coming mainly to the point, as you said, yes, definitely, then you have to understand that before a judge, if arbitration becomes a ground, then it will also be a ground that the lawyer is busy in some other court doing some other litigation. That per se, again, referring it to some reflection on what Jimmy said, that lawyers feel that it is my judicial, I should have everything at my, I will do arbitration also, I will appear in this court also, I will appear in everything. Now, I am a very strong believer that give some space to your colleagues who are more focused. There's work for everyone. And I'll reply to Jimmy's question that he says that I totally agree with him. I'll tell you my experience. It's slight digression, but I think it is important for the audience to know. I'm talking from experience, no bookish knowledge, nothing, all from experience. When I was elevated, there was a group of cases which was really very financially important. Because I was elevated, it had to go to someone else. The client came after 1 month and he told me, just to wish me all the best and sensitive. By the way, I asked him, what happened to that case? I hope you are taking care of it because it's very hotly contested and the stakes are very high. He said, no, sir, I've entrusted that brief to a lawyer. That lawyer was known, but it was quite a middle level. So out of curiosity, I said, you are aware of the seriousness of the issue and for you the stakes are very high. What prompted you? You know what he said? He said, I asked my colleagues, they said, go to him, he will get the matter disposed of in the High Court in 6 months. Not bothered about what would be he knows there's a forum. He wants it to be disposed of within 6 months. Now, time is of essence. Everybody has realized it is better to know your result within 6 months, whatever option is left, so that you give a finality. So that is also to be remembered. It is one of that case got him so many clients and big clients. You dispose it of people, it's a myth that I have to keep holding on, especially the lower courts. It's a myth. The moment you get your matters decided, 10 more will come just because you are a lawyer who promptly gets matters disposed of. Now, you have to change your mindset. You are not in sync with what the client, the litigants feel today, being pressured by litigation. And again, back to your point, Mr. Singh, then that means we have creating a special ground for adjournment. A lawyer, a counsel may be involved as a third or fourth counsel in a litigation. It will be very easy because you know that this is a ground now universally accepted by the courts for adjournment. You just understand the pressure judges are in, the media, one unnecessary adjournment, the other side, yes, if both sides agree, we have absolutely no issues. But if the other side disagrees, if it has been long, if there's an interim, I weigh a lot of factors before acceding or refusing. Normally, I don't refuse, but if these factors are there, long time stay, I have to be fair. My job is having a balanced, level playing field. Nobody has the vaguest of the idea what goes through a judge's mind, what responsibility. You have to sit in the chair to experience. Nobody has the vaguest idea in the entire audience or the intellectuals. What is upon the judge when he is really sitting as a judge? It's very different. You have to appreciate that.
Minutes, what I said was slightly on the point that when dates are being given, not for the adjournment, when dates are being given, suppose court says that 21st of July is the next date. What we say, if I said that kindly have it some other day, day after, because I have a hearing on that day. That is the point I was trying to make.
I am totally with you. In fact, I asked counsel where there is a hearing, a really hearing required, I tell them, you choose your dates. I tell them, both of you decide. I have to come here on all working days. You tell me your convenience. I have no preferences. You decide, but then on that day, you have to be honest before the court. I practice that, and I keep preaching that, and after hearing from you, I'll now propagate it also.
Thank you very much, Mr. Manullah. Now, since James is joining virtually, may I request the organizers to set him up? Oh, hi, James. Hope you can hear me.
Yes, I can hear you. Hopefully you can hear me as well.
Yeah. Good to see you, though virtually. James, so we are running short of time, so I'll quickly ask you about importance of being perceived as a safe seat of arbitration. What are your takes on that? Can you quickly tell us, the audience?
Yes, absolutely. Before I do, let me just thank Mr. Arun Chawla, Mr. Angie Patan, panelists, for not being there in person, but I'm grateful for the opportunity to participate. So I think to address your question specifically, in the context of our panel, being perceived as a safe seat is critical to attracting foreign investment. Right? Nothing interferes now than events in the U.S. As to how important that is. Because when you're perceived as a seat that neither respects the proper tests or that has excessive judicial interference, or where the rule of law, which we heard a lot about in the first panel, is not always respected, it becomes incredibly hard for businesses to predict how things will go, how disputes will be resolved, and what will happen to their investment. So I think being perceived as a safe seat, which you touched upon earlier, a seat that has a strong judiciary, but one that respects its role process of ADR, specifically arbitration, one that will avoid interfering unnecessarily, one that will offer support when it is needed, and one that will help keep the process efficient is really critical. And I would simply point out here that that is something that India has made incredible strides in over the course of my career. When I first started practicing 20 plus years ago now, my first matter in India was a matter in Bhubaneswar that went on for a very long time. Similar to how things would go in any jurisdiction, frankly. But over the course of the time since that matter to now, you have seen an incredible run of pro-arbitration case law come out of the Indian Supreme Court. You've seen much greater confidence in India as a seat, and in the Indian judiciary, and it's incredibly laudable. So much so, in fact, that I think many jurisdictions that are counted as preferred seats around the world, including New York, could take a page from that playbook. So that's a very summary answer, but I think it's the best one I should give.
Thank you very much, James. Now we move on to Sweta. And Sweta, we know we are running out of time, but we need to have your quick insights on how do we make our arbitration ecosystem in India more robust. Kindly share your experiences on that.
Honorable Justice Amanatullah, Mr. Ratan Singh, Jimmy, Ela. Good afternoon, dear friends. James, we are not able to see you, but we can definitely hear you.
Can you bring your mic closer to you?
I think now I'm audible. So the issue that actually is raised is very important. And in the first session that we heard, we realized that there are challenges of arbitration because of which we are looking at mediation as an option. Why have we reached this stage? Where have we gone wrong? And what are the corrective steps that are required to be taken is something that we need to really do an analysis of. I think the first step that we need to understand, and I think I would straight away jump to what I have to say, is if we have to focus on dispute resolution, we have to understand the need of the business. If we look at the stakeholders in the process, we have the lawyers, we have the general counsels, we have the judiciary, we have the arbitrators. I think between these four key pillars rests the whole responsibility of running the dispute resolution process. Now, because the courts are already overburdened, there are almost about 5 crore cases, which is about 50 million cases that are pending in courts. Definitely we need to look at appropriate or alternate dispute resolution mechanism. And that is why we started with focusing on arbitration. From 1940 to 1996, we saw that 1996 Act was more to adapt to the requirement at that point of time. But from 1996 to 2015, there wasn't much progress in terms of legislative amendments. From 2015, we realized where we are going wrong, and we corrected ourselves in 2019 and then in 2021. And we did not stop at that. We now have a 2024 bill as well, which is pending. So which means the legislature is understanding the need for making amends wherever necessary. So that is one step which has been taken into consideration. Why are we still not able to speed ourselves up? And if we look at the pattern in terms of the judgments that we have seen, the judgments when we started in Renu Sagar in 1994, it gave a certain direction to the entire arbitration framework. From there on, I don't know where did we go wrong in Bhatia. And then we further went wrong in Saw Pipes and then in Western Geeko. We started to correct ourselves from Balco, and we have now reached the stage where we are talking about Gayatri Balasamy. I think we have covered a lot of ground so far as the judiciary is concerned. But is that enough? I think where the problem lies is the fact that dispute resolution topic is being discussed only between dispute resolution lawyers. The first person or the set of people who need to understand where the challenges lie is the transaction lawyers. I think Jimmy mentioned about it, but it is the transaction lawyers who actually give us the feeding ground to have disputes which go on forever. Whether it is about change of law, whether it is about governing law, whether it is about force majeure, I think these are some of the very important issues which are left as a boilerplate clauses, never bothered to be understood, and therefore we keep arguing about all of those clauses forever. So I think the first change that we need is with respect to including transaction lawyers in the discussion which is happening with respect to dispute resolution. The second element of the lawyers who actually need to also understand, and it is crafty lawyers who are sitting in this hall, who also find ways and means to find lacunas in the whole agreement, and then try and delay the whole process. Arbitration in today's time, at least I have come across most of the arbitrations getting over in time. Where are we facing the real challenge is when it goes to the court in Section 34. Then it goes to the further concern when it goes for enforcement. I think Eli is going to touch upon enforcement, and I'm not expressing my pain points around enforcement, but there are just way too many. In Section 34, we go on forever. There is no commercial mindset that the judiciary has to understand the requirement of the whole, the ecosystem. And that is where it starts to falter. Then it goes into 37 and then goes up to Supreme Court, and in Supreme Court also sometimes up to curative. So we are not putting an end to the process. And it is not just the judiciary to blame, but also us as lawyers, because we are not putting finality to a process. We are finding ways to identify the lacunas and then to go on forever in that regard. So I think the first category of people who need to understand this concern, and instead of talking always about arbitration, is to ensure that it functions in the manner in which it is envisaged. The second, of course, is the general counsels, because general counsels also need to understand when they are looking at the seat or looking at which are the appropriate jurisdictions or looking at the dispute resolution clause or the institutions that they have to decide on. It is at that point of time also they do not apply their mind. Most of the clauses that are mentioned do not have, institutions still mentioned. I do not understand why, even after so many years of the institutions doing so well, are the general counsels not able to trust the institutions that are functioning? So I think we need to institutionalize arbitration as quickly as possible. The third element is judiciary. I've already spoken about it, and I would not want to go on talking about it, but then there is definitely a need. And this is where probably I think that there is a need for also doing a capability or a capacity building. Because for us, sitting in Delhi and Mumbai, it is much easier to talk about all of this. But if you go further down, maybe just 200 kilometers outside of Delhi or Mumbai, you will see that to be a completely different environment. So I think the need of the hour is to do capacity building. We look at specialists to get into onboarded as a judge. And those specialists who have a specialization in arbitration is then given a criminal roster. So I think our roster system also needs to be relooked. We need to understand how we are able to best utilize those who have a specialization in certain areas of practice. And most important is the arbitrators. This is not a pastime. This is not a part-time exercise. This is a very serious commercial discussion that is happening. The adjudication that has to be done as seriously as you have been doing the matters in court. This is not the civil courts where you have to go on with a civil procedure to be followed. I think that's also where we are faltering, because it just is a never-ending exercise when it comes to arbitrators. So training of the arbitrators is equally important. There has to be some kind of a continued legal education even for the arbitrators. To become an arbitrator, you need to have a certain amount of accreditation, and I think Mr. Ratan Singh mentioned about it. It is a very good exercise that is required to be done. It will be much easier for the lawyers also and for the clients also to be able to identify which are the best arbitrators with respect to certain areas, and then be able to focus on those sectors, expert arbitrators. So I think let's focus more on capacity building at all stages, whether it is lawyers, whether it is judges, whether it is the arbitrators. I think that is going to really bring a paradigm shift that we are looking at in terms of making arbitration or India an arbitration hub as we talk about it, and also focus on the arbitration in the era of globalization. I think that's the real concern for us, and we need to address it as soon as possible. So that's my 2 bits. Thank you so much.
Thank you, Sweta. Just to add to what Sweta said, one thing which if arbitrators will start doing in India, it will immensely help the whole conduct of arbitration system. One, the moment files, pleadings, documents come before the tribunal, they should make efforts to go through them. What happens in India is, typically, in all international arbitration, first day, arbitrators will tell you that, ladies and gentlemen, you should take it that we have gone through the file, we know the records. Somehow we are not doing it in India. Files are opened by the arbitrators at the time of final arguments or maybe at the time of writing up awards. Not good. If you do not know the dispute, you can never be in the control of the proceeding. You can never decide the discovery applications. In cross-examination, you can never get your doubts cleared. You will otherwise just keep correcting the grammars in English. That is not how the cross-examination is meant for. In cross-examination, the tribunal should get their doubts cleared rather than simply observing that whether a particular question is asked in a particular manner or not. So that is one thing I thought I must. Now, we are running short of time, and I am now going to Ila. Ila had said that I have very quick thoughts to say on enforcement. So now heading to Ila on the quick thoughts on enforcement.
Thank you. They were quick to begin with, but given how late we are now, they'll be even quicker. Just very quickly, everybody on the panel has spoken about the challenge of delay. But before I get into that, what do investors want when they're looking to invest in a country? They want a neutral forum. They want enforceability of their awards, and they want to be insulated from the courts. How are we doing in India? What is our report card here? Well, I think our arbitrations are obviously now much quicker. We have many amendments to the Act. We have a lot of pro-enforcement jurisdiction coming from the Supreme Court, which has helped in perception of finality of the award, starting with Vijay Karya, cases which show that they are not going to go and sit on appeal. We have Supreme Court judgment, which even helps us with technical delays and derailment in cases where they say, well, for example, stamp duty is not going to be an incurable defect. We are sort of ahead of the curve in recognizing enforcement of emergency decisions and interim relief. Many jurisdictions haven't done that so far. So that's all our positive scorecard so far. What is the problem? What's the real problem? I feel when we represent our clients? Well, the simple answer is, show me the money. You get the award, we never are able to execute it. We are stuck in court for, people on this panel have spoken about the reasons for the delay, and we all know them. Delay is endemic in our court system. After we get an award, we are back to the same situation as if we had been in a litigation. I have a case where I'm representing a Korean client. We were able to get an award in a Singapore-seated arbitration. In 2 years, we were able to pass it through the courts, get finality there. But it's been 3 years in the Bombay High Court where we haven't been able to get it for a jurisdiction hearing. So we're at that stage. So for the Korean client, it doesn't matter that he got his award very quickly. He hasn't seen his money, and it's not looking like he's going to see it anytime soon. Some decisions, which may have been very specific to the facts of their case, such as DMRC or Gayatri Balaswamy, the problem with those decisions is that they leave a sort of impression or a precedent where parties don't want to accept that their award is final. They will keep on going to the next round, the next round, the next round of challenge in the hope of a modification, or in the hope that, finally it'll get set aside. Especially true, as we all know, for government entities and government sector undertakings who don't want to take that decision to settle. One of the biggest things I tell a party, a foreign client, an investor in India, well, you won this big award, what is the next step? And I will say, well, now settle. Don't wait for this to go through the courts of execution. Now settle, because it's worth it. It's going to save you years in courts in India, and you may not see your money. So settle, discover where the assets of the other party are, try and get some deposit in court, try and get interim relief. And these are the grounds that I think counsel should use more and more, rather than belaboring an already very delayed system and going through the courts and going through that delayed process of enforcement. So was that quick, Ratan?
It is really the quickest amongst all of us. Thank you, Ila. Thank you, ladies and gentlemen. I think we have something to talk about after this session on what all we have spoken. And Melodist Amanullah will have the last words on that.
Thank you so much. It's been really exciting and thought-provoking. 2-3 things on the practical aspect. Mr. Ratan said that judges they have to decide, so they should be experts. I'll slightly deviate from the main path. Point is taken that the person who decides should be really well versed with the facts. He should be an expert. So that may be more applicable to the arbitrator, because now you don't put that conditions to the arbitrator, but in the judge you would want that to be. Basically, 80% of the arbitrators in India, the fact is there, are judges, ex-judges, former judges. So you have to first enforce and see that the person before whom you go, he thrashes out at a very, very deep understanding at that level, so that it is less open to challenge. Once you ensure that, I think a lot of your problems get solved at that stage, because a lot of things comes filtered. Because that person himself is not qualified to be the arbitrator in the sense you would want him to be, typically well-informed and expert on that subject. The result is there are many points which are left open for the courts to consider, or at least give it a thought. They may not ultimately hold, but then it creates time, it takes time, the system suffers, the credibility suffers, the faith suffers, the confidence comes down. So you have to plug the hole at the level of whom the arbitrator is. The other thing is that counsels are representing both the parties before an arbitrator. Rarely it happens that the client himself or herself argues, or the institution through their internal resources. Both sides are advocates. So you have to sensitize your fraternity who is expertising. Now this has become an expert domain of counsels expertising only in arbitration. They have to be more responsible that, look here, frivolously we will not file an appeal. What do you do that? You have to target that. I'm being on a very practical and basic level if these things have to succeed. Otherwise we'll keep holding these sessions, and the result would be, yes, vague area, little bit step forward, baby step forward. That doesn't improve. That doesn't give an impetus to this system. Now coming to the enforceability and finality. I think the moment a client understands that this is will give it a finality, that is the biggest confidence building, and that is for the system, especially the persons who are really administering. And here my specific pointed finger is at the counsel. They are the persons who really control the system. Where to go, what to do, what issues to raise, which forum to choose. It is they who are controlling even the courts. If they approach the court, and before the court, you forget. A judge may be very sensitive, but he cannot be technical. He has to give a hearing to a point which is being raised before him or her. That point, otherwise he is not a judge. So don't blame him. It is your fertility of the mind, the counsel fertility of the mind, who picks a point, who gives it to a judge. As a judge, he will be failing in his oath, in his duty, if he doesn't give it a thought. That may take time because other side it has to go notice. You know the system. And 2 minutes, again digression. Lot of things is said, pendency, judges are under pressure. I'll give you just 2 examples. How judges are absolutely nothing to do with pendency or the piling up of cases. A judge has to sit for certain hours. Is it a complaint that a judge doesn't sit? Rarely. He gives time in 10 cases, he takes up the remaining 10. No judge has a roster which is less than 400, 500 in the lower courts, less than 1,000 in the high court, and here it is totally way out. Everybody wants. That factor is not taken care of. Now, as a judge, can I stop a lawyer from arguing? Yes, what I do stop. I tell him you cannot repeat, you are wasting the time. But do I tell that you don't have that intellect, you are arguing absurd? I don't know, he may say something which would be very relevant. I have to give him that space that in his own way he addresses the court. Is the judge responsible? Probably the answer would be no. So in any view of the matter, it's basically how much you expect a human being to deliver in that 5 hours in those periods where the courts are working. There's absolutely no connection with a judge and a disposal rate. It depends on the bar, how long they want to. I know it is for sure, and everybody knows it's a fact. There are lawyers who are known in the civil courts. They will give you time. A tenant would come, I need 2 years. Okay, done. That is the only. After that, what happens? If you begin with this, how do you expect honesty in the system? How do you expect the honesty to be delivered and conveyed? You have to do some heart soul search. Don't just blame the judges. Then Mr. Jimmy said, transparent, fair and neutral. The moment he says fair and neutral, the role of the judge comes. If a judge is fair and neutral, is he not required to consider the points raised? Who raises the point? It is you who raise the point, the other side. And then you say, no, the judge. The judge is absolutely, and the final word is, in these matters, I've said it another forum, judges are redundant to be called. Don't even call them because they will only show you this side which is a spanner in this. You decided among yourselves, let it not come to a judge. We are the ultimate, we don't need to be sensitized. We are already sensitized. In the overall sensitization, arbitration is a minuscule part of it. A judge being enough sensitized, he knows his responsibility, he knows what is of essence in which case. In limitation matters, in contract matters, time is of essence, nature of the, he's sensitized. But if you raise a point, it is my duty to consider, I am obliged. So better you put your house in order, come to the judge, and then you will be delivered whatever you look for. Thank you.
Just to take clue from what Lord Justice Amanullah said, Lord Justice Amanullah says, put your house in order. Taking clue from this, SCL India, Society of Construction Law India branch was contemplating to have accreditation for construction arbitrators. And they will have to go through mandatory training programs or mandatory orientation program. Now I take a clue from here, we are going to have accreditation program for construction lawyers as well. We are trying to put the house in order, my lords. Thank you very much.
Thank you so much. And another thing, never want or even desire a judge to be brilliant and the master in his field, because then he will not give you a hearing. He should be neutral, he should be open. So brilliance is not a requirement for a judge. Being fully well-versed, then he leaves nothing to argument. He knows he has an opinion, he says, I am the last word, he delivers. He is not a judge. Thank you.
That was indeed a thought-provoking and enriching discussion. On behalf of all of us, I extend our gratitude to the chair for the session, Honorable Justice Amanullah, and to each of the distinguished panelists for sharing their valuable expertise and perspectives. As we conclude, I request the speakers at the dais to please take their seats in the audience, and I request the attendees to kindly be seated. We start with the next sessions shortly. I would request the attendees to stay back. We will, after this session, we'll have the lunch break directly. We don't have a high tea session right now. आपको वहीं देना पड़ेगा, वो वहाँ बैठा हुआ, थर्ड रो उस साइड बैठा हुआ, पुष्कर जी है ना? Welcome back, ladies and gentlemen. It's a pleasure to once again welcome our distinguished guests and valued participants joining us from India and overseas. May I request our honored dignitaries to kindly take their seats on the dais. Thank you, ma'am. Without much ado, it's my privilege to welcome you all to the technical session 3 titled The Future of Arbitration, AI and Legal Technology in the Digital Era. This session seeks to maneuver the imbroglio of an increased volatile global order and how AI and legal technology are transforming arbitration, enhancing efficiency, transparency, and predictability, strengthening investor confidence across borders. Building on the momentum of the previous 2 sessions, we now look forward to a focused and engaging discussion that seeks to highlight key challenges, emerging trends, and the best practices in leveraging AI and legal technology within the ADR spectrum. Without further delay, it gives me great pleasure to invite Mr. Arun Chawla, DG ICA and former DG FICCI, to kindly welcome the chair on behalf of Indian Council of Arbitration.
Ladies and gentlemen, we will now delve into the much-awaited session focused on the future of arbitration, AI and legal technology in the digital era. It's a distinct honor to have Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, chairing this session. Justice Mishra have had an illustrious career, having co-authored landmark judgments spanning a wide spectrum of legal domains, from commercial and environmental matters to constitutional and criminal law. His comprehensive engagements lend his perspectives rare depth and width, making it specifically relevant to today's discourse on building a resilient arbitration and mediation ecosystem in India. Many of us also had the privilege of hearing him as the chief guest at the IC Symposium in September last year, where his insights deeply enriched the discussion on arbitration and dispute resolution. Before we invite him to deliver his keynote, may I request Dr. N.G. Khitan, President IC and Senior Partner Khitan & Company, to felicitate Justice Mishra with a green certificate, a pledge by the ICA to plant a thicket of 8 trees at a facility in Ayodhya, Uttar Pradesh. Mr. Khitan. I now invite Justice Mishra to deliver his keynote.
Dear friend Mr. Chawla, Mr. Khitan, the legends of ICA, Mr. Ganesh Chandru, the partner, Dispute Resolution Practice, Dua Associates, India. Dr. Mark D. Wade, International Arbitration Practice, partner, La Live, Switzerland. Ms. Olga, she is not here probably. Joining online. Ms. Olga Boltenko, founder and partner, Boltenko Arbiters, Russia and Hong Kong. She has joined us online. Ms. Mehak Oberoi, Head Legal, G. Varnova, Hydro APAC. I am told she is a prolific speaker. Mr. Mayank Singh Thakur, Senior Partner and Country Head, Masin, expert in delay as well as quantum. Dear participants, my two law clerks, Nupur and Natasha. Ladies and gentlemen, delighted to be here again in this ICA conference this year. Last year also I was there, as Mr. Chawla informed all of you. With profound gratitude and humility, I stand before you today for sharing with you all my views on the theme, Future of Arbitration, AI and Legal Technology in a Digital Era. I am indeed grateful to Indian Council of Arbitration for giving me this opportunity to share my views on a topic which will determine the future of arbitration landscape of this country and globally as well, and will certainly pave the future of a speedy, cost-effective and efficient way of dispute resolution. As we stand today at a critical juncture in an evolution of dispute resolution, arbitrations, once rooted in community wisdom and later shaped by statutory framework, is now entering a new phase, one driven by algorithms, data, and digital intelligence. In India, the settlement of dispute without court intervention dates back to ancient times. Often family-driven resolutions and collective systems of Panchayati Raj have worked well for centuries in India. Then came the comprehensive step by introduction of this mediation and arbitration in Code of Civil Procedure, which included provisions on arbitration in the second schedule. Later, the Arbitration Act of 1940 consolidated the law, which is now replaced by the Arbitration and Conciliation Act of 1996. In the celebrated judgment of Justice Bhagwati in National Textile Workers Union in 1983, he said, if the law fails to respond to the needs of the changing society, then either it will stifle the growth of the society and choke its progress, or if the society is vigorous enough, it will cast away the law which stands in the way of its growth. Law must therefore constantly be on the move, adapting itself to the fast-changing society and not lag behind. It must shake off the inhibiting legacy of its colonial past and assume a dynamic role in the process of social transformation. It cannot be denied that the modern arbitration landscape is overburdened with complex commercial disputes, voluminous documentation, and cross-border challenges. Hence, artificial intelligence and legal technology in today's era is not merely an innovation, but a necessity. AI is the ability of a computer program or a machine to think and learn. AI thus has the potential to revolutionize the field of online dispute resolution. By utilizing advanced algorithms and machine learning, AI can assist in resolving disputes quickly, efficiently, and fairly. It can also help to reduce the costs and delays associated with traditional dispute resolution methods. AI also lowers error rate compared to humans if properly coded. They have incredible accuracy and speed. It is increasingly being applied in the legal services for various tasks, including conflict management, practice management, contract reviews, legal assistances, etc. AI tools nowadays are used for accurate and efficient legal research in selecting suitable expert counselors, arbitrators to facilitate procedural automation by translating, transcribing, and summarizing evidences, and even drafting complementary parts of legal documents and arbitral awards. Within the realm of alternative dispute resolution, ODR is emerging as the leading dispute resolution tool. ODR represents the combination of modern technology with current ADR techniques. ODR leverages information and communication technology to resolve disputes online without requiring physical presence. ODR is an economical approach since it cuts down costs related to travel and the need for physical venues, allowing disputes to be settled remotely. It is especially useful when parties are in different locations or have difficulty coordinating schedules, as it provides a convenient and efficient way to resolve conflicts. ODR platforms use advanced algorithms to manage administrative work, help in drafting agreements, and improve overall efficiency. The role of judiciary in this evolving landscape is both significant and multifaceted. As guardians of rule of law, courts must ensure that the use of technology in arbitration aligns with constitutional principles and legal standards. At the same time, the judiciary must also embrace innovation and facilitate the adoption of technology where it enhances efficiency and access to justice. In India, we have already witnessed encouraging developments in this regard. To quote a few judgments, in Trimex International versus Vedanta, the Supreme Court affirmed that arbitration agreements concluded via emails or electronic communications are valid and binding, giving legal recognition to online contracting and dispute resolution. In Shakti Bhog Foods, this judgment was reinforced that an online arbitration agreement is valid if it complies with the Information Technology Act, reinforcing the legal standing of digital arbitration. Another benefit of adopting AI and legal technology in the process arbitration can be predictive analysis. Through this process, by analyzing past arbitral awards and judicial decisions, AI systems can provide insights into how similar disputes have been resolved. While such predictions cannot and should not replace judicial or arbitral decisions, they can assist parties in assessing the strengths and weaknesses of their cases. Thus, in turn, may encourage early settlements, thereby reducing the overall burden on the courts. Arbitration cases often involve extensive documentation that requires significant time to review and analyze. AI-powered tools can dramatically reduce the time lawyers spend on document reviews by identifying key arguments, summarizing lengthy materials, and extracting events, people, and entities. AI helps arbitrators work more efficiently by quickly identifying the most relevant evidence, which speeds up the decision-making process and let them concentrate on analyzing arguments and applying legal principles. Rather than manually reviewing large volumes of documents, arbitrators can rely on AI-generated summaries, timelines, and visual maps of relationship to better understand the details and dynamics of a case. Now the challenges, both legal and ethical, are before us. Every innovation brings not only benefits but also unintended consequences. While AI can make arbitration faster and more efficient, it cannot replace human judgment, fairness, and ethical reasoning. I would hence like to mention in brief the legal and ethical challenges that may be faced while integrating AI, legal technology in arbitration. Data privacy and confidentiality is one of the foremost concerns which AI is facing and would be facing in times to come. It is often said that data is the new currency, or as many describe it, the new oil. Highlighting its immense value in today's digital world, confidentiality and data privacy is thus one of the most important aspects of arbitration, since the use of AI can put it at risk if not handled carefully. Arbitration often involves highly confidential business information. Any data breach or misuse can have serious consequences, AI systems also require large amount of data to work effectively, which means important documents may need to be uploaded onto these platforms. This can make clients uneasy as they may not know who have access to their data or how it is being used. Therefore, it is essential to carefully choose the AI tools that follow strict privacy standards and ensure that confidential information remains protected at all times. Then comes the element of lack of human touch. The area of concern that remains if we incorporate AI into arbitration would be a lack of human touch. Arbitration is not just about applying rules. It often involves balancing fairness, equity, and justice. Human judgments thus plays a key role in this, and since AI lacks moral reasoning, it cannot weigh ethical considerations in the same way. As we all know, AI systems follow programmed logic and pass data. They may not adapt well to unique or exceptional situations. Arbitrations often require flexibility and discretion, which comes naturally to humans but can be said to be limited in machines. One of the criticisms of including AI in arbitration process can be lack of explainability. So, for example, AI may prioritize certain documents as relevant but cannot explain why. The other party in such a situation may argue that a particular document was overlooked. This system may tend to create a lack of trust which may deeply hamper the arbitration proceedings. Another aspect which cannot be overlooked is unequal access to technology, which may tend to create an imbalance in arbitration proceedings. For example, large corporations using sophisticated AI for document analysis may gain unfair advantage over smaller firms. There is also the concern of invisible influence. If AI tools are used to assist in drafting arbitral awards or analyzing arguments, their influence may not always be disclosed, which may raise an important question as to whether parties are fully aware of how much of the decision is shaped by human reasoning and how much by machine processing. If this line becomes blurred, transparency will suffer. As we move towards integrating AI into arbitration, we must pause and ask ourselves a crucial question. Are we strengthening the system or unknowingly exposing it to new risks? One of the most pressing concerns is cybersecurity. Arbitration today is no longer confined to physical files and closed rooms. We are increasingly relying on digital platforms, virtual hearings, and cloud-based tools. While this shift brings convenience, it also opens the door to serious vulnerabilities. AI is not only a tool for efficiency, it can also be misused. Cyber criminals, including highly sophisticated actors, can use AI to identify weak points in law firms, servers, or arbitration platforms. There have already been instances where international arbitration institutions have faced cyber attacks. If such systems are compromised, the consequences for confidentiality and trust can be severe. And eventually, it will lead to destruction of trust in AI. Today, AI can generate highly convincing fake documents, emails, and even audio or video recordings, what we call deepfakes. If in an arbitration proceedings where evidence plays a central role, how do we distinguish between what is real and what is artificially created? This raises serious concerns about the authenticity and reliability of digital evidence. In light of challenges we have discussed, the question is not whether we should use AI in arbitration, but how we should use it responsibly. In this regard, India has already taken thoughtful steps Niti Aayog has laid down 7 guiding principles for the responsible use of AI, and I believe these principles can serve as a strong foundation for arbitration as well. The 7 principles are safety and dependability, equality, inclusivity and non-discrimination, privacy and security, transparency, accountability, and the last, protection and reinforcement of positive human values. As we reflect on the growing role of AI and legal technology in arbitration, it becomes clear that while its advantages are significant, they do not come without challenges. The use of AI in managing evidence, for instance, demands that we remain vigilant about the reliability of the technology, the security of sensitive data, and the ethical standards that guide its use. Let me share a recent real-world movement that captures this reality. In a widely discussed incident, lawyers relied on an AI tool for legal research, only to discover later that it had generated entirely fictitious case laws. The embarrassment was not technological, but was human. It reminded the legal community of a simple truth. AI can assist, but it cannot be trusted blindly. History tells us that every technological shift brings hesitation. When computers first entered courtrooms, there was resistance. Today, they are indispensable. AI stands at a similar threshold, but with far greater power, and therefore far greater responsibility. Technology is a useful servant, but a dangerous master. This reminds us that AI must remain a tool in our hands, not something that dictates outcome. In conclusion, the goal is not to choose between human intelligence and artificial intelligence, but to create a partnership where technology enhances human judgment without ever replacing it. We have a pool of talents, humans, that will guide us how we use AI in arbitration and shape the future of AI in arbitration globally and locally. Thank you so much.
Thank you, sir, for your profound and insightful address. Your remarks have laid a thoughtful and intellectually robust foundation for the discussion ahead. At this point, I would request the chair for the session, Justice Mishra, the panelist, Dr. Khaitan and Mr. Chawla to kindly join us on the stage for a ceremonial picture of the session. As we now move to the panel discussion, it is my privilege to introduce the moderator for the session, Mr. Ganesh Chandru, partner, Dua Associates India. We have had the privilege of having Sir at our conferences and his perspectives and expertise, and we're delighted to have him guiding the dialogue today. His experience ensures that the discussion remains both insightful and practically grounded. We welcome you, sir. Joining the distinguished panel are speakers with the extensive global and technical perspectives. Dr. Mark D. White is partner in the international arbitration practice at La Live, Switzerland. Ms. Olga Boltenko, FCI Arb, is founder and partner at Boltenko Arbiters, Russia and Hong Kong. She will appear online as she too unfortunately had faced visa delays. Ms. Mehak Oberoi is head of legal domain at GE Vernova Hydro APAC. Mr. Mayank Singh Thakur is senior partner and country head Maas in India. The session promises to provide profound insights. I request Ganesh sir to take on from here.
Honorable Justice Mishra, dignitaries, arbitrators from all across India, speakers, delegates from across the world who are present here physically, as well as those who are joining us through live stream. I think many of you may know that all our members who are not able to be here are watching this on live stream. In fact, yesterday there was an equal number of delegates on the other room. So congratulations to ICA for making this very popular. And thank you, sir, Mr. Kaitan, Mr. Arun Chawla, and their team for inviting me to be part of this wonderful conference, I should say, international conference. Good afternoon to all of you. I wish to start by quoting from a famous speech that was delivered on the eve of our independence. Long years ago, we made a tryst with destiny, and now the time comes when we shall redeem our pledge, not wholly or in full measure, but very substantially. At the stroke of the midnight hour when the world sleeps, India will awake to life and freedom. India has not just awoken to life and freedom, ladies and gentlemen, but has made great strides over the past 78 years in almost every possible area, including in the area of technology. We recently had the AI Impact Summit in Delhi at the Bharat Mandapam, very high-profile event in February this year. While welcoming the delegates, our Honorable Prime Minister stated that the AI Impact Summit was being held in India, a nation that represents 1/6 of humanity, which is home to the world's largest youth population, the biggest pool of tech talent, and one of the most expansive tech-enabled ecosystems. He said that India not only creates new technologies, but also adopts them at an unprecedented pace. This unprecedented pace, in which technology has pervaded all our lives in the last decade, and the effect of artificial intelligence over the last few years, is mind-boggling, but also very worrying sometimes. Like all other fields, the impact of technology and AI in the legal arena, especially in the field of dispute resolution and arbitration, has been significant. Honorable Justice Mishra, in fact, has laid down all the salient aspects of what technology is going to impact arbitration and dispute resolution, and also the 7 mantras that he said, very important for us to reflect on. One aspect I thought I very briefly touch upon is the costs. Everybody is now worried about time and costs in arbitration. So I'll just tell you an anecdote. There was one client who walked into an office of a very prominent lawyer. Ratan is not here. He was talking about 3 questions that were asked to him in Singapore. So he walked into Ratan's office, actually. I wanted him to stay here. And he said, he went into his office, he saw it was very swanky. It was so beautiful, plush sofas, chairs, and all glass work and all that. And he was worried, because the client was worried. Then he asked him, sir, first question he asked him was, what is your fees? He said, 3 questions, 3 lakhs. He was shocked. Then the second thing he asked him, don't you think it is exorbitant? He said, that could be the case, but tell me what your third question is. Right? This, ladies and gentlemen, is the problem really which clients are facing about time and cost. Cost is I think technology and AI can bridge in a great way so that the disputes are resolved in a cost-efficient manner. We are already seeing that happening in a big way. And this technical session will focus on how AI and legal technology in the digital area that we are living in today, arena we are living in today, will shape the future of the arbitral process. We have heard the Honorable Judge's view. We will view this further from the prism of a practicing lawyer from Europe, an arbitrator who will join us online, Olga, an in-house counsel, and an expert. So, eminent panelists, and I would like to first welcome Dr. Mark Waite, partner of Laliv in Switzerland, one of the leading arbitration law firms for international arbitration. He will focus on how the use of AI is shaping the work of legal professionals and counsel in arbitration proceedings. So we have divided this into 4. They have some slides. We'll try and make it, as we are talking about time and cost, hopefully we can finish it on time and this session. So over to you, Mark.
Thank you very much, Ganesh. So, as counsel in international arbitration proceedings, our challenge is to run large cases in an efficient and cost-effective manner and win the case for our clients. So, technology should help us, counsel, to be persuasive and win in an efficient manner. Now, I would like to make this very practical first with you. You've heard a lot about AI and the philosophical parts of it, but let's focus on what tools are available, how can we use them, and how can we use them in each phases of an arbitration. Now, when looking at the phases of an arbitration, I would start with the client or witness meetings. Unfortunately, we don't have the slides up, but
if
someone could
the slides can be projected,
up.
yes,
Thank
it's
you
here,
very
Mark.
much.
Yeah.
So if we start on the left side with the client witness meetings that often start a dispute resolution process or an arbitration process, the tool that helped me most over the last, I would say, 12 months or so is an AI-based note taker. I have one example here. It's Plod AI. There are others out there. They're great tools, little devices that will record the discussion that you have with a client, a witness, and will transcribe it, and more importantly, summarize the important points that you need for witness statements, for instance, when drafting witness statements. And what is even better, even when you change topics in your discussions going back and forth, these AI tools are able to group them in a meaningful way. So you don't need to have a dedicated note taker in the team anymore, or that dedicated note taker can now focus on more productive tasks. A huge cost saving for clients. Now, moving to the drafting stage, where we're drafting submissions as counsel, I'd like to talk about essentially two tools that I've been using significantly over the last few months. One is Exhibit Manager for finding evidence and creating chronologies and then hyperlinked e-briefs, which make it very easy for arbitrators to easily navigate the submissions and the voluminous facts in a specifically document-heavy or fact-heavy case. And then let me discuss briefly a tool I've been using a lot, which is Microsoft Copilot. There are others out there, but Microsoft Copilot has been particularly effective in improving first drafts that I've received by lawyers who maybe are not non-native English speakers, or maybe have come with a background and have predominantly worked in state court litigations where they are using much of their jargon and ways to express themselves that may seem a bit off at times in truly international arbitration matters. So it typically in the past took significant time for me or my partners to revise and edit these drafts to a level that is expected in international arbitration. Improving the drafting here with AI helps leveling the playing field. Now, yes, there are risks, obviously, that come with the use of AI or Copilot in improving the drafts. So you have to be very careful with how you prompt Copilot or the LLM to avoid it becoming obvious that you have been using AI to improve your draft. AI uses quite often very predictable rhetorical patterns that can make it become obvious quite quickly that you have been using the help of a machine to improve your drafts. Also, it is not a substitute for careful and structured thinking and analysis. So if you ask Copilot to improve rubbish, you will simply get beautifully looking and polished rubbish back. Now, the next phase, the document production phase, I will leave to Mr. Thakur. The e-discovery tools have been using statistical methods like predictive coding for a long time. And I will move over to the topic or the phase, at least which I cherish most, but I think most of the advocates in the room are really thriving at that moment, which is the hearing. Now, preparing opening statements and cross-examination outlines involve deep dives into the evidence on record. And as an advocate, I have to review and analyze the case record in detail. And this is an area where I find the most exciting use case for AI in Exhibit Manager or other tools. And because I've been using that tool to create test arguments, create cross-examination outlines, anticipate counter-arguments, which I think is even more important than developing your own arguments that you test and find the best counter-arguments, which we sometimes may get a bit blind when we believe our case too much. And then during the cross-examination itself, the team uses these tools to fact-check answers that are coming, which is also very useful. And the beauty of these tools is that it automatically bases the answers on the complete record of the case that is before the tribunal, and you don't have to upload your evidence and submissions to another platform. Now, as with any new technology that becomes relevant for arbitration, regulators in the wider sense are very quick to shout for clear regulations or at least guidelines in the form of soft law. And we've heard this this morning or earlier from Justice Mishra as well. So some institutions have already issued guidance for the use of AI, and many are to follow. And as a member of the ICC task force on the use of AI in international arbitration, I'm somewhat guilty of this movement as well. Now, however, I would caution against getting too prescriptive at this early stage in the process. Yes, I do see the need for some regulation as to how arbitrators should use the technology. If I wanted to boil down the use of AI by arbitrators to one principle, it is that you may use the technology in the same way as you would use an arbitral secretary. Certain tasks can be delegated, but the arbitrator ultimately retains the responsibility for the decision-making process and the award rendered. Now, there are differences in the room, and many of them are culturally, that on what we think is appropriate for secretaries to do. And we are not going to solve this here, but in one of my arbitrators, I thought it would be an interesting experiment to load the case file onto Exhibit Manager and ask AI to summarize one of the parties' position on a certain topic in a clear and concise manner with reference to the relevant evidence. And I was shocked and embarrassed how I better understood the points made by that party. And I immediately stopped the whole process. I found it unfair and inappropriate. You may disagree with me, but in my view, it is for the parties and not for the arbitrators to crystallize the best arguments. Predictability and transparency of the process, I think, is key. Now, if we come to counsel work, very, very briefly, I would say hands off to the regulators. It is essentially for the counsel and their clients to decide how to structure their legal team and the technology used. Typically, I hear two counter-arguments against that approach, and I'm sure you will think the same. Equality of arms and preventing hallucinations on cases that have been made up in submissions by generated by AI. So let me take these two arguments in turn. There is no inequality of arms in international arbitration or litigation for that matter. Let's face it, some teams are better than others. Some parties may have more money to spare for their defense. And I'm not going to warn my opponent if I'm using my star associate on the team on this case. Why should I warn my opponent that I'm using this cutting-edge technology? Second, on hallucinations. We hear horror stories, and Justice Mishra has pointed them as well with hallucinated references to cases, etc. This is not an AI-specific problem. If we rely on the research of an incompetent associate, the outcome is equally embarrassing. It is our responsibility as advocates to check what we are using. If we are using unreliable sources, that's our problem, not the technology's problem. Now, very, very briefly, before I end this, what will the future bring? We will see a significant improvement of the reasoning capabilities of these tools. I could go into the technical details, but that's where everyone is working on, improving reasoning. Now, what does this mean for us as a profession? Is legal tech going to complement our work, or will it be replacing work of counsel? And it's, you know, there are legal tech companies out there who are trying to position themselves as law firms, and we need to keep that in mind. Personally, I would favor a slightly different approach, because I think data processing will never replace judgment, what we call judgment. And AI, even in more sophisticated ways, and even if these AI models learn more in reasoning, will always be data processing. And there is some element of human judgment that, at least in my view, cannot be replaced in the decision-making process. We have to be mindful of that and use the technology, I think, as complement rather than replacement for what we are doing. And with that, I'm going to end. Thank you very much.
Thank you, Mark, for that. Covering all the aspects in a very, succinct manner. Next, we move on to Ms. Olga Boltenko. She'll give the perspective from that of an arbitrator as well as a practitioner. She's a founder and partner of Boltenko Arbiters, based both in Russia and Hong Kong. She's going to join us virtually, and she's going to talk about virtual hearings, what platforms can be used, what are the legal issues that may arise. Over to you, Olga.
Thank you very much, Ganesh, and good afternoon, ladies and gentlemen. I'm zooming in virtually from Hong Kong, and so first things first, at any virtual hearing or meeting, can I please check whether you can see and hear me?
Yes, we can. Yeah.
Excellent. Well, given that technical glitches do still impact virtual hearings around the world, this is a brilliant start to my virtual intervention from Hong Kong on virtual hearings. Thank you very much, Ganesh, for the opening remarks and for the introduction. And I'd also like to extend gratitude to Honorable Justice Mishra for the welcome remarks that I find very illuminating and setting out the ground for our discussion here. I'd like to also thank the esteemed audience whose undivided attention I'll have for the next, hopefully 7 or less minutes. I'm very grateful to Mr. Arun Chawla and his team for the organization of this event and also for the invitation. But I cannot express in words how much I regret not being able to be there in New Delhi in person. However, that is perhaps quite appropriate for me to appear virtually, given that I'm tasked to speak about virtual hearings. I do invite with that many of the dear friends in the audience to reach out to me if your business takes you to Hong Kong or to Singapore, and we can then have an in-person meeting. Ganesh has tasked me to utilize my time wisely and to speak on 2 main issues that pertain to virtual hearings. The first is the platforms used for virtual hearings, and the second issue is any legal challenges and complications that arise as a result of the usage of the virtual go to the bar in Hong Kong, and I do maintain an arbitrary attendance in Singapore. So in my brief remarks, I will be referring to mostly Hong Kong and Singapore practice, and the Indian practice to the extent that I'm familiar with that. We'll set the definitions first. Virtual hearing, and that's not a contested, I believe, definition, is also known as a remote hearing or online courts when it comes to litigation. A virtual hearing is a legal proceeding where participants, be it judges or party representatives or witnesses, litigants, appear via an audio-visual technology or online, rather than physically. Virtual hearings, as all of you in the audience would know, have accelerated tremendously during the COVID pandemic. But since then, they have become quite a permanent fixture for arbitration hearings, but also for court hearings and a lot of civil matters, administrative matters, but even for some non-trial criminal proceedings, at least here in Hong Kong. So dealing with the first issue, which is platforms used in virtual hearings, I should say that the platforms differ significantly depending on whether those are court hearings or arbitral hearings. The court hearings usually mandate the platforms that are designed and dedicated for court-specific usage. They ensure a confidentiality and cybersecurity for the litigants appearing before the judges online. And those platforms are typically regulated quite significantly on the statutory level, including in Hong Kong and Singapore and many other common law jurisdictions, in India as well. And they are also recorded in the rules of courts. For example, in Hong Kong, the court's remote hearing ordinance came into effect in 2025, and it requires for a party that seeks a virtual hearing to make an application to the judge, and the judge will then decide whether a virtual hearing can be held. The ordinance itself sets out over 16 non-exhaustive grounds for which a virtual hearing may be requested, including the nature and complexity and the urgency of the proceedings, the views of the parties, the ability of the parties to engage and follow the proceedings, and that's bringing us to the discussion of technical capabilities of the parties, the maintenance of the rights of the parties, whether the parties are legally represented, and many other such issues, which are relevant specifically for example, for Hong Kong seated arbitrations, where party representatives may actually draw inspiration from this ordinance in order to request a virtual hearing. Other jurisdictions have very similar provisions. For example, in Singapore, hearings are commonly, online hearings are commonly used in the court system. In the UK as well, Australia, virtual courtrooms, as they're known, are in operation across the entire country. BVI as well quite frequently uses virtual hearings. And I understand that in India as well, as most, all of you, I believe in the audience would know, virtual hearings are fully operational, legally valid through the e-courts project by the Supreme Court of India e-committee. When it comes to arbitration, though, virtual hearings are even more common, although perhaps less regulated, being sort of wild west of virtual arbitrations. Here, the guidelines would be those issued by the arbitral institutions that deal with how virtual hearings are to be conducted. And most arbitral institutions, as you know, have such guidelines. Those guidelines are soft law. They're as opposed to statutory regulations that we have when it comes to court virtual hearings. They're open for the parties to adopt and for the tribunals to include, for example, in procedural order number 1 or otherwise. The inclusion of virtual hearings and the usage of artificial intelligence during the hearings can be quite controversial, though, because in some jurisdictions there are limits on how much artificial intelligence can be used during the hearings, specifically when it comes to enforceability of the future award and the ability of the party to reasonably present its case. The HKIC, for example, has issued a very comprehensive guidelines on the use of virtual hearings in international arbitration. So did the Singapore International Commercial Court and many other institutions around the world. Other than that, those institutions institutions also offer specialized dedicated platforms for the virtual hearings. But in addition to that, many parties, as a lot of you would have participated in those as well, would use Zoom for virtual hearings, Microsoft Teams, WebEx, other platforms, in addition to using dedicated hearing managers and electronic bundle managers such as Opus 2 and Epic that sort of created the entire industry of virtual hearing managers. Now, in concluding my first point, virtual hearings are firmly the reality of contemporary dispute resolution, and the benefits of virtual hearings are absolutely tremendous. It's first of all the efficiency. As you know, a lot of the senior busy arbitrators will find it very difficult to schedule a quick case management conference or even a short hearing given their busy schedule, especially if that requires international travel. Online hearing would allow for those to happen without that much difficulty. Another advantage of virtual hearing would be reduced cost. Imagine having to fly 3 senior busy arbitrators to a hearing venue ahead of time, first class, booking a convenient hotel for them, paying all their daily expenses, and flying them back out to their home jurisdictions, in addition to having counsel team attending the hearings and clients as well. All that cost is tremendous compared to the savings that virtual hearings can actually bring. Another advantage would be working on sanctions-related arbitrations. And as a Russian national, I'm very intimately familiar with that. Specifically where counsel from sanctioned jurisdictions are simply unable to even obtain visas to attend an in-person hearing in certain jurisdictions, which would make it quite unjust and unfair process where the other side can actually attend the hearing in person before the tribunals. Now on the AI-assisted virtual hearings and the advantages that that can bring to the arbitral process, there the opportunities are absolutely limitless. It highlights what the AI can do, and that sort of echoes what Honorable Justice Mishra noted in his welcome remarks, but also what Mark said earlier today about the use of AI. For the AI-assisted virtual hearings, you can have a transcript being created without the need of an actual court reporter. You can have simultaneous transcribed interpretation, for example. You can have summaries of the hearings and of the witness statements, so the dispenses of the tribunal secretaries, unfortunately. You can actually counsel, maybe able to prepare post-hearing briefs relatively fast, just having to feed the transcripts to the AI, and many other absolutely tremendous time and cost-saving advantages. That comes with a massive caution though, because the AI, or as we I assume are talking about the large language models in this case, is absolutely flawed. It is not at the stage yet where it can perform all of these wonderful functions without human supervision. For example, transcription by AI, especially in hearings where counsel and arbitrators speak in different accents, as they always do in international arbitration, making it difficult for the AI to transcribe accurately the hearing proceedings. Something that Mark also mentioned in terms of summaries, timelines, and other such issues. It really depends on how well the arguments are drafted by the parties. And Mark, I believe, called it garbage in, garbage out. The AI may not always be able to decipher a badly drafted argument, summarizing it in a beautiful way that makes it look like it's actually accurate, but in fact it isn't. So without human supervision, AI is very dangerous and it's prone to mistakes. And now looking at the time, I'm on to my second point, and those are legal challenges. Despite all these wonderful advantages of virtual hearings, AI-assisted virtual hearings in particular, they are at the very least 6 legal challenges and technical challenges as we know them in virtual hearings at the moment. First is due process and fairness. Concerns specifically exist regarding a party's right to represent fully and reasonably their case, the equal treatment, and the potential for diminished ability to properly cross-examine in the case of virtual hearings. Witness credibility, hard to assess during virtual hearings, and security and confidentiality can always be a concern. Witness tampering, where there's nobody in the room where a witness is supposed to testifying online, there's a wide opportunity to tamper with, but also technical disparity and time zone constraints. Now with that, looking at the time, I will conclude my second point with brief statistics, and that is the institutional statistics do show across Asia and globally that virtual hearings are on the rise. They're here to stay. I'm quite impressed with the Indian judges embracing artificial intelligence, having listened to the presentations earlier today. And what we can do as counsel is catch up and stay relevant. Thank you very much.
Thank you, Olga, for that amazing presentation. Just one point I would like to add. Of course, when it comes to virtual hearing, we can have a separate session altogether on that. One thing is very important to have a virtual hearing protocol, which is the IBA guidelines on taking of evidence in international arbitration 2020 in Article 8.3 recommends that it's good to have a hearing protocol, and before the hearing you do the testing. And this is exactly what, Olga, you very rightly pointed out about witness tampering, how you're going to do all this. It's nice to have a case management kind of a hearing where all this should be sorted out and parties should agree on it. And I think that is very important, and we also do that in India now. Even for virtual hearings, we do have this protocol being exchanged between parties. Thank you so much for bringing the international perspective, and I'm sure you're going to stay on for the rest of the session and the other sessions as well. Thank you so much, Olga. Moving on, yeah. Can we give a round of applause for her? Thank you. We have heard from the counsel, we have heard from an arbitrator, now the most important person, the client. So the in-house counsel. So Mehak is here, Ms. Mehak Oberoi. She head of legal of GE Vernova's hydro business in Asia Pacific. She also plays a very important part in the Society of Construction Law in India, and a very good speaker. She'll give us a perspective of an in-house counsel on how technology has pervaded the entire arbitral process. Over to you, Mehak. And if you can have her slides, I think, so that we can finish timely. Yeah.
Okay, good afternoon, everyone. I'm very cognizant of the fact that we're keeping you away from lunch, so I'm going to try to keep this as short as possible. So I think I want to start with So I'm going to start with a small confession. I think there definitely was a time when the moment a dispute surfaced, you picked up the phone, you called your external counsel, you gave whatever data you had to them, and then you just sat and waited for the very long email to come with a longer invoice. But I think that shift now is taking place, and I don't think it's been overnight. I don't think it's dramatic, but there is a shift that's taking place. Whether it is where the control really lies now, how the costs are being reshaped, and what risk actually looks like in an arbitral process in today's technology-related world. So I think from an in-house counsel's lens, if you look at control, I think the control is now coming back in-house. Now, when I say that, it doesn't mean that the external counsel has become less relevant. They absolutely have not. What has happened is that your information asymmetry has reduced. So earlier, I was relying on someone outside of my company to build the narrative for me and tell me my story. Now, I have the tools in-house, whether it is contract analysis or AI-assisted tools for reviewing trackers, I have all of that. So I know my story. So when I'm coming to you as an external counsel, by the time I'm there, 60% of my strategy is already in place. So what I'm looking for is someone to amplify my strategy. So if you're there to help me with volume or with efficiency, that work has gone away. So why I need external counsel now is, and why external counsel is still relevant to me is, if they can amplify the strategy that I'm trying to make. So that's where the shift is coming back in-house, because my dependency on the number of things for a particular matter have reduced. The matters are still relevant for which I rely on the external counsel, but they're not as much in number. Now, when we talk about control, it does not, the control shifting in-house, it doesn't mean that the cost is disappearing. I think it's just being redistributed at this point in time. So when I say that we're using technology in arbitration, and yes, it makes preparation of arbitration faster, but I do not think it is still making it cheaper to run right now. We may get to that point at some point in time, but right now it is not it. So how, okay, I've lost my chain of thought. Yeah, so with external counsels, earlier there were manual reviews, right, of contracts, etc., like I was discussing in the previous part of it also. Now all of that is being done in-house. So maybe my invoice from the external counsel will reduce to that extent, but that invoice is still landing somewhere where it's just harder to quantify. So I have to build capability in-house. I need to purchase AI tools in-house. I need document management tools in-house. And I need people to be able to understand this technology, to be able to use this technology efficiently, and understand the nuances of it to ensure that you get an accurate result. So the in-house cost that I'm bearing now has increased, but I am unable to quantify it, or at least not precisely, right? So it's become a hidden layer, even though the external counsel cost to some extent would be reduced. So I think we're at the stage of redistribution. It's going to take us a while to see the actual cost reduction as well. The last point would be of data. Data is power, yes, but data is also exposure. Now we are at a stage where everything in my data is searchable, retrievable, producible. So I'm not only arguing my own case, I'm also explaining my own history. So now things are so easily, within seconds, discoverable that it's so important for you to know the story that you're trying to build at that point in time. Was it discoverable before AI? Yes, but it wasn't always discovered. Why? Because possibly it was too expensive to chase. Possibly it was buried in thousands and thousands of folders of documentation, but now it's going to surface in minutes. Not only is it going to surface, it's also going to do a pattern mapping across 10 other documents and may end up telling you a story you possibly did not want to tell, or maybe you possibly did not know yourself. So that's why data becomes an asset and a liability both as far as technology is concerned. So we need to be more mindful, and just saying that nothing harmful exists in silos is no more a benchmark. It has to be that there is nothing contradictory anywhere on record. And now that is a much higher threshold to meet in reality. So I think to sum it up, the impact is that the control has shifted, I think for the better. I think the cost has been redistributed, not reduced yet. And I think data has become an asset and a liability both. So I think everyone has been talking about the fact that human judgment cannot be replaced, and I completely agree with that. But I'm also very mindful that the good lawyers and the ones who are prepared are going to become more relevant, and the ones who are not prepared are going to become more visible. So it's very important for us to upskill ourselves, because that is the only way we will survive in this fraternity. Thank you.
Hello, check. Thank you, Mahek, for that, for saying that still external counsel are relevant, because all of us otherwise would have been quite perturbed. But one thing, I see a lot of young lawyers here today. One angle about AI and how it can, especially legal research, drafting, many aspects of this can be done now by technology. So, but I feel in dispute resolution, especially litigation and arbitration, the advocacy, conducting a trial, making an argument before the court or before the arbitrator, that I think it's going to take, some more time for some technology to replace that. So therefore, I would encourage a lot of youngsters to specialize in dispute resolution. Especially many of you want to go to corporate. I'm not saying corporate work is bad, but litigation definitely, and arbitration, the advocacy part, in my view, is not going to be easily replaced by technology or AI. With that, the most important aspect in arbitration these days, especially for big ticket arbitrations, construction infrastructure projects, matters where financial issues are involved, expert testimony is extremely important. We are very privileged to have Mr. Mayank Singh Thakur, a senior partner and country head of Masin India. And Mayank, if you can throw some light on the tools that an expert witness can use, what you need to avoid, and also very briefly touch with e-discovery and document management, that'll be excellent. Mayank, over to you.
Hello. Yeah. Thank you, Mr. Chandru. So we have heard Honorable Justice Mishra. We have heard an arbitration lawyer, an arbitrator, in-house counsel. So definitely we have got great insights. I just want to throw light from an expert's perspective. So AI is a reality. So let me begin with, can I have the slides, please? Yeah.
Mr. Mayank's slides, can you just put it up?
The device. Is there a device? So let me begin with the statement. The question is no longer whether to use AI or not. What we have to answer now as an expert, how to use it. How to use it without compromising your credibility, your independence, and definitely professional standing. So we have experts in forensics, technical, and economists. So we have to be very careful while using AI, but we can't fall behind. I mean, it's a technology which has come up, and we have to use it because we are working on timelines and deadlines which are really impractical these days. So without usage of AI, it really becomes difficult. But how to use and how much to use, that we'll talk. So, as I said, it is used at various stages of the arbitration, and we can actually use it for primary purposes, basically the documentation, the organizing our reports, organizing the mandate we have. And definitely one thing we have to keep in mind, it cannot replace the expertise. Say a delay expert, a quantum expert, a forensic expert, he has to put his brain after getting certain AI outputs. How and where it has to be used, that's a question which every expert has to answer to himself. The most important thing, Mark also said that I should cover it, the document review and e-discovery. Now what we are dealing here with is voluminous documentation. Now I was in an arbitration, it was between a private contractor and a public sector organization. And the claimant's pleadings were of 56,000 pages to be very specific. I was dealing with such, and then there were respondents' pleadings. In this way, I was dealing with 150 delay events. I was a delay expert in that matter. So just to segregate the documents for each in every delay event, if I would have put 3 people, 4 people from my team, they would have taken months. AI helped me to do it in 15 days. So I was able to meet the submission deadlines. So basically document clustering and relevance is something important where AI can help. E-discovery. So we find, especially in international arbitrations, that the documents, especially where we are having the expert report going along with SOC, memorial style pleadings. Generally, claimants give us access to their server. And then from those servers, because all the documents are electronically stored, if there is no AI, going through each and every document electronically is also a Herculean task. So that is very important to use AI there. And the most important thing is, experts may use AI for efficiency. They cannot use AI for decision making. Basically, there has to be a manual intervention, which document to be relied upon, which document should not be relied upon. Only document segregation and extraction can be done through AI. Drafting, yes, it helps in drafting, but only the language part of it. It cannot help you in data analysis. You can do summarization, it can give you the structural support, but it cannot give you the, I'm trying to go through quickly because I know I'm keeping everybody away from lunch. So it can be used in drafting and language usage, but it cannot be used in the analysis of the data. Basically, drafting helps you in improve the clarity, and also it can carefully be used as an editor to the reports, where you can sort out mistakes which are made through manual typing. Now, when we are dealing with large financial data and large documentation, yes, so it can be used as an extraction tool for analysis, where it can pull out the financial records. We generally deal with huge financial records when we are dealing with delays of 5 years and 6 years. And for prolongation cost, we have ledger which goes in thousands and millions of entries. There, it is easier to segregate the ledger in various cost heads, which simplifies the work at a later stage of analysis. Of course, virtual hearing, we have all talked about a lot on virtual hearings and transcription, so I would not want to comment. Chronology and case mapping. So I'll give you an example. So there was a huge delay in a particular project that was placed in Mauritius because of weather conditions. And both contractor and the owner, they were writing to each other and blaming each other for such delays, that the work was delayed due to weather. Now I'm dealing with letters ranging 2,000, 3,000 letters only on weather. And that has been segregated with all other communications into the server. So I simply gave a prompt to AI. Please provide me chronology of rainfall from so-and-so folder from the server. And in a matter of 15 minutes, I got a chronology related to rainfall. So I exactly knew what was the rainfall, when it happened, and how much it would have affected, because definitely there were norms, how much of rainfall will affect the work. So this is how the case mapping and chronology can be helpful by usage of AI. Now, the most important thing, the risk of using AI. The first risk is compromising expert independence and credibility. So without going into details, there is an international arbitration judgment where a particular report from an expert was discredited by the tribunal because of excessive usage of AI. So definitely expert credibility on risk. So the documentation, data extraction can be done. But the analysis, if I am doing a delay analysis and maybe a AP/AB analysis or time slice windows analysis, the analysis has to be done in a human way, manually. You cannot ask system or AI platform to give it to you. Similarly, if I'm extracting cost, I can segregate cost when I'm a quantum expert. But whether the substantiation of that particular cost is to be checked, that has to be done manually. And whatever exercise is being done through AI, there has to be a manual check to it as well. So this is the first risk which generally face. So these are the common tools which can be used, acceptable uses of AI as an expert, which we generally do. And why it is? Because it improves efficiency, but it does not generate opinions. Of course, opinions should not be generated by AI. Opinion should be individual's opinion. And final conclusion, of course, should remain with the expert. But where is the concern arises? So when the opinions are generated, then it is a very difficult position. Then your credibility is at risk. And once credibility lost as an expert, it's very difficult to get it back. Second biggest problem is hallucination. Somebody has spoken about AI hallucination. I remember we were looking for a reference for a particular matter, and a generic AI platform gave us a case number, the claimant's name, the respondent, it was a court matter, so both sides' names were there, and the case number was also there. We went and checked it, there was no such case. And it named a very prominent construction contractor and government company. So AI may give incorrect information. So one should be very careful and should not fall trap into the AI hallucination. Because the output looks authoritative, very authoritative. But when you do your background research, you are in trouble. So that background research is very much required. As I said, impact on credibility is very important, because all these things, if you are not very careful and you have not done your homework well, there were incorrect assumptions, fabricated references, falling trap into hallucination, that will definitely take you to a wrong opinion, and you will be giving up a wrong report. And then, of course, cross-examinations, they are difficult. People sitting here on my right and in the audience have cross-examined me, and trust me, these are tough guys to face. So, it is always good to be well prepared. And then second most important is disclosure. Okay, these are a few principles which are practical safeguards for an expert to do. Then there is a mandatory human verification, we have talked about it. The most important thing is disclosure. So whenever I write a report, and I have used AI to a certain level, I disclose that in my report. It is very, very simple. The statement has to be there. And it say that the AI-assisted tools were used for the literature search and document analysis. All conclusions and opinions are independently formed by the expert. So here you're disclosing that there was a usage of AI while preparing the report, but not for the opinions. And there should and once you say that, definitely you will decrease one question in cross-examination. So just to summarize whatever I've said, what is permitted, what is used with the caution, what should be prohibited, I've tried to summarize it here. Core takeaway, technology can assist expertise but cannot replace the responsibility. AI does not change the expert's duty. Of course it does not. The opinion always belongs to the expert. So with this, I would want to conclude, and thank you so much, ICA, for considering me for this.
Thank you, Mayank. Yeah, one thing you said, AI will not replace. The same with lawyers as well. I'm sure technology and AI is not going to replace lawyers, but remember, lawyers who do not know how to use technology, there's a good chance that you could be replaced. So it's important for us to know how to use technology and AI. With that, we come to the end. But before that, just a very quick closing, because we have the Honorable Judge here, and we should hear from him after he has heard all this. He gave an excellent opening, and if you can say a few words, sir.
We have a brainstorming session, and all the stakeholders in the whole process, they have formed this panel. On the one hand, Mr. Mark, a counsel doing arbitration work mainly. Then we have heard Ms. Olga from Hong Kong, who is a arbitrator in virtual hearing, basically doing. Then Mahak, an in-house counsel, and then Mr. Mayank Singh, an expert witness in delay in quantum. And we have heard the inputs from all these stakeholders, we may call it, because it's a whole process with which we are, for which we are discussing and looking forward the way to save the AI for arbitration or in arbitration. And having heard all of them, what I wonder really is whether AI is making the job of a judge whether easy or difficult. Because at the end of it, this arbitration, after they do all this exercise with the help of AI, and eventually the decision, the award, lands in the court by one or the other party. So having done all this exercise through experts, AI, machine, brain, etc., at the end of it, when it lands in court, I was just thinking, when it lands in my court, what I will do. Whether I will also use AI so that AI kills the AI, or AI enhances the AI. And eventually, whether it is human which will dominate the AI or the AI will dominate the human. And my conclusion is, at the end of the day, it is the humans which will control the AI, which will guide the AI, and which will decide which way the AI should go in future. Thank you so much.
That was indeed a thought-provoking and enriching discussion. On behalf of all of us, I extend our gratitude to the chair for this session, Honorable Mr. Justice Mishra, and to each of our distinguished panelists for sharing their valuable expertise. As we conclude this session, we proceed for a sumptuous lunch, but quick. We'll be back by 3 p.m. for the next session to start. Thank you. We start in the next 5 minutes. I request people in the lounge area to kindly come back for the next session.
persons only. Our firms demerged on the 30th.
Ladies and gentlemen, hope you all enjoyed your lunch. Without much ado, it's my privilege to welcome you all to the technical session 4 titled Policing Arbitration. Do anti-arbitration injunctions help or hurt India's global standing? This session, ladies and gentlemen, seeks to examine the impact of anti-arbitration injunctions on India's arbitration framework and its perception in the international arena. Building on the momentum of the last sessions, we now look forward to a focused and engaged discussion that will highlight key challenges, emerging trends, and best practices in balancing judicial oversight with the autonomy of arbitration, ensuring that India's global standing remains robust and investor confidence is upheld. Without further delay, it gives me great pleasure to invite Mr. Arun Chawla, Director General ICA and former DG FICCI, to kindly welcome the Chair on behalf of Indian Council of Arbitration.
Good afternoon, ladies and gentlemen. I hope you had a sumptuous lunch and not sumptuous enough to make you feel sleepy. With our previous sessions setting a strong precedent, we now arrive at the final and perhaps one of the most nuanced technical sessions of the day, policing arbitration. Do anti-arbitration injunctions help or hurt India's global standing? It is a distinct honor to have Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India, chairing this session. Prior to his elevation to the Supreme Court, Justice Kumar served with distinction in the Karnataka High Court and subsequently as Chief Justice of the Gujarat High Court. He has consistently demonstrated a balance of vision, compassion, and administrative ingenuity. As Chief Justice of Gujarat High Court, he launched Signal Schools, quite an ingenious idea, I must say, converting buses into classrooms to educate children engaged in begging, and introduce justice clocks in courtrooms to track case pendency, maintaining a quarterly clearance at the rate of above 85%. He also piloted live streaming of district courts and conducted lok adalats to efficiently resolve traffic, utility, labor, and service-related disputes. His leadership reflects a commitment not just to justice, but to accessibility, efficiency, and social impact. But before we invite Justice Arvind Kumar to deliver his keynote, may I request Dr. N.G. Khetan, President of ICA and Senior Partner, Khetan & Company, to felicitate Justice Kumar with a green certificate, a pledge by ICA to plant a thicket of 8 trees at a facility in Ayodhya, Uttar Pradesh. I think we'll have the honor of having a photograph with the May I now invite Justice Kumar to deliver his keynote address. Thank you.
A very good afternoon. Respected dignitaries, distinguished members of the bar, esteemed colleagues, and my co-panelists, Mr. Amit Sibal, Senior Advocate, Mr. Alex Gunnings, Mr. Amra Lees, Ms. Tini Abraham, and Mr. Igor Gorchkov. Once again, a very good afternoon to all of you. The initial speaker said you all had a sumptuous lunch. So this reminds me that when I used to go to Bhopal, Judicial Academy, to give my lecture series, I used to see every time, 3 times I saw one particular judge was also there whenever I went. And he was occupying a particular chair behind a column. So 3rd time I was so inquisitive, I asked him, brother, how come you occupy that chair? Is it a good luck chair or something? And he said, nothing, sir. This is the best place to take a good nap. But fortunately, there are no pillars here. So I hope and trust that, and our time schedule, as usual, as it happens in all the seminars, running behind schedule. And we were supposed to commence at 2:15, end at 3:05. And today we commenced at 3:20 or 3:19 to be precise. And we are supposed to close it at 4:05. We'll try to do as much as just is possible. And I request my co-panelists also to share their thoughts as quickly as possible and within this time schedule. And the thoughts which I would like to share with you is, there is something quite remarkably about a gathering such as this. We come from different jurisdictions, trained in different traditions, shaped by different legal cultures, and yet we find ourselves speaking a language that is in essence universal. Not the language of statutes or precedents alone, but the language of fairness, of balance, and of resolution. Perhaps that is the enduring promise of arbitration, that even where laws diverge, the idea of justice do not. I must confess, there is also a certain philosophical curiosity in being asked to speak on arbitration. Courts, by their very nature, encounter disputes when positions have hardened, when dialogue have failed, and when resolution requires adjudication. Arbitration, on the other hand, is founded on the hope that reason may prevail before conflict becomes irreconcilable. In that sense, one may say that courts see the end of disagreement while arbitration seeks to preserve the possibility of the agreement. And yet, as experience often reminds us, even the most carefully structured processes, whether judicial or arbitral, must occasionally confront the limits of human expectation. It is perhaps for this reason that discussions such as these remain relevant and indeed necessary. I extend my heartfelt appreciation to the Indian Council of Arbitration and to Mr. Arun Chawla for creating a forum that allows for such reflection. In a world where disputes increasingly transcend borders, it is conversations of this nature that ensure that our response do not remain confined with them. And if I may add, with some degree of humility, arbitration has perhaps achieved what few institutions have. It has persuaded parties from across the world who may agree on very little else to at least agree on how they will disagree. The question we are called upon to examine today is often framed in narrow terms, whether anti-arbitration injunctions represent judicial overreach or whether they serve as a necessary safeguard. In my respectful view, that formulation does not capture the full depth of the issue. The real question is not intervention versus autonomy. It is legitimacy versus abuse. Arbitration is founded on party autonomy, but autonomy cannot be absolute. It cannot operate as a cloak for procedural unfairness, jurisdictional overreach, or inequitable outcomes. Autonomy without accountability is not arbitration, it is abdication. India today stands at a significant and defining juncture in arbitration. The data placed before us is not merely encouraging, it is transformative. In 2023, Delhi International Arbitration Center has reported a 14-fold increase in arbitration filings, rising from 528 cases to 7,358. In 2024, the Mumbai Center for International Arbitration recorded a 48% increase in the number of cases filed. Further, India today stands at the third position globally in approaching the Singapore International Arbitration Center for international institutional arbitration. These figures are not just statistical markers, they reflect a deeper structural shift. They indicate that India is no longer a peripheral participant in arbitration. It is emerging as a serious and credible forum, both domestic and international dispute resolution. However, this growth also brings with a corresponding responsibility. In today's global economy, arbitration is not merely a dispute resolution mechanism, it is a jurisdictional signal of commercial credibility. Parties and investors do not assess jurisdiction solely on the basis of legislative frameworks. They observe how courts respond to arbitration, whether with consistency, restraint, clarity, or with unpredictability and hesitation. India's moment, therefore, is not just about volume, it is about vision. It is about demonstrating that arbitration grows. The legal ecosystem surrounding it evolves with equal maturity, ensuring that expansion is accompanied by stability, predictability, and principled judicial engagement. If I may suggest, the time has come to crystallize this evolving jurisprudence into a more structured framework. The vexatious and oppressive, quote and unquote, formulation, though valuable, may benefit from further doctrinal clarity. A principled approach may be understood across three limited categories. Number one, jurisdictional illegitimacy, where the arbitration agreement is null and void or incapable of being performed. Two, procedural unconscionability, where the arbitral process is fundamentally unfair due to ambiguity or impossibility. Three, abuse of process, where arbitration is invoked as a tool of harassment through duplicative proceedings or forum shopping. Beyond these narrow confines, courts must exercise restraint. Intervention is not anti-ethical or arbitration. To arbitration, indiscriminate intervention is. From the standpoint of statutory architecture, the Arbitration Act 1996 itself a product of India's commitment to unilateral model and the New York Convention. The legislative intent underlying the Act is clear: to minimize judicial intervention and facilitate a party-centric dispute resolution mechanism. In this context, Section 5 of the Act assumes significance, as it expressly mandates that no judicial authority shall intervene except where so provided in the Act. This provision has often read as embodying the principle of minimal interference. However, it is equally important to note that the Act does not envisage a complex exclusion of judicial power. Rather, it contemplates a carefully calibrated role of courts, particularly at the pre-reference stage and in matters concerning the validity and enforceability of the arbitration agreement. Section 45 of the Act, which applies in the context of international commercial arbitration governed by New York Convention, is particularly instructive. It provides that a judicial authority shall refer parties to arbitration unless it finds that the arbitration agreement is itself null and void, inoperative, or incapable of being performed. The negative formulation of the provision is significant. It places the burden on the court to examine whether the arbitration agreement suffers from any such fundamental infirmity before compelling parties to arbitrate. It is in this statutory setting that the jurisdiction to grant anti-arbitration injunctions must be understood. While the Act does not expressly use the expression, quote, anti-arbitration injunction, unquote, the power is traceable to inherent jurisdiction of civil courts, read with the limited supervisory role preserved under the Act, particularly where the arbitration itself is under serious doubt. The Apex Court in Modi Entertainment versus WSG Cricket Private Limited dealt with the issue in the context of anti-suit injunction, but the principles laid down therein have equal relevance to anti-arbitration injunction. The court recognized that Indian courts possess the jurisdiction to restrain proceedings, including foreign proceedings, where such proceedings are oppressive, vexatious, or in breach of a contractual or legal right. At the same time, the Apex Court also emphasized that such power must be exercised with great caution, bearing in mind the principles of comity and the need to avoid unnecessary interference with foreign jurisdiction. In Balaji Steels, the Apex Court had the occasion to consider the scope of intervention in the context of an international commercial arbitration where the seat was outside India. The court noted that the agreement between the parties clearly stipulated arbitration in Benin under the laws of that jurisdiction. In such circumstances, it declined to entertain the request for appointment of an arbitrator or for injuncting the arbitral tribunal holding the proceedings by concluding that in the absence of any cogent material demonstrating that the agreement itself was null and void or incapable of performance, the court must honor the express contractual stipulations which the parties have agreed upon. What emerges from this line of authority is a consistent judicial philosophy that while arbitration is to be respected as a chosen mechanism of dispute resolution, it cannot be insulated from scrutiny where the very foundation of that mechanism is in question. The court therefore does not act as a forum of appeal against arbitral proceedings, but as a guardian of the threshold legitimacy of the arbitral processes. It must be emphasized that the exercise of such jurisdiction is not routine. There must be a clear and demonstrable case of invalidity, incapacity, or abuse, failing which the parties must be left to the arbitral process that they themselves have chosen. The real issue would be drafting of the failure in the drafting. If one were to identify the true source of anti-arbitration disputes, it does not lie in judicial overreach. It lies in contractual ambiguity. Anti-arbitration injunctions are rarely born in courtroom. They are born or come into existence while being drafted. Unclear seats, conflicting governing laws, asymmetric clauses, procedural uncertainty are some of the grounds. These are not mere drafting errors, they are structural defects. The Apex Court in Mahanagar Telephone Nigam versus Canara Bank and others aptly observed that the arbitration agreement is the foundation stone of the entire process. If the foundation is unstable, the structure cannot endure. Before I conclude, I see many young faces or young lawyers also here, and this takes me back to my younger days, which I would like to share in this august audience. One of the first cases which I started in my practice from 25th May 1987 relates to an arbitration proceedings initiated under the 1940 Act. The Honorable Apex Court had appointed a former Chief Justice of Bombay High Court as the arbitrators. Totally, there were 54 sittings held. 2 sittings were held in Delhi in ILI, Indian Law Institute, where I also participated as a young bachelor. Why I am harping upon this word bachelor is, during the process this arbitration was going on, I got married. So I extended the invitation to our opponent lawyers, including the arbitrator. After the marriage, so immediately thereafter, I was there in the arbitration proceedings. The arbitrator was, the sole arbitrator, was a former Chief Justice, asked. I remember some youngster was getting married, because we were 6. From the other side, there were 4, we were 2 from our side. So I raised my hand. He said, when was marriage is over or it is yet to? I said, sir, it was over. When? I said, day before yesterday. He said, what? You got married day before yesterday and you are here. Proceeding stands adjourned. He said, no, we are doing injustice. He said, at 1:30 we will wind up, and he said, I will be going out for some outing. The reason, and he said, and what he said, I still remember. He asked me, why did you come? You said you got married day before yesterday. Why did you come? I said, sir, I did not want to lose the flow of the reasoning or the process. I wanted to learn. It is there I learnt not only arbitration laws, not only Sale of Goods Act, not only Contract Act, but also Evidence Act, and what is as to how you have to cross-examine a witness, because in that arbitration proceedings, one witness was cross-examined for 93 days. And I learnt as to how a demeanor of a witness matters, because on that basis we succeeded in that arbitration proceedings. And this is why I am telling the youngsters, you should be serious in your profession. You should be committed to your profession. You should be wedded to your profession. And only when you dedicate yourself to what you are doing, the results will be very, very encouraging, and the answer is none else, myself. So I appeal to all the youngsters, taking off on, this is what I've seen in, especially in Delhi, Mumbai and Calcutta. Sundays not working, Saturday evening taking off. In Bangalore, we had no holidays. Only holiday was Sunday going at 4:30. Otherwise, we used to always work. We used to wind up our office, we leave the office, earliest was 11:30, late was 1:30. Of course, now as Supreme Court judge also, we are sitting till 1:30, 2 o'clock, that's a different issue. We are required to read, Mr. Amit knows that especially on Mondays and Fridays, what would be the amount of work. Be that as it may. My request or my appeal to the learned younger members of the bar is, put in hard work. Be sincere to your work. Be honest to your work. And be honest to your seniors. Because you will be a senior one day and you will be the future of this bar. So take care, and I once again thank the organizers for giving me to share, for giving me an opportunity to share my thoughts in this august audience. Thank you once again. Jai Hind.
Thank you, sir, for your nuanced and insightful address. Your remarks have laid a thoughtful and intellectually robust foundation for the discussions ahead. At this point, I move towards the panel discussion. It's my privilege to introduce the moderator for this session, Mr. Amit Sibal, Senior Advocate, Supreme Court of India, and an associate member of 3VB London. We have had the privilege of Mr. Sibal time and again lending his perspectives and expertise at our conferences, and we're delighted to have him guide this critical discussion today. Joining this distinguished panel are experts who bring rich global perspectives. Mr. Alex Gunning is King's Counsel, also a barrister at 1 Essex Court, London. Ms. Amanda Liss is Head International Arbitration at Mallesons, Singapore. Ms. Tini Abraham is a partner in dispute resolution practice at Trilegal, India. Mr. Igor Gorchakov is a partner in the dispute resolution practice at Al Tamimi and Company, UAE. With this, I would now like to invite Mr. Sibal to take over the panel discussion.
Thank you very much. And thank you, first of all, to Justice Arvind Kumar for, in his keynote speech, inspiring us, young and old, and framing, or if I may say so, reframing the issue of discussion today as a discussion about anti-arbitration injunctions in the context of the issue of legitimacy versus abuse. And perhaps pointing out that perceptions of party autonomy can differ. A conventional view of party autonomy is that parties have chosen a particular mode of dispute resolution as arbitration. But when circumstances arise where the very integrity or fairness of the arbitration comes into question, where there is, as Justice Kumar put it, jurisdictional illegitimacy, procedural unconscionability, or abuse of process, then a court might take a view legitimately that even to promote party autonomy, it might be necessary in very exceptional circumstances to grant an anti-arbitration injunction. Where the balance lies is something that I hope to hear from our amazing and multi-jurisdictional set of panelists about. We have panelists with experience of practice in the UK, in Singapore, in the UAE, and so many of them have in themselves a multi-jurisdictional expertise. So I hope to have them share their experience and knowledge of anti-arbitration injunctions with us. Many of them have been caught personally in volleys of anti-suit and anti-arbitration injunctions between different courts in different jurisdictions in cross-border disputes. So I think it should make for a fascinating discussion. The recent case of MSA Global brought some of these competing considerations that Justice Kumar spoke about to the fore in what I might call a potboiler of a dispute where the Delhi High Court granted an anti-arbitration injunction restraining ICC arbitration proceedings, which injunction was affirmed on appeal by the division bench. From allegations of bias against an arbitrator being the essential ground for grant of the anti-arbitration injunction by the Delhi High Court, to an anti-suit injunction being passed by the Singapore High Court restraining proceedings in Delhi, the MSA Global case had all the ingredients of a Bollywood masala flick in arbitration terms. The MSA Global case is perhaps the reason we might be sitting here today, because it has reignited the debate on the question of when anti-arbitration injunction is legitimate policing and when it is undue interference. I hope to have a format of discussion with my co-panelists, followed by questions from the audience, and then I will invite Justice Kumar to give his closing remarks. May I start with Teeny? Close to home. How, Teeny, would you characterize the current position on anti-arbitration injunctions in India? Do you think the law now is settled and principled, or do you think that it remains fact-sensitive and unpredictable?
Good afternoon, everyone. So I think I'll answer this question by quoting Justice Kumar, because he sort of set the context for this answer. And if we look at the jurisprudence on this in multiple jurisdictions, including India, I think the answer is that there is a framework which is set, which is where you look at an anti-arbitration injunction when it is vexatious or oppressive. But I think, so to answer the question of whether there is certainty in law, yes, there's a broad framework which is in place. But I think the problem comes, or why it becomes a topic of discussions every few years in conferences around the world, is the fact of how these terms are being used and how it is interpreted in certain fact situations. So it is, I think, while the ideal situation would be to have courts not interfering with an arbitration proceeding, we respect the autonomy of the arbitral tribunal to decide on its own jurisdiction. The court's interference is limited to deciding whether there's a valid arbitration agreement which is capable of performance. There might be circumstances where the courts may need to travel beyond that, and therefore this test of oppressive or vexatious remains relevant. But what becomes critical is how it gets applied on a regular basis. What are the benchmarks that needs to be applied in order to have this test fulfilled, so that there is clarity which comes up, and there is the similar fact situations does not lead to a situation where you have an anti-arbitration injunction in one case and in the other there is no such injunction being granted, or vice versa. So I think that is where this issue is, as you mentioned, a potboiler at this point in time.
One of the striking features in MSA Global is the Indian party Indian party's multi-forum challenge to one of the arbitrator's appointments on grounds of bias and non-disclosure. So first a challenge before the ICC court, then before the Singapore High Court, and then seeking an anti-arbitration injunction in the Delhi High Court on the same grounds. Now the Singapore High Court subsequently granted an interim anti-suit injunction in support of the arbitration. The Delhi High Court then granted an anti-arbitration injunction on the reasoning that the fairness and integrity of the arbitral tribunal had to be protected, and on the reasoning the very essence of party autonomy meant that you must have an impartial arbitral tribunal whose integrity cannot be in question, and therefore the court reasoned it merited an exceptional measure of anti-arbitration injunction in the interim. Now, how in your view does this approach sit with the principles of party autonomy and judicial comity, particularly when you have now a supervisory court in the party's chosen seat, that is Singapore, having already intervened to protect the arbitral process, but you then have an anti-arbitration injunction by a different jurisdiction?
The MSA Global, I think, raises a fair amount of discussion and concerns because of this peculiar fact situation, which is that you had the institution who has the first, who's the first pullers in that sense to make sure that the appointment process is kosher, taking a view. The court of the seat, which has a supervisory jurisdiction, taking a certain position, and then we have the Indian court granting an anti-arbitration injunction on the basis of, at the end of the day, protecting party autonomy and the integrity of the process. While the fulcrum of the discussion remains that it is to protect the integrity of the process and to avoid anything which is vexatious. What becomes, to my mind at least, a aspect which the courts needs to be careful about is that at what point in time it is the duty of a foreign court to interfere with an arbitration process when there is a seat court which is clothed with that authority to do certain functions in order to protect the integrity of the process. So I think the real question therefore boils down is that if you have enough checks and balances, do you need an anti-arbitration injunction to be granted by a foreign court? And in this situation, obviously, when we look at the judgments of the Indian courts and of the Singapore courts, there is varied reasoning which has come for a difference in opinion. That said, I would think that balance is something which needs to be looked at, and personally, I would think that there is a very thin line which at some point in time you think that it may or may not have been crossed when it comes to giving the respecting comity of courts and the supremacy of the seat court.
I personally think that one of the lesser known facets of MSA Global is something Justice Kumar pointed to in his keynote, which is the importance of good drafting of arbitration clauses. Because one of the things that many of you might have noticed looking at the reports of that judgment is that the Singapore High Court took the view that the seat was clearly Singapore, whereas the division bench of the Delhi High Court took the view that the seat of arbitration was New Delhi. And this difference of view arose in large part, sir, on account of a poorly drafted arbitration clause. And much of the lack of clarity would have been avoided perhaps with a better drafted arbitration clause. Which brings me, sorry.
Absolutely, and in fact, just to add to what you just mentioned, the fact that there was no mention of seat at all in that clause, which was silent on the seat, which created and the ICC taking a position in the first instance.
Which brings me to Amanda Lees. Amanda, staying with MSA Global for a moment, how did the Singapore court react to the anti-arbitration injunction by the Delhi High Court, and what would you say is the attitude of Singapore courts to anti-arbitration injunctions generally?
Thank you very much, Emmett, and a pleasure to be here this afternoon. Thank you for inviting me to speak. As has already been mentioned, what happened then is that the Singapore High Court granted a permanent anti-suit injunction against engineering projects in respect of the proceedings in Delhi. Now, in doing so, the Singapore High Court made a number of points. First, in terms of the dispute resolution provision, as you've already alluded to, it was an unusually badly drafted provision. We see a lot of them. This one was particularly bad. It referred to the Delhi courts having exclusive court jurisdiction. It then also had another provision providing for an arbitration before the ICC. Now, given the provision for arbitration, both parties agreed to arbitrate, and they went through the process of having a seat designated by the ICC, which is what happens under the ICC rules when no seat is mentioned. Now, here the ICC designated Singapore as the seat. And what is not picked up in the Delhi judgment is that engineering projects acknowledged this and signed terms of reference in which Singapore was agreed to be the seat. And this was something that the Singapore court highlighted. And not only that, then engineering projects actually went to the Singapore court as the supervisory court of the seat and made several applications. Firstly, a setting aside application and then a challenge application, and continued to acknowledge that the Singapore courts had such jurisdiction as the seat court, somewhat contrary to the submissions they were making to the Delhi High Court. And there does seem to have been a sort of difference in the submissions that were being made in Singapore and in Delhi. So the first thing that the Singapore court noticed was that it had supervisory jurisdiction over the arbitration, not Delhi. And it went on to consider, well, what is the role of the Delhi courts given the provision in the dispute resolution clause that they had jurisdiction? And in this respect, the Singapore court looked at the decision in Sul America, which is an English decision where there was a dispute resolution clause that referred to both arbitration in London and Brazilian courts, and held that the Brazilian courts had quite a narrow residual jurisdiction. And the Singapore courts likewise held that the Delhi court had very little residual jurisdiction, and in particular, the Delhi court had no jurisdiction to act as a supervisory court, which, reading the judgment, it seems it did take upon itself to do, nor did the Delhi court have the jurisdiction to injunct the continuance of a validly commenced arbitration in the opinion of the Singapore courts. And the Singapore courts made a number of comments in relation to the Delhi decision itself. They noted that central to the proceedings in Delhi was the issue of the impartiality and independence of the arbitrator, and this had been central to the challenge provision, the challenge application, which engineering projects had also brought in Singapore. As I already mentioned, the anti-arbitration injunction was, in the view of the Singapore court, outside the residual jurisdiction. The Singapore court, as the seat court, should perform the function of deciding challenges to arbitrators, and had actually done so on the basis of that jurisdiction which engineering projects had invoked. The Singapore court had dismissed that challenge. And then finally, that the model law allowed the tribunal to continue the proceedings and make an award when a challenge to an arbitrator was pending. And so you could not say that the tribunal, by doing so, was acting in a manner which was vexatious and oppressive when it was allowed to do so under the model law itself, which has force of law in Singapore. Right? And this was one of the grounds the Delhi judgment, or the basis of its deciding to issue an anti-arbitration injunction was that the continuance of the proceedings was vexatious and oppressive. And the Singapore court's view was, well, how could it be when the model law actually allows it to do so? And finally, that an anti-arbitration injunction is not a court invention that's provided for under the model law in relation to challenges to arbitrators. So as on the basis of making those sorts of observations about the Delhi decision, the court then went on to grant the anti-suit injunction on two bases. Firstly, as the Delhi proceedings were commenced and continued to be run in breach of the dispute resolution clause, given that any dispute was supposed to be arbitrated, and two, that it was an abusive process as it was a collateral attack on the Singapore court decision, which decided against the challenge to the arbitrator and therefore was vexatious and oppressive itself. And I think the Singapore court took a very dim view of engineering projects, in effect forum shopping, by having started these proceedings in Singapore and then deciding to go to Delhi. And then turning to the second part of your question, very briefly, about what is the attitude of Singapore courts to anti-arbitration injunctions. As you have already picked up, the Singapore courts actually take a very dim view on anti-arbitration injunctions. I haven't been able to find an example where any anti-arbitration injunction has been granted. The applications that have been made have not been successful. They take a very strict view about Article 5 under the model law and in confining the role of the court to only taking those sorts of interventions which are actually allowed for under the model law. And it's very similar to the Section 5 that Justice Kumar read out in relation to the Indian Act. And they take a very strict view of that, and that it doesn't allow for anti-arbitration injunctions. The one thing in this judgment where the judge referred to maybe there would be an anti-arbitration injunction is the first category that Justice Kumar referred to, which is when, for instance, an arbitration claim might have been brought outside the scope of the arbitration agreement or on the basis of an invalid or non-existent arbitration agreement. Then, it's possible that they might entertain such an intervention.
Thank you. If I can turn to the UK, Alex, what would you say, how would you think an English court might have reacted to an anti-arbitration injunction in the nature of what was issued in MSA Global?
If the underlying question is in relation to
a London-seated arbitration.
A London-seated arbitration, I think it would have resolved it in exactly the same way as the court in Singapore, which is a very quick way of answering your question. I would say, just to pick up the MSA Global case touches on three really hot topics, I think, in current arbitration law. The first is the law applicable to the arbitration agreement. The second is the impact of a failure to disclose. And then the third is the availability of injunctive relief. I think the English court would have held that the law applicable to the arbitration agreement was the law of the seat, on the footing that that's what the 1996 Act says, and it would have concluded that the seat was London for the reasons, or Singapore, for the reasons that Amanda has given. And indeed, the reasoning of the Singapore court was very much along the lines of the decision in Sul America, which is an English case. Secondly, I think the English court would probably have been disinclined to treat the non-disclosure by the arbitrator as disqualifying, at least in a way that affected the interim measures award that had been made. I think it might be said, looking at these decisions from afar, that the English court and the Singapore court maybe are being a bit lily-livered about arbitrator non-disclosures, and they perhaps focus too much on the indeterminable question of whether the failure to disclose indicates a shortcoming in the arbitrator that might have affected the award. And that was very much the reasoning, I think, in the Delhi High Court, that this was a serious shortcoming and it was indeterminable what its effect was, which was why it was so serious. Thirdly, if you assume the English court had, was the seat, or England was the seat, then it would have regarded the proper approach as being to apply under Section 24 of our Act to remove the arbitrator and or to challenge the interim measures award under Section 68, which is what they did actually in Singapore, or the equivalent to that. They would have held an anti-arbitration injunction which sought to get around that, was vexatious and depressive. So it would have been the same result, I think, in England.
An interesting point you make, Alex. I personally think what troubled the Delhi High Court more than anything else was not so much that the arbitrator had not disclosed, because the failure to disclose would not have been a contravention of Schedule 5 or 7 of our Act either. I think what troubled the Delhi High Court was the reason that the arbitrator ultimately gave for not having disclosed. He said, when I realized that I had this previous involvement with an affiliate of one of the parties, I consciously did not disclose it because I believed it would trigger a challenge by that party to the partial award we had already passed and a challenge to my appointment.
Yeah. It was a brutally honest thing to say, but probably not advisable.
Now, the UAE is a unique jurisdiction operating two court systems, the civil law and the common law. How do these two systems approach anti-arbitration injunctions and anti-suit injunctions in support of arbitration? If I can ask Igor, who practices at Tamimi and Company in Dubai and is qualified under both English and Russian law.
Thank you very much, Amit. Thank you for the opportunity to speak at this conference. Esteemed guests, well, UAE is indeed a very interesting jurisdiction. Well, first of all, as you rightly say, we operate both civil and common law court systems. And second, we are an extremely pro-arbitration jurisdiction. So speaking about anti-arbitration injunction in civil law courts, like mainland courts, this concept simply don't exist there. So you will not be able to get such an injunction from that court. But I wouldn't say, therefore, that you are completely safe from the risks, because there's another angle of this issue, i.e. a possibility of getting an enforcement action from a foreign court anti-arbitration injunction. And that's where the interesting story might begin. Speaking about international courts in free zones, DIFC and ADGM, these are the common law courts, so they apply common law test, and Amanda and Alex said quite a lot about that. I don't think I have very much to add on that. Just to say that we've seen a lot of examples of anti-suit injunction in support of arbitration. I can't think of any example of anti-arbitration injunction yet. I can't say that it's not possible, but as I say, UAE is an extremely pro-arbitration jurisdiction, so it is, you need to meet a very high bar in order to get such kind of an injunction from DIFC or ADGM court. Speaking about the enforcements that I mentioned, UAE, like other jurisdictions, including India, by the way, is now becoming a country where parties fighting between each other are seeking to enforce their judgment because the jurisdiction is viewed to be as neutral. For example, Russian parties look at UAE or India in their regard. And speaking about Russia in particular, it is the only or one of the few civil law jurisdictions that do have a concept of anti-suit and anti-arbitration injunctions, and recently Russian court issued quite a lot of those for quite significant amounts. And now we have approached the time when these injunctions and these court orders are getting enforced in various jurisdictions. And in that regard, I would mention two cases that are going on now. One is going on in the UAE, another is going on in India, in Mumbai. Both cases involve the enforcement of Russian anti-arbitration injunctions under so-called Lugovoy law. In the UAE, this is the case of Wintershall against Russian Federation, and the quantum of the case there is $6.5 billion, quite a big one. And the case in India is also quite significant. It also involves enforcement of an anti-arbitration injunction in the High Court of Mumbai on a dispute between Eurohem, Russian company, and Tecnimont, a big Italian contractor, and I think the quantum there is in excess of 3 billion euros. So those are quite significant cases, and they are now being tested in the courts of our countries.
As you said, it's anti-suit injunctions are more common in the UAE to protect arbitration. And the Wintershall case, I understand, was an instance of that. Sir Jeremy Cook in the DIFC did not agree with the Russian side's plea, opposing the anti-suit injunction. Which really, it strikes me because we've just heard Amanda say anti-arbitration injunction unheard of in Singapore, perhaps one end of the spectrum, and perhaps the UAE is pretty much at the same end of the spectrum. But you look at Russia, that might be at the other end of the spectrum, where you have not only anti-arbitration injunctions, but you even have an anti-arbitration statute, which is the Lugovoy statute, which says that after sanctions have been imposed, all arbitration agreements to which a Russian entity is a party in connection with a sanctioning state, or an entity from a sanctioning state is a party to that arbitration agreement with a Russian entity, the arbitration agreement is deemed to be void. And so as a result of that, parties have approached the Russian courts to resolve those disputes, and which has resulted in issues where anti-suit and anti-arbitration injunctions have collided. If I can turn back to Alex for a moment to talk about perhaps the UniCredit case, which you argued in the UK Supreme Court, in connection with a dispute between a Russian party and a German party, very briefly.
Yes, so when I said a little earlier that arbitration-related injunctions are a hot-button topic in England, a large part of the reason for that is precisely what Igor has mentioned, which is the Lugovoy law, which has seen a battle between English anti-suit injunctions and Russian anti-arbitration injunctions, and the most prominent, but certainly not the only case in this respect, has been the Ruschem Alliance case, which arose out of some bonds that were granted by UniCredit, a German bank, to the Russian project owner, and those bonds were governed by English law, but provided for ICC arbitration seated in Paris. The banks declined to pay under the bonds when the contractor withdrew from the project, but rather than starting an arbitration in the ICC in Paris to recover the sums payable, the project owner commenced court proceedings in St. Petersburg, and it did that, amongst other things, because of the putative impact of European sanctions on the Paris-seated arbitration. And the Court of Appeal in England granted a declaration that the Russian proceedings were brought in breach of contract and granted a final anti-suit injunction restraining the Russian proceedings, and that anti-suit injunction was upheld in the Supreme Court. But following the decision of the Supreme Court, the Russian project owner continued with the Russian proceedings in breach of the anti-suit injunction and obtained an anti-arbitration injunction in Russia to preclude any arbitration in civil law and in Paris. And in civil law countries such as Russia, injunctions of that kind are combined with something called an restraint, which is a form of fine, in effect, which is levied for failure to comply with the injunction. And faced with a very sizable restraint, and the potential impact of that restraint on Unicredit's assets in Russia, Unicredit applied to the Court of Appeal to revoke the anti-suit injunction, which itself was a rather novel thing to do, because there was no suggestion it would have been wrongly granted. They just wanted it removed. And the Court of Appeal couldn't revoke the declaration that they had made because it was right that there was a breach of the arbitration agreement, and they couldn't correct that, but they did agree to revoke the anti-suit injunction. So in that particular standoff, the Russian decision to grant an anti-arbitration injunction outflanked the English Supreme Court decision in practical terms. And that wasn't because the Russian court had a better view about the terms of the meaning of the arbitration agreement, and it wasn't because the English court had changed its mind about whether an anti-suit injunction should be granted. It was just because the Russian court had the more painful weapon, and Ruscom Alliance didn't have assets or officers in England who might be the subject matter of contempt proceedings in the English court, whereas Unicredit did have substantial assets in Russia. So I think what that tells you is that in this sort of standoff between anti-suit injunctions and anti-arbitration injunctions, the jurisdiction that is likely to prevail is the jurisdiction with the most effective coercive leverage over one or other of the relevant parties in that case. That's the sort of Ruscom Alliance. I would just pick up one point, though, that Igor was making about the Eurochem case, because I think we might see a similar sort of issue arising. In the Eurochem and Technomont case, there are competing English arbitration proceedings and Russian court proceedings. And the Russian courts handed down judgment in favor of Eurochem, and Eurochem has sought a freezing injunction in the Bombay High Court in support of its enforcement of that judgment. The English tribunal has issued peremptory orders to prevent the Russian proceedings and to prevent their enforcement. And the English court gave judgment requiring compliance with that latter peremptory order preventing enforcement on the 9th of February 2026. And the timing of that was significant because the final submissions in the Bombay High Court were made on the 11th of February 2026. So we wait to see what the Bombay High Court makes of what appears on the face of it to be a battle between the English arbitration and the Russian proceedings.
Points emerge from what you're saying, and thank you so much for compressing all that in a very short time, very complex proceedings you described there. But two takeaways amongst so many. One, that clearly then, when a court decides whether it should grant an anti-suit or anti-arbitration injunction, it has to look at the entire picture and what the consequences might eventually be for the parties, including where assets are located, point number one. The point number two is interesting, which is that the English High Court claimed jurisdiction in Ruscom Alliance and Unicredit based solely on the fact that the governing law of the arbitration agreement was English law, even though the arbitration proceedings were seated in Paris under the PCA, and neither party was English, and Russia didn't have, the Russian entity had no assets in England. And that really is commensurate in some ways with how various jurisdictions find that they have the power to consider grant of anti-suit or anti-arbitration injunctions. The issue is whether they will choose to exercise that power. So turning back to Amanda for that, if you look at countries in the APAC region, Hong Kong, etc., in what instances have courts granted anti-arbitration injunctions?
Yeah, thank you. I think it's very interesting to look at Hong Kong because Hong Kong is also a model law jurisdiction like India and Singapore, but has taken a different view as to whether or not it has the power to issue an anti-arbitration injunction. And basically they've held they do have the power to grant such injunctions, but they will exercise it only in exceptional circumstances. They say this power may be exercised if two conditions are satisfied, namely the injunction does not cause injustice to the claimant in the arbitration, and two, the continuance of the arbitration would be oppressive, vexatious, unconscionable, or an abusive process, picking up very much the criteria that Justice Kumar outlined. And finally, they said the court's discretion to grant anti-arbitration injunctions is to be exercised very sparingly and with due regard to the principles of autonomy, independence, and finality of arbitration embodied in the Hong Kong Arbitration Ordinance. And you do see the way in which the Hong Kong courts have approached these cases is they have sought to strike a balance between intervening when necessary, but only doing so exceptionally. And in one of the recent cases, Eaton Properties, the court only granted a limited anti-arbitration injunction. So the court allowed the arbitration to continue in relation to some claims where they said it was up to the tribunal to work out whether or not these claims were re judicata or in breach of issue estoppel, and only prevented the arbitration of those claims which were truly vexatious and oppressive because they were seeking to reopen the findings of two previous awards, and those awards had actually gone the whole way to the Court of Final Appeal. So they really had been challenged to the full extent in Hong Kong. There's a couple of other examples in Hong Kong as well, but this one of trying to challenge awards by starting a new arbitration is becoming a bit of a theme. And then finally, just to mention an Australian case, Kraft and Beger. This is unusual in that Kraft brought both litigation in Australia and an arbitration in the US, and it ended up that the court in Australia granted a temporary anti-arbitration injunction until the proceedings were determined in Australia on the basis that there was an overlap in issues, and they were concerned, in order to protect the integrity of the court process, they were concerned about inconsistent findings. So there's another example from another model law jurisdiction in APAC, taking a different view from the Singapore courts.
What's clear is that there is power to consider grant of anti-suit or anti-arbitration injunctions, but commercial actors want ultimately certainty and predictability. And the problem with the jurisprudence in anti-arbitration injunctions tends to be that if you have broad concepts like whether it is oppressive or vexatious to continue certain proceedings, whether a suit or an arbitration, it becomes fact-specific, and therefore the outcome is difficult to predict. That's where I thought it was very helpful, the suggestion that came from Justice Kumar in his keynote, where he sought to break down the larger, broader concepts of oppressive and vexatious into three subparts: jurisdictional illegitimacy, procedural unconscionability, and abuse of process. And many of the examples that all our panelists today have offered in this discussion have fallen into one or the other of these silos. At this point, we're short of time, so if I can invite the audience, in case they have questions, to very briefly address them, indicating perhaps your name and the panelist that you're addressing your question to. Thank you. Can we get a mic there? Can we pass one of these mics on?
Thank you very much. Rodrigo Galadari, Dubai. I think we heard, I'm very grateful for this panel that I think was one of really the best, not these days, but that I've seen in various conferences over the last year probably. These are very hot topics, the Wintershire case, Rascom Alliance. Another case that I think, I'm not sure was mentioned, is the Google case in Russia, right? Also concerning restraint. And what happened is that the Moscow injunction was actually enforced in South Africa. The shares of Google, yes. I think Alex. Okay, somebody has comments. Yes.
You're not audible. You'll have
okay.
to move the mic closer to your...
Sorry, yes. So another case that I think is interesting is the Google case, right? Also concerning Astrintes from the Moscow court. And that injunction was actually enforced in South Africa. And I think that is creating a new map of jurisdiction which Russia calls friendly, or non-unfriendly at least, where those injunctions have teeth. And so, and the traditional opposition is between the English courts, of course, the render anti-suit injunctions, as of course in the DSC now we have a common law court that also is looking at those remedies. Do you see India or other jurisdictions which are not hostile to Russia developing a practice of enforcing injunctions from Moscow, for example? So do you see where do you see that flow lead India, for example, or why not South Africa or maybe China in the future?
I mean, I appreciate you've asked about what the position is going to be in India, and I'm the least qualified person in this room to answer that question. But I am familiar with the case that you're talking about, which is obviously a notable case because of the size of the restraint, which is currently greater than all of the money in all of the world. And it's an interesting case because actually in England an anti-enforcement injunction was taken out as a result of that, and in a sense the breadth of availability of anti-enforcement injunctions has been expanded as a result of the Lugavoy law and its consequences. And we've also seen in England a development of anti-recognition injunctions to prevent people getting their judgments recognized in foreign countries. So there's a kind of quite a broad range of weapons that are available. I think you might get some insight into what approach India takes to all of this by the outcome of the Eurochem case, because it does seem not the identical issue, but a similar issue has arisen where it's not the restraint which is being sought to be enforced in India, so far as I understand it. It's the actual judgment that was obtained in Russia that is seeking to be enforced. But that was a judgment obtained in breach of an arbitration agreement. So I guess we will see how that goes. I would, though, just pick up your broader point, which is that it's easy for people to think, well, the only assets that I have exposed to a Russian anti-arbitration injunction are my assets in Russia. But the reality is that it's broader than that. And if you have assets in former CIS countries, in Kazakhstan, or as you point out, even in countries such as South Africa, you need to be thinking about what the consequences might be for those assets.
Just add to that, as far as India is concerned, you ask a good question, because for domestic arbitrations, there is a clear-cut provision in Section 17(2) to enforce interim orders passed by a tribunal. What happens if there's an interim order by a tribunal in a foreign seated arbitration or an order by a court? Well, Section 9 of Part 1, which otherwise applies to domestic arbitration, also applies to international commercial arbitration. And some courts have taken the view that they can, on the principles of Section 9, some courts in India, look at enforcing interim orders passed abroad. So that's one avenue, and I can chat with you later about some instances of that I've been involved in. But I think it's time to invite Justice Arvind Kumar to give his closing remarks, as all good things must come to an end.
Thank you, Amit. Hitherto, we have delved upon the perception of party autonomy, fairness of arbitration agreement, the terms to be read with clarity, and it was also pointed out by Amanda that divergent opinions of Singapore court and Delhi court and supporting the Singapore court judgment And I would like to add here what in that Singapore court, while dealing with MSA Global, said, quote, there continues to be tension between the court proceedings in Singapore and Delhi. So this tension or impasse, according to my perception, could have been easily solved by referring the parties to mediation. The very foundational premise remains inconsistent. See, what was intended to be a mechanism for efficient resolution of the dispute gave rise to a competing proceedings and increased the complexity. This ought not to have happened but for the poor drafting of the agreement. So now I think at this stage I can say, when you draft an agreement, of course AI tools can be utilized to ascertain as to whether such clauses have resulted in any litigation. To some extent it can be utilized. There is nothing wrong. But ultimately it is the draftsman's acumen which will prevail. So keeping these things in mind, I think we have deliberated upon as to how anti-arbitration injunctions would be required in circumstances which may prevail in facts and circumstances of each case. It all depends upon. That is why it is said always, a case takes its color from the terrain it travels. There cannot be any straitjacket formula or a precise by arithmetical precision we cannot prescribe any formula. This is where the lawyer's acumen who will assist the courts for the judges to come to the conclusion. In this case, that is MSA case, I think what the lawyers did was the age-old principle, either convince the judge or confuse the judge. So they have tried to confuse the judge to the maximum. So that apart, I think this Chintan or Manthan was very, very erudite, and it has thrown light, and lot of food for thought has been given, and the takeaway is that you should now brood over and come out with your own suggestions and ideas and assist the courts in either granting the injunction or not granting the injunction. Thank you.
That was indeed an engaging and enriching discussion. On behalf of all of us, I extend our gratitude to the chair for this session, Honorable Mr. Justice Kumar, and to each of our distinguished panelists for sharing their valuable expertise and perspectives. As we conclude this session, now I request the dignitaries on the dais to kindly take their seats in the audience. So we change over for the next technical session soon. The attendees are requested to stay seated. Ladies and gentlemen, as we reach the penultimate session, I'm delighted once again to welcome you all to this engaging fireside chat titled In Conversation with Global General Counsel, Managing Risk, Disputes, and Strategy in a Globalized Economy. May I request our esteemed speakers to kindly take their seats on the dais? So their names. This session seeks to navigate the intricacies of managing risk, disputes, and strategy in a globalized economy, while exploring the evolving role of general counsels in addressing complex cross-border challenges. As the final technical session of the day, we look forward to a focused and engaging conversation that brings together diverse perspectives from global legal leaders, highlighting emerging trends and best practices in aligning legal strategy with business objectives in an increasingly uncertain international landscape. Without further delay, it's my privilege to introduce the moderator and discussant for the session, Ms. Manjari Chaudhary. She is the General Counsel and Chief Compliance Officer at Maruti Suzuki India, and who will be steering the engaging fireside conversation today. Joining her, the other speakers are Dr. Akhil Prasad, who is the General Counsel at Boeing India and Boeing Defense. Ms. Sujata Balachandar is the General Counsel at EY India. Mr. Florian Kahn is the General Counsel at Framatome and also a board member at the DIS German Arbitration Institute. Mr. Zubin Masani is the General Counsel at Air India. I would now invite Ms. Manjari to take over from here.
So thank you so much. And let me first thank ICA, Mr. Arun Chawla, for inviting us to be part of this wonderful two-day event and international conference and giving us some dedicated time for a group of general counsels to provide their viewpoint and thoughts on a topic which I'm sure you'll all agree is very, very not only interesting but highly topical and relevant. With that, let me welcome all of you to this session, where we will be talking about the role of the General Counsel in managing risk, disputes, and strategy in a globalized economy. Today, it gives me great pleasure to be moderating a panel of fellow general counsels, both from India and overseas, who not only will add their perspective to this topic, but also carry with them rich experience, many years of rich experience over multiple sectors and different legal landscapes, and where they have been addressing multiple and complex risks and disputes for their respective organizations. So the panelists have already been introduced. Let us get straight into the topic in the interest of time today. When we talk of the global economy and we think of 2026, in 2026, as the World Economic Forum report says, is going to be a highly fragmented geopolitical and geoeconomic world, where world trade actually becomes a very high-stake lever of power and control. And therefore, in a scenario of that nature, in an environment which is so different, you know, the role of a general counsel in this environment also has to change from being just a legal advisor to what I think of a general counsel's current role as having a triple mandate. One, of being a risk steward. Two, of being a dispute architect. And third, of being a strategic business enabler. So with that, let me begin, and we will try and put this session over the next at least 40 minutes into 3 segments, where we will first talk about managing and prioritizing risk, and then we will talk about dispute management, and third segment will be where we will talk about how a general counsel has moved and evolved into a role of a strategic business enabler and a partner to the business to provide effective decision making. So with that, let me start by being very broad and asking all the panelists here to answer one simple question, I think, which everybody here sitting would want to know, is what's materially different about the general counsel's risk landscape in a globalized economy today compared to 5 to 10 years ago. And we'll just go straight from your Zubin first. If you could all take about a minute to just encapsulate your broad thoughts, and then we'll come to some more detailed questions on risk.
I hope this is on. Yes. Thanks, Manjari. Manjari, when you ask what's materially different about the GC's risk landscape in a globalized economy compared to 5 to 10 years ago, I think the question probably presupposes that there's a material change in the globalized aspect of that question. And perhaps there is, and I might let other panelists speak on that aspect of it. But when you think about 5 to 10 years ago, that's only 2016 to sort of 2021, which is not terribly long ago. And I think what has really changed, actually, are the expectations on GCs in this jurisdiction. If I look at the 5 to 10 year period, that's probably, to my mind, changed more than even the globalized nature of it. And the reason I say that is because, I mean, you're aware of this as much as all of us on this panel. We didn't have as many GCs 10 years ago as we do now, right? We had lots of heads of legal. We had sort of general manager legals. But there was a very different profile within the organization, a very different reporting structure, a very different access to information. We have, for one reason or another, and I think this is obviously the right direction from our perspective, now actually got general counsels in the traditional sense of that word. Perhaps there is a tendency to overuse it or occasionally misapply it. But I think that's the real change from my perspective, that the expectations of what you're expected to deliver on have really gone up.
So from the change in expectations to what is expected to be delivered, moving on, Sujata, would you like to add to that?
Yeah, sure. So for me, personally, when I look at how the GCs are functioning, we have moved from being risk-averse to risk-aware. So almost like being part of the DNA, like 5, 10 years back, like what Zubin was mentioning, I had the privilege to work back with GCs, as you know, Manjari. I used to be a practicing counsel, and I had the privilege to see who were there on those hot seats. And what for me is important is how we become risk-aware, being part of it and not kind of saying, okay, fine, I'm not going to take it up, and then be a roadblock by saying, okay, this is risky or not to do things. And again, I would kind of, if anything, that's a breach. What for me risk is today is not really the breach, or more than is the easing of the boundaries where the general counsels are aware of. So from a professional services firm, if I look at it, so the culture behind it, the conduct of people, we are someone who have the hand on the pulse of the organization. So as a general counsel, we are really someone who comes in as a first, rather than what we were as a backstop. Now I think there is a complete shift wherein we say, okay, fine, we know exactly what is going to happen, and there we are being risk aware and also being the first stop to know that, okay, how can we now deal with it before we are. I think that's the job of a GC, to preempt things rather than react. Of course, we do react, but I think that's the value add.
Fantastic. I think that's giving a whole new dimension of being risk aware. And having a pulse on what goes on in the organization, and therefore that also adds to your awareness of the risk. And that perception is totally different than what it was about 5 to 10 years ago. Moving on, Akhil, what's your thought on it?
So I would say, Manjari, I think these last 5 years have been truly transformative for a general counsel, for the simple reason that the geopolitical situation. So remember COVID, remember Russia, Ukraine, remember what's happening, around the Middle East, Eastern region. I think this has been a very disruptive last 5 years. And it has been, I would say, for a general counsel, a wonderful opportunity to help business analyze and navigate them through these times of uncertainty. Because I do not imagine in my 30 years the situation has been as disruptive as it has been in these last 5 years. And the opportunity that we get as GCs, you know, to advise business, to navigate business, to help them become sustainable has never been tested before.
No, fantastic. I think you've added a very new dimension which talks of how you become more a business enabler, of understanding, you know, you become more integrated into the business thanks to these global disruptions that are taking place, where the role of GC has expanded into integrating with the business, understanding what the business requirements are, and therefore supporting them in that regard. Would you like to add more to that?
I don't think there's a lot to add, because I would echo everything that has been said, and especially what you said before is that we've witnessed in the last 5 years, maybe even since the start of COVID, different crises folding into each other, having interdependencies, and therefore exacerbating the effects of each of those crises. And at the same time, you are witnessing something, when the topic is here, the globalization, you are witnessing something that could be described as the globalization being somehow the victim of its own success, because at the end of the day, why are those crises that may be even localized in Europe or in the Middle East or wherever, why are they so impactful? Because we are so interconnected. And I think, and I want to echo what has been said about the changing role of the GC, we are moved a little bit more to the top of the line, where as before they were making all kinds of strategic plans, and at the end of the day they came to the GC or to the legal department and said, can we do that? And we would say, well, I don't know, maybe like this. Whereas now they're looking to us to actually interpret the landscape for them in order to provide the first, let's say, beacon as to where they go, as opposed to just being the backstop.
Great, because the role is to provide a beacon. You provide a line of sight. And that is a huge shift from being a back-end office to coming to having a table, a seat at the table, where all the senior people sit and you are considered an integral part, not only because you are there, but because of what has brought you there, partly because of the circumstances and the globalization and the change in the risk scenario, but it is also a lot to do with what the GCs bring to the table today, and therefore are able to address those risks appropriately, right? So just moving on this topic of risk definition and prioritization, Zubin, may I go a little more deeper into this topic? What role does a GC play in anticipating geopolitical risk before they transform into a legal or a reputational risk?
I think the key is before they transform into a legal risk, and what role. Well, I think a GC can play a very important role in this, provided you have a little bit of foresight in being able to anticipate something well before it translates into a legal risk. And since the question is specific to geopolitical risk, perhaps it's best to illustrate it with an example or two. If you're watching the news and you hear a potential presidential candidate threaten that when he comes to power, there will be an introduction of a massive tariffs regime across the globe, I think the right thing for a GC and their team to be thinking about it is, well, how does that affect me and our business? And in our line of work, you then need to sometimes get as granular as wondering how that translates into your contractual provisions. You usually farm the taxes provisions out to tax. Legal, sometimes your eyes tend to glaze over those. But when you look at the minutiae, the definition of taxes will in some way have import duties thrown in there, which is effectively what a tariff is. And if you are not quick enough to be able to realize that you're then signing up to effectively taking on risk on any increased tariffs, and then those tariffs are increased to 50%, as we've seen recently, you've probably missed that opportunity to catch something up to a year and a half before it became a problem, right? And we saw the same sort of thing during the pandemic, where the best negotiated force majeure provisions were not able to be applied in circumstances where you're in a business area where your business has been completely frozen up because of the pandemic. You're just not operating, but you've got certain fixed costs that you're still liable to meet. And even the best drafted force majeure provision will not let you get out of a payment obligation. So I think there now the lesson is to anticipate that sort of thing. Build in provisions for global risk where you know that you might be sitting idle for a period of months, and agree with the counterparty this is one of your key commercial provisions where perhaps we agree to share risk in those sort of scenarios.
So what I hear, Zubin, what you're saying is that, you know, the role of a general counsel today is also anticipation. And given that we are living in a globalized economy, we are a click button away from any news, any information across the world. I think anticipation and figuring out what could go wrong at what point in time, or what global geopolitics or the economy or the turns and twists that are taking place, how can they impact an organization, and thinking ahead. So agility and foresight is what I see in the role of a general counsel, right? So moving on, Sujata, let's just shift a little gears. I'd like to talk about how should a GC's office anticipate risks that are not codified in law?
Okay, that's
Yet.
very interesting, yes. See, I think the hardest call for me, for a GC, is not what is illegal. I think most of us is very codified, so we understand. I think it's the most difficult task for a GC is to kind of construe what is going to be difficult to defend. So it's not anything that's illegal is codified, and what is going to be difficult to defend for me fundamentally. And most of the decisions today, Manjari and all of us are taking on those issues which are yet to be regulated. Half of the things, when at least as a professional services firm, when we sit around, it could be anything. It could be emerging technologies. It could be independence. For example, if it's an audit firm, I can speak for it, where you say, today we have a company's bill that's come about, which is now going to kind of debar non-audit services. But we had to think of it almost like 15, 20 years back when you're accepting clients. What is the independence? What is it that we bring to the table? So we need to set a standard for ourselves, because there is a lot of regulatory oversight, and we have new regulators coming up, and we need to, rightly as you said, we need to think ahead, anticipate. So that's where we get the biggest push from the management, from people at the table, because it's not codified, right? So you as a
Yes.
GC, you're able to anticipate, you're trying to advise them, saying maybe this is how this is to be done, because many things do come up with retrospective effect, Manjari. We've seen so many laws that come in. So for me, we need to think ahead, we need to anticipate. That's one of the toughest decisions we all take on a daily basis, according to me, that which is yet to be codified or regulated.
Yes, because it's easy to manage something that's codified and you know what you need to do. But what's coming up and how you anticipate that, what is your level of agility? And we all talk about the role of general counsel moving from being reactive to being proactive. I think that is what you were trying to sum up here. And an extension of the same, Akhil, in that regard. So when you define and prioritize risk, how do you balance legal compliance with business agility?
That's a great question, Manjari. So how many of us know how to fly a kite? Kite flying.
Some do.
So the
some
CEO
do.
would want to fly the kite, and the general counsel is holding on the leash, right? So this is very, very similar to what I think is our job as GCs. See, from one fundamental principle is there cannot be a business without a risk.
Yep.
So a risk has to be acceptable, otherwise you park your funds in a bank deposit or in a whatever, current account and earn interest. So our job as GC is to allow business to take risk. For that, I think what is important is we have to really understand the business, understand the global business, understand the compliance across the globe, have a team, of professionals, whether you are, a big Indian multinational or you are a multinational organization, you need to have the right people across the board who are able to first understand the business and keep the business compliance and requirements in sync. I think that is how I see it.
No, this is, you have to get that balance right, because enabling business is core, and how do you still keep it within the guardrails? And for that, understanding the environment and understanding the different requirements becomes key. Moving on, Florin, Since you're the only one from overseas with us here, but we'd like to get a little bit more global perspective. In a global organization, how do you ensure a consistent risk appetite while respecting local legal, cultural, and regulatory realities?
That's a question that entails a lot of things, but before I answer that, may I just quickly come back to the topic of anticipation, because I had the discussion. I don't know how many of you tend to sometimes work from home. I do. And my daughter came to me the other day and said, I want to do something, can you help me with my homework? And I said, I'm working. Could you please wait a little bit? And she says, you're reading the paper. And I said, yes, that's work.
I do.
That's work, because I think one of the things that has changed is that we need to be really up to speed of what is happening. And so I wanted to add that, because that's, for me, a very important part. In terms of keeping risk appetite alive, also with regard to the legal function, is that I've tried, when I started 10 years ago in my job, I started to instill a sense of opportunities first. And then, because we wanted to never say no, but we wanted to say no, but. So we would always, I would ask my team to say, or train my team to never say just no, because what would happen then, nobody will come to you the next time. They will just go around you if you only say no. So you would have to, when you analyze the situation, you come to the legal conclusion that your answer to a question is likely to be no, your task is to find another way. And for that, I think it's very important what you said. For that, you have to be really close to the business. You have to understand what is their goal, what is the end game, actually, and where do they want to go. And if you know that, and if you're close to the business, then you can come with the but. No, you can't do that, but let me tell you how you could do that in a different way that maybe even achieves the same goal.
No, thank you. And that brings us actually to the end of the first segment on defining risk and prioritization of the same. I think one thing that has really stood out, what I've seen, is that it's so important to anticipate, to be extremely relevant. You cannot say that you're just a legal person, so that's what you're restricted to. You have to be a player on the table of the CEO and MD or the board, and how they look up to you. How much of value add are you doing? And therefore, to anticipate, to be relevant, to understand the business, like all of you said, to be agile, all of those things are extremely important as you define risk in the new geopolitical and a global economic, economy that's global, and also prioritize it for your organizations. With this, and by the way, when you talked about newspapers, I think I do that myself, and I always tell everyone, my team, I said, please do read 2 dailies, one national daily and one economic daily. It's so important to do that every single day. Your day shouldn't start without doing that, and that helps you to remain extremely relevant. The next segment that we thought we'd discuss about is how do you, when you are advising, when you manage crisis, there will be occasions of dispute, always will be. We're a running organization there. So how do you handle disputes? General counsel's role as a dispute architect, as to how they look at disputes. Are you the person who is going to resolve smartly, or are you just going to work very hard at it? Now that's the difference, because smart solutions need not always be incorrect or not legally correct, etc. It's just the way you structure it and build a little bit of pragmatism and use the legal sort of tools that you have in order to bring it to that conclusion. So with that, may I again go back to Akhil, start with you this time. How does a GC function as a dispute architect, mediating, enabling business-led settlements, really, and choosing the right forum of settlement or any dispute resolution?
So, I must confess that we have Zubin, the customer, on the panel. So customer is always right. So, so there is no point in litigating with the customer. So the kind of business we are in, we will never, ever have a situation where we cannot sit across and resolve. So I must confess that, while there may be small disputes, employee-related disputes, which will happen in our organization, but in my 13 years in my current organization, there has never been an arbitration. And the reason for that is simple, very simple, that you have to find a way and you have to sit across with your business colleagues. So whether it's defense, whether it's commercial planes, there has to be so for example, what I said, 5 years have been very disruptive, especially during COVID. We had all OEMs, all airline companies have a vast supply chain. And the worst thing you can do is to look at force majeure. And the worst thing you can do is to penalize your suppliers, because you can do that as a part of the contract, but you are now discontinuing a relationship. And once a relationship is broken, no matter what, COVID will come and go, but that relationship will never be revived. So that is how I see a day-to-day for a general counsel most often is mediation. And we sit across, we find a way, and we always have to ensure that the businesses are sustainable. And we have to find a way that business continues.
No, I think in today's world, talking of sustainability and resilience, and especially in your supply chains, I think is a very important and relevant topic for all of us. It's extremely thought-provoking also. Today also I read in the paper as to how India is looking to see what could be other sources of energy that we really need to look very actively at than reliance on just certain things which we had assumed to always be okay. So the world is not okay, and in that General Counsel's role, Florin, can I take the next question to you in that? That, what organizational tools or authorities do GCs require from their organizations to be effective in managing risks and disputes, more specifically dispute strategies? So, outside counsel holds a lot of leverage because we go to them for seeking dispute resolution, but there is a cost attached to it also. So how do you drive consistency and value across the jurisdictions?
That's a question that you either can answer very shortly or very long. I think external counsel sometimes suffer, let me start there, suffer from some kind of availability bias, because what they see is just a very tiny fractions of all the disputes that are happening in a company every day, and they tend to think it's all there is. But dispute management has, from an in-house perspective, has a lot of facets. It starts with contract drafting. It starts with drafting a contract that is in line with the topography of the risks, that actually allocates risk, let's say, in a more or less fair manner between the parties, which then reduces the amount of disputes. It then goes on to drafting possibly a multi-layered clause, an escalation clause, which may include several stages of negotiation, mediation, then arbitration. And it also creates a conflict, creating in the company, and this is what I do with internal trainings, is creating a conflict mindset, positive conflict mindset, so that you don't shy away from conflicts, because what you tend to do a lot in an organization, you shy away from conflicts, but that you embrace them and solve them in a productive manner. And that is also something that is an attitude more than it is a legal training.
Right. Okay. Quick 2 months, just to zoom in to Sujata. We do have the minister waiting, so we'll try and wrap this fast. Quickly, Sujata, how can a GC influence internal policy and culture, and as tools that may be more, they may be more effective in conflicts and disputes management? And is international arbitration the only tool?
So again, like just seconding what Akhil said, that all of you are our clients, so we don't really get into disputes with any of our clients. That's being young, and we really don't want to do, but yes. So to the culture and what you touched upon, Manjari, that's very, very important for us. It's a question of arbitration, like any other commercial contracts. When we do enter into with our clients, we do kind of prefer, obviously, an arbitration. But for us, it's more than the disputes with the clients or anything, which is really next to nothing, is our relationship with the regulators. I think most of our businesses are regulated, so our relationship and what's the culture of the team. So these days, with so much of regulatory oversight, what regulators are looking, I'm looking at both, right from my colleagues on the other side would speak on the arbitration, since we are more regulated entities. We look at regulators and the interactions with them very critical as the issue itself, and how we are able to have a dialogue with them. They want to see cooperation, they want to see transparency, what's your accountability matrix. And these days, regulators do want to have a dialogue. We do not get into, the culture is not get into any adversarial relationship. They bring in a lot to the table. So we want to get into the remediation. So it's a kind of a matrix in the culture where we tell our people, yes, we need to engage with our regulators. And okay, I see there is the minister waiting on. Okay, I'll just wrap it up. Okay, I'll pass it on. It's more on.
Just as we wrap and close on this topic of the role of the GC, one quick 10 seconds, Zubin. You have just set up a huge team at Air India. How do you work with them to bring about a mindset shift within your team to align them closely with business strategy, really? So that's important, not just the General Counsel, but the whole team needs to look in the same way. Yeah.
Very quickly, Manjari. If the majority of your team has a private practice background, as is my experience, you've already got people that are very, very client-centric, client-focused in delivering solutions for the client. Encourage them to think of your internal business units as their internal clients and adapt their delivery to what the clients really want.
Right. So with that, I think that we'll try and wrap this now. I thank you for being a great audience. We would have loved to have some questions from you, but in the paucity of time, we will give that a miss. Just 3 takeaways, which I'd said that the first is that the world is shrunk, it's global. There is, in the geopolitical world, we all are expected to look at risk differently. The whole face of risk has changed, and it's coming to us at a speed of the internet, really. The second is that being a dispute architect, so very important to work smart rather than just to work long. And lastly, General Counsel's role today is that of a translator and integrator of business to support the business, to anticipate the risks, and to provide or aid good decision making that can be good for the business. So with that, thank you so much for your patience, and thank you, my fellow panelists, for some great thoughts here, and thank you again.
That was indeed a multifaceted discussion. We thank all the speakers for the time and effort. At this point, I request the speakers, Dr. Khaitan and Mr. Chawla, to join us on the stage for a ceremonial picture. As we conclude this session, I request the speakers on the dais to kindly take their seats in the audience. We prepare for the valedictory session. If there are any attendees outside, Once again, a very good evening to our distinguished guests, the Honorable Union Minister for Law and Justice, esteemed members of the legal fraternity from both the bar and the bench, and valued participants from India and overseas. It is a privilege and an honor to welcome you all to the valedictory session of the 5th edition of ICA International Conference on Arbitration in the Era of Globalization. As we mark the conclusion, of this enriching and intellectually stimulating conference. I now request all present to kindly rise for the national song as we honor the spirit of our nation and mark the commencement of this significant gathering. Jai Mataram. Ladies and gentlemen, without much ado, we now move to the felicitation of our distinguished dignitaries. As part of ICA's sustainability initiative, we're delighted to welcome and felicitate our distinguished guests with green certificates, each symbolizing a pledge, with trees being planted at Ram Bhumi, Ayodhya, Uttar Pradesh. I would request Dr. N.G. Khaitan, President ICA, and Senior Partner Khaitan & Co. to kindly felicitate Shri Arjun Ram Meghwal, Honorable Minister for Law and Justice, Government of India, with a green certificate, marking the planting of a thicket of 10 trees in his honor. Thank you, sir. We're equally privileged to have with us today for this session Ms. Sapna Jangiani, King's Counsel, England and Wales, Chair for Commercial Bar of UK, Combar India and Asia Committee, and Judge at the DIFC Court, UAE. As we open the valedictory session, I take this opportunity to invite someone who brings with him a wealth of experience flowing from the confluence of law, policy, advocacy, and the advancement of institutional arbitration in India. Ladies and gentlemen, it's my privilege to welcome Mr. Arun Chawla, Director General, Indian Council of Arbitration, and former DG FICCI, to deliver the welcome address.
Thank you, ladies and gentlemen. These 2 days have been momentous, but as all good things must come to an end, this also has to come to an end. It's a distinct pleasure to welcome you to this valedictory session of the 5th edition of the ICA International Conference. Over the last 2 days, we have shared part-packed journey of ideas, debates, insights. Today gives us a moment to pause and reflect on this rich tapestry and to celebrate the thought leaders and practitioners whose vision, experience, and dedication have made this gathering both inspiring and impactful. Ladies and gentlemen, this conference has been an exceptional platform to explore the evolving contours of arbitration in the era of globalization. From technical sessions on harmonizing arbitration and mediation to discussions on ADR mechanisms boosting economic growth, to cutting-edge dialogues on AI and legal technology, and finally to deliberations on anti-arbitration injunctions. Each session has contributed to a deeper understanding of the challenges and opportunities shaping the international arbitration landscape. Ladies and gentlemen, as we bring the curtain down on this conference, it will be an incomplete show if we do not listen to the vision of Union Minister of Law and Justice. Therefore, please join me in welcoming Shri Arjun Ram Meghwal, Honorable Minister for Law and Justice, Government of India, who will, through his valedictory address, enlighten us about the way forward. Shri Meghwal's vision and leadership have played a key role in shaping India's legal framework and strengthening the arbitration ecosystem. We look forward to his reflections on the future trajectory of dispute resolution in India and globally, and on advancing the cause of making India a premier hub for international arbitration, building on the clarion call set forth by the Honorable Prime Minister Narendra Modi. Ladies and gents, once again, a thunderous applause for the Union Honorable Minister of Law and Justice. Ladies and gentlemen, we are equally delighted to have with us Ms. Sapna Jhangiani, King's Counsel in England and Wales, Chair for the Commercial Bar of the UK, India and Asia Committee, and Judge at the DIFC Court, UAE. Her global perspective and insight into the cross-border arbitration have inspired practitioners and institutions alike, and her engagement in the earlier sessions has provided the much-needed international dimension to our discussions. So please join me in welcoming Ms. Jhangiani as well. With these few words, I would like to invite Mr. N.G. Khitan, President of ICA and Senior Partner Khitan & Company, to deliver the opening address. Thank you.
Sir, first of all, the hearty welcome to our Honorable Law Minister. Sir, you have been sitting here since 8 a.m. this morning. There was always a feeling that the closing ceremony or the valedictory session is not such an important session. But let me tell you that when I joined my profession in the trial, there used to be closing arguments from both the sides. And that used to determine whether your case is good or bad, or whether you will win or lose. So I personally feel the closing arguments are the best arguments and is the most important session as far as any seminar is concerned. Sir, we have been hearing for last 2 days our Honorable Chief Justice. We have been hearing Lieutenant Governor of Delhi. This morning we have been blessed with the presence of 4 Supreme Court judges. We have had the blessing of presence of the Law Secretary. We had Justice Sikri. We had the people from international community coming all the way from different parts of the world. And yesterday, what I spoke about was how the India has shaped. I spoke about the economy of India. I spoke about the power of India. I spoke about how mediation and arbitration is so relevant if we want to grow at the same rate. But at the same time, I thought that when I have the most powerful law officer of the country in front of us today, I'll make some of the suggestions which I gathered last evening and the whole of this morning, because this is the best time that I can convey the feelings of the international lawyers, the feeling of the lawyers practicing in India as to what needs to be done. Sir, I can only tell you that the Gen Z in India is a very satisfied community. This is only because the proactive approach and because India has become a global power, so therefore Gen Z has a lot of confidence in the present government and they are satisfied a lot. So thank you, Singh sir, for giving this confidence to Gen Z particularly. Sir, what we thought, what was conveyed to us yesterday was that don't call it ADR, alternative dispute resolution. That's the Chief Justice said that it should be PADR, preferred alternative dispute resolution. And I would put it PI, preferred institutional dispute resolution. So that's how I would like to put it, and that was the message which the Chief Justice gave, sir. And the other thing which was the concern was in relation to Section 44 of the Arbitration and Conciliation Act. The other concern was in relation to how do we make, if we want India to sustain, if India to grow in the same way, in the same momentum, and if we want India, and if we want to ask the business community to come and set up industry in India, we want foreign direct investment in India, we have to ensure that we move away from ad hoc arbitration to institutional arbitration. That was the message which we had from the Chief Justice, sir. Today, sir, we had the session again by the different judges from the Supreme Court. We had the session from where the people from the international community were there, and there also there was a feeling that Section 12A of the Commercial Court Act needs to be looked into. The section. So therefore, I would request that there was also a concern that there has to be a time frame. The arbitrator must frame a time frame, and the award must be given within a time. The arbitration must conclude within a reasonable time. There was a session on effect of artificial intelligence. There was an effect of virtual hearing. But sir, today we did not have just our Solicitor General of India, Mr. Tushar Mehta. I thought if he's there, I would have preferred to give his quotation as to what he felt about the arbitration in India. He was addressing a message time from arbitrators. So there are too many, a person is doing too many arbitrations. So what we need to do, and I thought this is the best opportunity for me since I have the Law Minister, Honorable Law Minister with us, that what we need to do. Now we are a young country, we are an aspirational country, and we are the fastest growing economy in the world. We have opened our economy, and if that is what we want to grow in the same pace, then what in central acts, administered by the 23 central acts, administered by the 23 ministers are being amended. It seeks to decriminalize 717 provisions. So this is a remarkable thing which we have done. It seeks to rationalize 1,000 offenses, removing outdated and redundant provisions to facilitate ease of living and ease of doing business. So I think he needs an applause for doing all that, sir. Thank you very much. Sir, we had recently, we have a new labor code. We have, from the 1st of April, we have the new Income Tax Act. There is a total overall of insolvency law. There is a total of overall of corporate law. I mean, everything is happening in a short time. We are easing the law. I mean, we are ease of doing business, ease of living, and ease of happy, to be happy person to carry on business here. So what we need to do. So therefore, sir, I would like to go one by one, which the business community, which the lawyers fraternity feels that what we should be doing. The first is, sir, inclusion of more reciprocating countries under the Code of Civil Procedure. This is very, very important. Sir, limit the number of arbitrations which an arbitrator can take. In my personal view, not more than 5 at a time. No ad hoc arbitration, sir, no ad hoc arbitration. That's what the entire business community, the entire lawyers fraternity feel. It should only be institutional arbitration. mandatory mediation before arbitration, resolution of all disputes through single arbitrator, not 3 arbitrators, unless it's a case of extreme necessity. It will avoid cost, not only cost. Then, sir, the summary procedure of arbitration in all the claims below 10 crores. I think that is also very, very important. Sir, the another very important point is bilateral investment treaty. If we want to make India as a global hub of arbitration, I think the provision of litigation in the bilateral investment treaty has to go. If there is any dispute and differences, it has to be resolved through mediation and arbitration, not through litigation, because your provision says that you must exhaust litigation within 2 years or 3 years, and then you go for an arbitration. And we know, sir, that it cannot be resolved in 2 to 3 years. Ultimately, a person has to go for a mediation. So therefore, there is a delay in resolving their dispute, because they have to go for a litigation first and then to arbitration. So I think all bilateral investment treaty must have a mandatory provisions for arbitration and mediation, not litigation. Sir, the another is inclusion of arbitration clause in all dispute mandatorily amongst the BRIC countries. Sir, our turnover today is larger than BRIC countries. Turnover today is larger than G7 countries. Our turnover of BRIC countries is $77 trillion as against $55 trillion of G7 countries. We have 10 members, 10 partners. I don't know if you all agree, if the BRIC countries all agree, there can be an understanding that all dispute and difference between them could be resolved through arbitration, mediation, and conciliation. So this should be a next agenda in the BRIC conference, which we are all having, because sir, there is a separate session for arbitration in BRIC countries. The people from all the BRIC countries, they come and participate in the BRIC conference, and I think this should be a part of the agenda, that the dispute and differences between the BRIC countries should be resolved through arbitration. Another thing which we have done, sir, we are in an era of free trade agreement. I mean, we are signing free trade agreement day after day. It's a new India. People are coming to India and signing free trade agreement. We had a free trade agreement with EU. We had a free trade agreement with UK. We had a free trade agreement with Australia. We are going to have a free trade agreement with New Zealand very soon. We have a trade agreement with 10 Asian countries. I mean, what not? I mean, we are going and having free trade agreement. When we are having a free trade agreement, why not have a provision there, sir, that if there is a dispute, then it has to be resolved through the mechanism of arbitration and mediation? Because the Prime Minister says that I want to make India as a global hub of arbitration. It is your desire also, sir, to make India as a global hub of arbitration. So therefore, why not in free trade agreement a provision for mediation and arbitration? Why not a dispute among the BRIC countries, provisions for mediation and arbitration instead of litigation? Sir, the other point I was trying to say, that mandatorily no part-time arbitration. There has to be no part-time arbitration. It has to be for a minimum period of 6 hours in a day. There should be a provision in law to incorporate that the law, either you are practice in court or you practice before the arbitrator. You can't do dual things. That on the same day you will go to the court till 4:30 and then you will do an arbitration for 2 hours or 1 hour, have a cup of tea. No more, sir. We have to be very serious as far as the arbitration is concerned. So I think the minimum period to do an arbitration should say that it is like the court proceedings. It should be continuous arbitration for 3 hours. The other point which I want to say, sir, the encouraged third-party funding, which we are lacking, but I think third-party funding is very essential. The shifting of appointment of arbitrators. Again, sir, I'm speaking for all the lawyers community here, from our friends from the different parts of the world, the appoint provisions and the power to appoint arbitrators should shift from court to institution. Sir, you know what is happening in Section 11A. Arbitrators are not being appointed for 6 months. I am coming from Calcutta, sir. There the arbitrators are not being appointed for a year, more than 1 year. If this is the state of affair, that the powers of arbitration, the power of appointment should shift. The power of appointment should shift from court to institution. So, sir, as I was saying, total prohibition on parties to appoint their arbitrators. Total prohibition. This will only reduce the cost of arbitration, and also, sir, you will see that how the arbitration will proceed fast. Sir, you know that there can be no growth of commerce and industry, and the industry will collapse if we are not able to resolve our commercial disputes in a timely manner. Sir, for me, to arbitrate is a divine function. Personally, for me, to arbitrate is a divine function. And let us all decide to go for preferred institutional dispute resolution mechanism. Thank you very much. Thanks a lot.
Thank you, Khaitan sir, for your insightful remarks and for giving us an inspiring start to today's deliberations. At this juncture, I would like to invite Ms. Sapna Jangiani, King's Counsel in England and Wales, Chair for the Combar India and Asia Committee and Judge at the DIFC Court UAE, to kindly share her valuable insights and perspectives with us.
Shri Arjun Ram Meghwal, Honourable Minister for Law and Justice, Government of India, Dr. N.G. Khaitan, President ICA and Senior Partner Khaitan & Co., Mr. Arun Chawla, Director General ICA and former Director General FICCI, Ms. Geeta Luthra, Vice President ICA and Senior Advocate Supreme Court of India, distinguished guests, colleagues and friends. What an honour to be able to address you in closing after the embarrassment of riches we have been treated to in this two-day conference. As mentioned by Justice Nagaratna in our first session of today, the exchanges we have engaged in during this conference will generate ideas. They will propel us forward as a dispute resolution community. Each of us individually, and also India herself, as she continues her irrepressible journey as the world's fastest growing major economy, the rising tiger of Asia. We heard from the Chief Justice yesterday about arbitration being an express highway. It seems to me that India herself is on an express highway towards becoming the third largest economy in the world by 2028, and potentially the largest economy in the world by 2050. Over the last couple of days, we have focused on India's concerted efforts through an engaged executive, legislature, and judiciary to provide a predictable and stable rules-based environment for commerce and investment to thrive here. Now, the courts that I am most familiar with are those in England and Wales, Singapore, and my own court, the Dubai International Financial Centre courts. All of these courts, like India, observe the common law, a legal system which since its inception and throughout its history has supported the ever-changing needs of global commerce. We heard from the Lady Chief Justice of England and Wales as she spoke about the strong bonds and binds between England and Wales and India. She also mentioned the increasing complexity of commercial disputes and how we need to adapt our rules-based order to focus not just on providing predictability to commercial parties, but also flexibility. I would like to add to that, if I may. As I mentioned in our first session this morning, we need to offer dexterity to commercial parties between dispute resolution options. And by that, I mean arbitration and mediation and everything in between, encompassing adjudication and binding and non-binding neutral evaluation. Users are telling us that this is what they want, and it is incumbent on all of us as dispute resolution practitioners to respond to that clarion call from our community's dispute architects, as they were very nicely called in our previous panel. We also all have a part to play in supporting India's trajectory towards becoming the leading economic powerhouse in the world. As she rises, she will lift not only her citizens, but her trading partners, her collaborators, and her overseas friends, like some of us visiting here today for this conference. Ms. Geeta Luthra reminded us in her vote of thanks yesterday of Martin Luther King's famous quotation about the bending arc towards justice. President Barack Obama frequently cited this quotation from Martin Luther King, and in closing, I'd like to share with you his unique take on it. As Ms. Luthra so aptly shared with us yesterday, Dr. King said that the arc of the moral universe is long, but it bends towards justice. To this, President Obama added his own crucial caveat. The arc doesn't bend on its own. It bends because we pull it in the direction of justice. I take this opportunity to congratulate ICA and my friend Mr. Chawla on a highly successful 5th edition of the ICA conference, bringing us all together so that we can each play our part in ongoing progress towards justice. Thank you very much.
Thank you, ma'am, for sharing your perspectives and for those valuable insights drawn from your rich, multi-jurisdictional experience across both the bar and the bench. It is with great honor and privilege that I now invite our chief guest, Sri Arjun Ram Meghwal, Honorable Minister for Law and Justice, Government of India, to deliver his valedictory address. Sir.
इंडियन काउंसिल ऑफ आर्बिट्रेशन द्वारा आयोजित ये कॉन्फ्रेंस, जिसका नाम आर्बिट्रेशन इन द एरा ऑफ ग्लोबलाइजेशन दिया गया है, इस अवसर पर उपस्थित हमारे एनजी खेतान साहब, प्रेसिडेंट ऑफ आईसीए, श्री अरुण चावला जी, डायरेक्टर जनरल ऑफ आईसीए, गीता लूथरा जी, वाइस प्रेसिडेंट ऑफ आईसीए, और सपना जांग्यानी जी, सभी उपस्थित आर्बिट्रेशन से जुड़े हुए सभी एडवोकेट्स, विशेष मेहमानगण और पत्रकार साथीगण। देखिए, अभी खेतान साहब जब बोल रहे थे तो मुझे बहुत से टॉपिक दे दिए, तब मैं सोचूं क्या बोलूं क्या नहीं बोलूं। इतने टॉपिक दिए हैं कि मैं शुरू कहाँ से करूं यही समझ में नहीं आ रहा है, लेकिन कुछ तो करूंगा। खेतान साहब, आपने एडीआर का एक तो नया नामकरण किया है। नामकरण तो हमेशा कोई विद्वान आदमी ही करते हैं, इसलिए पिंकी आनंद जी आप सहमत हैं ना? विद्वान तो हैं ही है खेतान साहब, और आप जज हैं, इसलिए आप अगर कह देंगे तो हम मान लेंगे सब। आप बताइए, विद्वान तो है ही ना? तो ताली बजा दीजिए खेतान साहब के लिए। हम लंबे समय से एडीआर की बात ही करते आ रहे हैं, अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म, यही कंसेप्ट हमारे यहाँ चल पड़ा, किताबों में भी यही है। इन्होंने सूर्यकांत जी का उदाहरण दिया कि उन्होंने आगे पी जोड़ा, प्रिफर्ड एडीआर, और ये कह रहे हैं मैं पी के साथ आई जोड़ता हूँ, प्रिफर्ड इंस्टीट्यूशनल एडीआर। तो है तो विद्वान ही सब। तो ऐसे विद्वानों के बीच में मुझे बोलना पड़ रहा है, तो कुछ कम ही बोलूँगा, लेकिन कुछ गलती हो जाए तो आप थोड़ा माफ़ कर देना। देखिए, एआई और वर्चुअल हियरिंग का भी जिक्र किया खेतान साहब ने, और इसका जिक्र करते करते जैन जी तक भी आ गए, और अमेंडमेंट इन आर्बिट्रेशन एक्ट को भी ले आए, जिसको पिंकी आनंद जी रोज ही कहते हैं हमें। अभी हम बात कर रहे थे तब भी ये कह रहे थे, प्रोसेस में है पिंकी जी, ये सब्जेक्ट हमारे प्रोसेस में है, जल्दी इसका कोई रिजल्ट निकलेगा। और ये इस बात में भी बड़ा दम है कि एडहॉक आर्बिट्रेशन की जगह इंस्टीट्यूशन आर्बिट्रेशन होना चाहिए, इससे हम सहमत हैं। और जब हम सहमत हैं तो आप मानिए कि गवर्नमेंट इस दिशा में निश्चित रूप से काम करेगी कि एडहॉक आर्बिट्रेशन की जगह इंस्टीट्यूशन आर्बिट्रेशन होना चाहिए। अब एक विषय कॉमर्शियल कोर्ट के 12A का भी आया और अपॉइंटमेंट ऑफ द आर्बिट्रेटर का भी आया। इसके लिए कमेटी बनी हुई है, उसमें हम काम कर रहे हैं। और एक जनविश्वास बिल का भी आप लेके आ गए। ये बहुत शानदार जनविश्वास बिल अभी अभी पास हुआ है। जो सेशन अभी हमारा चल रहा है पार्लियामेंट का, उसको हम बजट सेशन कहते हैं। ये बजट सेशन का एक्सटेंशन ही हुआ है 16, 17, 18 अप्रैल को। और महत्वपूर्ण काम होने वाला आपको पता ही है ना? पता है किसके लिए? पिंकी जी के लिए? सबके लिए है। मातृशक्ति के लिए नारी शक्ति वंदन अधिनियम जो 2023 में पास हुआ, इसको लागू कैसे करेंगे, इसके लिए बजट सेशन है, एक्सटेंशन किया है। लेकिन इसी बजट सेशन में एक जनविश्वास बिल पास किया। पहले बिल आया, फिर इसके लिए कमेटी बनी जेपीसी ने सारे प्रोविज़न इसमें देखे। आप सही जिक्र कर रहे थे, 784 प्रोविज़न में से हम कुछ चीज़ें ठीक कर पाए और उसके कारण 1000 ऑफेंसेस डीक्रिमिनलाइज हुए। ये छोटी बात नहीं है। एक इसमें बड़ा विषय केतान साहब जो हमने किया, वो आपके ध्यान में ला रहा हूँ। कई ऐसे प्रोविज़न थे जिसमें ट्रेडर को या एंटरप्रेन्योर को या जो हमारे काम करने वाले लोग हैं, उनको फाइन भी लगता था और कभी कभी फाइन के साथ पेनल्टी भी लगती थी और कभी फाइन अलग से भी लगता था। तो हमारे पास सुझाव आया कि साहब फाइन तो है 100 रुपये का, लेकिन उस फाइन भरने के लिए जो प्रक्रिया करनी पड़ती है वो 10,000 की है। अब समझ में आ रही है आपकी बात क्या? नहीं आ रही है? एडवोकेट करना, उस कोर्ट जाना उस कोर्ट जाना। भैया अचानक तुरंत ही भरा लीजिए। तो उन्होंने कहा फाइन हम तुरंत नहीं भरा सकते, फाइन का प्रोसीजर है, वो तय होगा उसके बाद ही भराएंगे। पेनल्टी तुरंत भरा सकते हैं। तो ये कुछ छोटी छोटी ऐसी चीजें थी जो ध्यान में भी नहीं थी। व्यक्ति तकलीफ पाता था, परेशान होता था, लेकिन ये भी किसी के ध्यान में आई, केतान साहब, तो नरेंद्र मोदी के ही ध्यान में आई और जिससे ये ठीक हुआ काम। 1000 चीजें ठीक की है ऐसी। ये छोटी छोटी चीजें हैं, लेकिन ये अभी एक इंडियन सक्सेशन एक्ट था, इसी पिछले बजट में हमने कम से कम आपको 1633 एक्ट या तो हमने रिपील किए हैं या हमने अमेंड किए हैं। लेकिन एक इंडियन सक्सेशन एक्ट था 1925 का, अंग्रेजों के जमाने का, और वो 3 ऐसे हाई कोर्ट के टेरिटरी के एरिया थे जहां पे लागू था। बॉम्बे हाई कोर्ट का जुरिस्डिक्शन, कलकत्ता हाई कोर्ट का जुरिस्डिक्शन और मद्रास हाई कोर्ट का जुरिस्डिक्शन। और क्या था कि एक वर्ग विशेष को छोड़ दो, बाकी कोई हिंदू, कोई जैन, कोई बौद्ध, कोई मुस्लिम, कोई पारसी, ये कोई अगर विल करेंगे तो उसको प्रोवाइड कराना पड़ेगा। कब था ये प्रावधान? 1925 में। लेकिन एक कम्युनिटी के लिए नहीं था। लेकिन ये एक विभेदकारी प्रोविजन था, एक्टिव विभेदकारी था। इक्वलिटी का भाव ही नहीं था इसमें। जो हमारा कॉन्स्टिट्यूशन कहता है आर्टिकल 14 इक्वलिटी, वो हमारा पिलर है। इक्वलिटी, लिबर्टी, फ्रेटर्निटी, और साथ में जस्टिस। और जस्टिस भी 3 तरह का, सोशल, इकोनॉमिक एंड पॉलिटिकल। लेकिन वो पड़ा था। ये भी खेतान साहब चेंज हुआ तो इसी नरेंद्र मोदी जी के कालखंड में चेंज हुआ। कब प्रोबेट कराने की कोई आवश्यकता नहीं। तो ये सब ईज ऑफ डूइंग बिजनेस से ही संबंधित विषय है। आपने न्यू लेबर कोड की भी बात की, आईबीसी को हमने चेंज किया, उसकी भी बात की। लेकिन आप क्रिमिनल जस्टिस सिस्टम को हमने चेंज किया, उसको भूल गए। वो इतना बड़ा चेंज है, उसका जिक्र आपको करना चाहिए। सीमा नहीं, सीमा आपने सीमा तोड़ी नहीं, लेकिन चीजें छोड़ी भी नहीं। लेकिन आप सीपीसी में अमेंडमेंट की बात कर रहे हो, लेकिन जो हमने क्रिमिनल जस्टिस सिस्टम में अमेंडमेंट किया वो भी तो आपके लिए जरूरी था या नहीं था? तो उसके लिए भी ताली बजा दीजिए आप जोरदार। अब आपने एक विषय और हमारे लिए दिया है, वो ब्रिक्स कॉन्फ्रेंस का। आप चीजें तो अंदर से खोज के लाते हो शायद। ये हमारे ब्रिक्स कॉन्फ्रेंस इस बार जो अहमदाबाद में हो रही है सर, ब्रिक्स कॉन्फ्रेंस, और इसमें 10 कंट्री हैं, आपको जानकारी है ही, और 10 कंट्रीज के जस्टिस मिनिस्टर आ रहे हैं। जो फॉरेन सेक्रेटरी आ रहे हैं वो 19-20 मई को हैं। सुझाव दिए हैं, उनका जोरदार चिंतन मनन और मंथन गिफ्ट सिटी में ही करेंगे, अगर आपने ऑफिस वहां खोल दिया तो। ये भी आपने अच्छा सुझाव आपने दिया। मैंडेटरी प्रोविजन के बारे में आपने जिक्र किया, पार्ट टाइम आर्बिट्रेशन, ये सब मैं भी नोट सब किए मैंने, और मेरा साथ में जो स्टाफ आया उसने भी सब चीज़ें नोट की है। शिफ्टिंग ऑफ आर्बिट्रेशन का भी जिक्र किया, लेकिन ये करते करते आप डिविनिटी की ओर भी बढ़ गए। और आर्बिट्रेशन का काम है भी ऐसा ही। जो हमारे पुराने भारतीय पंच परंपरा में जो पंच होता था और जो निर्णय करता था, वो देवता के समान ही होता था, इतनी इज्जत मिलती थी। तो डिविनिटी की तरफ आप ले गए उसको, वो हमारा कंसेप्ट है हमारा, क्यों न्यूट्रल होता था। पंच परमेश्वर, 5 आदमियों ने निर्णय किया, सबने मान लिया, इसका मतलब वो न्यूट्रल निर्णय करते थे, निष्पक्ष होते थे, और उनका डिसीजन भी बाइंडिंग होता था, क्योंकि उन्होंने पंचों ने निर्णय किया है। ये जो पंच हैं, ये कोई ऐसी डिविनिटी की ताकत लेकर के हमारे बीच में आए थे। इनका कोई फीस नहीं लेना, समय देना और निष्पक्ष निर्णय करना, ये पंच परमेश्वर का काम था, जिसका जिक्र आपने खेतान साहब आपने किया। बहुत अच्छी बातें आपने की, मैं बहुत धन्यवाद देता हूं आपका। लेकिन मैं सपना जी का भी धन्यवाद देना चाहता हूं कि इन्होंने 3rd लार्जेस्ट इकोनॉमी की बात की बाई 2028। हम सभी इसमें चल रहे हैं, हम सब।
Thank you, sir, for your insightful and inspiring address. Your remarks have offered a thoughtful perspective that beautifully encapsulates the key themes of this conference and will continue to guide our reflections going forward. As we bring the valedictory session and the larger overarching conference to a close, I now call upon Ms. Geeta Luthra, Vice President ICA and Senior Advocate, Supreme Court of India, to the dais for the word of thanks.
Good evening, everyone. So the question that I think we can ask is arbitration reflective of a legal system's maturity? Is mediation reflective of a legal system's maturity? And as the Honorable Law Minister just said, Panch Parmeshwar. So Panch Parmeshwar is really going back to mediation. So we are doing the full cycle, coming back from a very established, based on the English legal system, a disputes resolution system which was adversarial, to an arbitration system where in the first session we talked about med, and now we come to arbitration and then to mediation. So at the outset, after asking this question, I want to start by thanking our chief guest of today's valedictory session, Shri Arjun Ram Meghwal, the most talented, multifaceted personality and law minister we have. Thank you, everyone. Please thank him. I also thank Mr. N.G. Khetan, who has Dr. N.G. Khetan, who has been spearheading the Indian Council of Arbitration since many years. A special thanks to Mr. Arun Chawla, Director General ICA. I have already yesterday spelled out many accolades for him. So today we'll spare him that. I also wish to thank Sapna, who was there on the opening session today morning and is there with us in the valedictory and has so beautifully given insights to various sessions today. My sincere thanks go to all the speakers for the 4 sessions as well as the fireside chat. I was first and foremost wanting to thank the various members of the governing body, various members of Indian Council of Arbitration, the team behind all this, to say a special thank you to all of you to put this together so seamlessly and so well. So we've had various discussions on what should we call this dispute resolution. Today, the person from Drew and Napier, Mr. Yim, said we have to call it appropriate dispute resolution. So first we have to find the right name for it. Now it's no longer alternate, it is the main dispute resolution. Now we are talking of it as the appropriate dispute resolution. So the first session was a session on arbitration and mediation, where the chairperson was Justice Nagaratna. And before I say that, Pinky tells me, don't call me Miss Pinky Anand, I have to say Dr. Pinky Anand. So with various insights from Sapna, Mr. Leong, and Mr. Sahil Narang. That was wonderful. And the discussion was, do we have med? Do we have only mediation and arbitration? Do we have conciliation, mediation, and arbitration? So, of course, everyone had their own inputs. My own take on this would be that you cannot have the same person wearing the hat of a mediator and an arbitrator. Because first I confide in that person, and then I have a dispute before that person where I take away a lot of what I may have put on the table when I am before that person in mediation. That, of course, but it had been put on mediation, and therefore we are looking at trained mediators. This was something one of the speakers, trained mediators. This was something one of the speakers today spoke about, that we need accredited arbitrators, we need accredited mediators. There's been a lot of development of law it's been galloping in India on all fields, including on the aspect of pre-litigation mediation, particularly in commercial contracts, and the Supreme Court's various judgments, including Patil automation, have paved that way and have stressed that 12A is important, except where you need urgent interim relief. Coming now to the second session, because all the sessions were extremely interesting, extremely wonderful. I just spoke about, that was headed by Justice Amanullah, and we had a very lively interaction between Mr. Ratan Singh and Justice Amanullah, whether judges should give way when a lawyer says, I have arbitration for next 5 days, please accommodate me. And the discussion was, in fact, enjoyable, lively, and Jimmy spoke about the 10 commandments which they follow in Singapore to make arbitration very robust. The third session was equally enjoyable, and Justice Prashant Kumar Mishra was the chairperson. Ganesh Chandru, who is present with us just now, as are various other persons who were speaking at that session, spoke about our tryst with destiny and about what was said and the famous quotation from that time. The one issue that came up was that in this, and this was the third session, where there is artificial intelligence, we have to guard with regard to the fragility of confidentiality. And yesterday, Justice Suryakant, while talking of AI, warned us that we have to be sure that we do not give up the independence of the judge or the arbitrator while we give in to digital sessions. The last session, which was chairperson by Justice Arvind Kumar, whom I also want to thank, and beautifully moderated by Mr. Amit Sibal, was extremely interesting insofar as India has said, yes, we will grant anti-arbitration injunctions, but we will be very slow and it will be very rare. And this was said in World Sport Group as well as various other judgments of the Supreme Court. The last session, which was the fireside chat, where Manjari led the whole session, there was a discussion by various general counsels, and they are the persons that we turn to when we go for arbitration. I can thank one and all for this extremely, extremely engaging 2-day session and the closure of the 5th edition. Alas, it closes too soon, and it was very, very interesting, very engaging. But thank you one and all for all those who have been attendees and all those who have participated and been the speakers. Thank you, everyone.
Ladies and gentlemen, thank you for being with us over the past 2 days and for making this conference such a vibrant and engaging forum. While the session concludes here, deliberations continue beyond. We now warmly invite you all for the dinner that follows. Thank you.